I kindly invite speakers and the chair of the first session to take the stage. Please. Ich versuche mich. Ladies and gentlemen, good morning and welcome. A warm welcome also on behalf of the rector, Laura Ramacciotti, who was unfortunately not able to make it today. For the first time, the University of Ferrara hosts a conference with 38 distinguished experts from America, Asia, and Europe, and among them, eminent representatives of the academic world, intergovernmental organizations, supranational courts, national governments, and big tech companies. We would like to thank each of our distinguished speakers and chairs for making the way to Ferrara from America, Asia, and Europe, despite many commitments in a time we know very well in which the increasing duties because of the mix of virtual and physical meetings makes even more challenging our task to be accomplished. And for their tough work for delivering their draft papers and materials before the conference. We would like to thank also the other participants in the room, each of them, for being here and for their contribution to the discussion for strengthening our values and ideas. So this conference could not take place in more challenging times. Digital disruption, climate challenges, abrupt change of circumstances due to international conflicts. This makes all the more important to strengthen our synergies. Our conference represents also the first step of the so-called research project of national interest on digital vulnerability in European private law, funded by the Italian Ministry of University and Research. The research project involves 5 Italian universities: Trieste, Ferrara, Politecnico delle Marche, Molise, and Roma Tor Vergata, and is funded for the period 2022-2025. If we are here today, it is because of an idea of the members of the scientific committee of this project, in particular my fellows Claudia Amodio, Camilla Crea, Amalia Diurni, Marta Infantino, Luca Ettore Periello, and Loredana Tullio. So one thank to all of them. So this research project, some words more, as today it's the kickoff of our work, 3 years work, aims to unlock the legal potential of the notion of digital vulnerability in Europe, but in a broader perspective, from a global perspective, by investigating how national and European principles, rules, and policies on digitalization can be aligned, reimagined, and reshaped for the protection of vulnerable persons in the digital environment. And not only physical persons, but also businesses, which are impacted by a new form of vulnerability, facing the multi-level dimension of digital vulnerability. We think now, for instance, the new concept of a very strong contracting partner, very strong online platforms. We design a new step in the weakness test of the contracting parties. So we know that in recent years, vulnerability has emerged in legal discourse, in dialogue with other disciplines, as a concept to capture the rather fluid and multi-layered nature of the human condition, and to question the adequacy of some foundational legal and policy norms. Yet, despite the potential notion of vulnerability as a key tool to overcome the limits of legal formalism and paternalism and to foster substantive equality, the legal status and effects of the notion are still quite unclear. For this reason, we are here today and tomorrow, and in the future, hopefully, we will continue our cooperation. In particular, the notion of people's vulnerability has only seldom been applied to the specific forms of exposure to harm that might arise from interaction with digital technologies. In our current and pervasively digitalized world, we believe it is increasingly important to analyze how digital technologies impact pre-existing forms of vulnerability or create new ones, and to understand how the law can prevent or address unequal experiences of technology. So what we are going to plan with this project, with your help? So we aim to investigate the notion of digital vulnerability by exploring how this stands vis-à-vis traditional paradigms of protection of weaker parties, such as rule on incapacity, consumer protection, but also business protection, data protection, anti-discrimination, equality before the law, and to what extent it might properly capture risks and harms stemming from digital technologies. We also aim to test to what extent current existing national and European rules adequately deal with personal conditions in which digital technology might prove particularly disruptive and challenging for the persons involved, and to assess how national and European legal principles, rules, and policies could be aligned, reimagined, and shaped in order to properly translate the notion of digital vulnerability into justiciable issues. But we aim, as I mentioned, to do this in a global perspective. That's the reason why we are glad and honored to have had the opportunity to involve leading experts from other jurisdictions, from other continents, who may show us useful solutions in order to tackle existing problems we as Europeans are facing. This is also today the second Ferrara Colloquium on the law of the digital economy in the framework of the Center for European Private Law at this very university. And the first colloquium took place just 12 months ago, co-organized by Rainer Schulze and myself, on the topic harmonizing digital contract law, the impact of the twin directives on the supply of digital services and on the sale of goods, and the regulation of online platforms. So we're glad to announce that yesterday went into print the volume, more than 800 pages and 41 authors, containing the proceedings of that conference. So, in some sense, we are closing a circle and opening a new one. So data, and a warm thank to all the authors which outstandingly contributed to that volume. So data have an increasing economic value, and consumer of digital content and digital services is now used to pay with data instead of in addition to money. Some say that data is the new oil of the digital economy. Actually, they are the new sun, as they are like a renewable energy, suitable to increase their value when processed, analyzed, and recombined. And just yesterday, very hot days for this development, 14 June, the European Parliament approved the Artificial Intelligence Act, an instrument that aims to protect consumers from potentially dangerous applications of artificial intelligence. And this move was made amid concerns that recent advances in the technology could be used to nefarious ends, ushering in surveillance, algorithmically driven discrimination, and prolific misinformation that could upend democracy, impair democracy. So the new instrument takes a risk-based approach introducing restrictions based on how dangerous lawmakers predict an AI application could be. It would ban tools that European lawmakers deem unacceptable, such as systems allowing law enforcement to predict criminal behavior using analytics. Then it would also introduce new limits on technologies simply deemed high risk, such as tools that could sway voters to influence elections, or recommendation algorithms which suggest what posts, photos, and videos people see or social networks. So I would say forthcoming, because the way is not to the end, yesterday by the European Parliament approved AI Act takes aim at the recent boom in generative AI, creating new obligations for applications such as ChatGPT that make texts or images, often with human-like flair. And companies would have to label AI-generated content to prevent AI from being abused to spread falsehood. The yesterday approved AI Act requires firms to publish summaries of what copyrighted data is used to train their tools, addressing concerns from publishers that corporations are profiting off materials scraped from their websites. So the threat posed, implied by the legislation to such companies is so grave and so meaningful that OpenAI, the maker of ChatGPT, say that it may be forced to pull out of Europe depending on what it includes in the final text. So the European Parliament's approval is a critical step in the legislative process, but the Act still awaits negotiations involving the European Council, whose membership largely consists of governments of EU countries. So some say that data is the new oil of the digital economy, as I mentioned. And talking about data as the new sun, as a renewable energy, our mind goes back to Copernicus, who graduated in Ferrara at the beginning of the 16th century, precisely in 1503, as you can read in the Dome Square. So to say today we need a new Copernican revolution. So facing the multifaceted disruption of the traditional equilibria, which require a new balance between different values, rights, and duties, we wish you all 2 fruitful days of discussions. Thank you very much. And now I'm glad to give the floor and the word to Professor Ki-Soo Lee, President of the Korea Society of Law. Please.
Honorable Professor Alfred D. Franceschi, ladies and gentlemen, it's a great pleasure for me to give a welcome address at the inaugural conference of the project Digital Vulnerability in European Private Law, DIVE. First of all, I would like to express my sincere gratitude to the Italian Ministry of University and Research for funding this project, and to the Scientific Committee and the Advisory Board for organizing this conference. I am also grateful to the University of Ferrara for hosting this wonderful event. Korea University, where I served as the 17th president, is well known for the beautiful campus. In fact, This is my second visit to the University of Ferrara, and I believe we have at least one thing in common. In our urgent and pervasively digitalized world, we believe it is increasingly important to analyze how digital technology affects existing forms of vulnerability or create new ones. And to understand how the law can prevent or address unequal experiences with technology. As we are gathered here today with the world-leading academics, scholars, and legal practitioners, it will be a great opportunity to share our insight, thought, knowledge, and experiences. It will then lead us to achieve our goal on the conference, to explore the very limits of the notion of digital vulnerability. As we all know, the DIVE project organized 3 international conferences. We are here today at the University of Ferrara for the first conference, and the upcoming conferences will take place in Rome in March 2024 and in Trieste in March 2025. Proverbs say that the beginning is half of every work. In this context, developing meaningful outcomes from the conference will be the halfway to the success of the DIVE project. As the president of the Korean Society of Law, I would like to briefly introduce KSL. Korea was under Japanese colonial rule from 1910 to 1945 and became independent in 1945 after World War II. The Republic of Korea was formally established in August 15, 1945, after the transfer of power from the United States Army military government, which had ruled South Korea since the end of Japanese rule in 1945. We went through the Korean War from 1950 to 1953 under the founding president Seungman Lee. The Korean Society of Law was established in July 1956. The American Bar Association supported the establishment of the KSL with the aim of promoting legal culture in Korea and improving the judicial administration. Today, the KSL plays an important role in the judicial system of Korea with its 35,000, consisting of judges, prosecutors, lawyers, law professors, and etc. The KSL will celebrate its 70th anniversary in 2027 and plans to host the World Jurist Conference in Seoul 2027. The theme of the conference will be survival strategies of each legal areas for the development of legal technology. I hope that the DIVE report, which will be published in 2025, and the 2 years of changes will be discussed at the World Jewish Conference in Seoul 2027 to improve the legal culture of the world. Finally, I would like to thank the chairs and the speakers of each session for their hard works. And I wish you all good health and happiness. Thank you.
Thank you very much for these excellent introductions by my friend and colleague Alberto De Franceschi, who gave a wonderful overview about the project and about the topic, and by my estimated colleague, Professor Ki-Soo Lee, who has informed us wonderful about the important and advanced work on the digital topics in Korea, and furthermore has shown that this topic we are dealing with is really a global topic. The discussion we should have is not only an Italian, German, European discussion, it's a discussion uniting Europe and East Asia, a global discussion. Thank you for your contribution at the beginning of this conference. Thanks from my side also to the Italian network dealing with the project. Alberto has explained. I'm very happy that this project gives us a chance, a possibility to come together and to exchange ideas on this topic of common interest. Thank you to all of you that you are here and that we in our first section now can present some ideas and in the last time of the section can discuss it with all the participants here in the hall, and hopefully, if not today, then later on by email with the participants outside the online participants. Okay, this first section addresses private law facing digital vulnerability, the global challenges. Private law facing digital vulnerability. This is a very broad topic, as Alberto has explained. However, on the European level, on the European private law, we have to expect some answers by the European Union. Unfortunately, the first Advocate General at the Court of Justice at the European Union, Maciej Spuna, was not able to come for some personal reasons. It's a pity for the topic he could present, and also for me personally, because I know him since a long time and I hope to see him again. Nevertheless, European Union will be present here, and surely the first paper will be given by a representative of the European Union. The European Union always combined its main project, the single market, with measures and policies to protect weaker parties, to balance some results of the market developments as a labor law, anti-discrimination law, consumer law, etc. In the digital age, now the single market developed towards a digital single market since the Commission's strategy paper of 2014-2015. The question now arises whether and how the protection of weaker parties will be adopted to the digital age, including the protection of digital vulnerability. And so this is a topic we are dealing with, and this is a topic we hope some answers from the European Union today or in the future. I will give the floor to Egeline Braun, official of the European Commission. She worked at the EU Consumer Protection in the DG Justice since 2016. She is leading the work on the fitness check of EU consumer law on digital fairness and on Fair Commercial Practices Directive. But she is not only an European official. She is a real European by her formation and her biography. She is an Estonian national. She got law degrees, not only in her home country, but at Maastricht University in the Netherlands and at the European University Institute in Italy, Firenze. And, well, now she is working in Brussels. So she is a European official and a European citizen.
Thank you so much for the kind introduction, and hello to everyone. It's an honor to be here at the start of this project, and indeed to be representing one of the European institutions. And today I will try to give you an overview about some of the key questions that the European Commission currently is reflecting on in the area of digital vulnerability. And I will primarily be speaking from the perspective of EU consumer law. Why? Because that's the field in which I am working, but also because currently this is precisely the area of law in which there are active reflections ongoing in the Commission about how to address some of the challenges brought about by digital technologies, and specifically the concept of digital vulnerability. So vulnerability in general and consumer vulnerability has been a key recurring concern for the European Commission. And it was already identified as a legal challenge when the concept of vulnerable consumer was codified in the Unfair Commercial Practices Directive back in 2005. And this importance on the evolving concept of vulnerability has been recognized in different Commission policy documents, including in the current so-called New Consumer Agenda, which outlines our policy priorities until 2025. And as a result of this continued focus on the vulnerable consumer, we see a wide array of consumer and cross-sectoral legislation, for instance, in the area of food, energy, financial services legislation, which has some provisions that are aimed at protecting vulnerable consumers. And these provisions sometimes, quite rarely, explicitly acknowledge also the role of digitalization in the formation of vulnerabilities. For example, in the European Accessibility Act, it has one of its objectives in making sure that digital solutions are accessible to persons with disabilities. But most of the time, these provisions that you will find in European laws are rather limited in substance. They're also often enshrined in recitals as opposed to articles, or they are limited to specific groups of vulnerable consumers, so not really referring to the concept of vulnerability in general, as is the case with the Unfair Commercial Practices Directive, which, for example, refers to vulnerabilities such as mental or physical infirmity, age, or credulity. And we do see this trend of singling out specific groups of vulnerabilities also in some of the new digital legislation that is being negotiated, like the Artificial Intelligence Act that was mentioned earlier, which also similarly only singles out certain types of vulnerable groups when referring to certain prohibitions of AI use cases. So I think we can conclude that until now, there isn't really yet a proper reflection about digital vulnerability in EU law that would go much beyond protecting the classic vulnerable groups. And yet, as highlighted by various academic studies, as well as the Commission's own 2016 study on vulnerability, large segments of the EU population do consider themselves to be vulnerable. And the last time we asked this question in one of the EU surveys, back in 2019, 43% of EU citizens qualified themselves as vulnerable because of one or more reasons. So this increase in vulnerability can be due to a plethora of reasons. These days, make your pick: war, pandemic, inflation. But undoubtedly, digitalization also has an increasing role in exacerbating these vulnerabilities, especially given the increase in the sheer complexity of the digital technologies and business models that are continually being rolled out. And therefore, what is the main concern for the Commission right now, as expressed in the new consumer agenda, is that consumers are at risk of being targeted by unfair practices that exploit their cognitive biases or in other ways make use of knowledge or information about their vulnerabilities in order to distort their decisions. And this was also confirmed recently in a public consultation that we ran about the state of play of digital consumer protection, where 74% of consumers felt that within the last year, their personal data had been misused or used unfairly when personalized commercial offers or personalized content was being shown to them. This is also being corroborated by a behavioral study that the Commission conducted last year about the prevalence of dark patterns, so these manipulative interface designs, where we found, unfortunately, that among the most popular websites and apps used by EU consumers, a whopping 97%, so virtually all of them, contained at least one dark pattern, or a type of practice that we could also call an unfair commercial practice. So this is rather alarming and also raising the attention of consumer protection authorities in Europe. And earlier this year, we saw the CPC network, which is the Consumer Protection Cooperation Network that brings together the different consumer enforcement authorities from the member states, conducting a sweep of marketplaces and specifically e-commerce and online retail shops. And they found that, again, nearly 40% of them also contain some of these manipulative dark patterns. So all of these factual findings are a source of concern for the Commission, but also for various stakeholders that we listen to in our policy reflections. And for instance, one of these stakeholders, the European Consumer Organization, BEUC, is going a step further in arguing that in this new digital environment, essentially the average consumer or the average person has now become vulnerable, that in a way we are all vulnerable potentially in the digital environment. And based on their 2021 study, they call this new situation that is emerging digital asymmetry. So referring to a more structural state of vulnerability characterized in particular by vast differences in power between the trader and the consumer. So this entire debate and these factual findings essentially were a large reason why last year the European Commission finally launched a so-called fitness check of EU consumer law on digital fairness. So we're not focusing on digital vulnerability, but we take a more positive spin. We are looking at how to ensure digital fairness. And this is a typical exercise that we have to conduct every few years. It's a formal evaluation of the current situation. It's a mandatory step before we can even consider any new laws in the future. And so concretely, we are examining whether the Unfair Commercial Practices Directive, the Unfair Contract Terms Directive, and the Consumer Rights Directive are still fit for purpose, taking into account as well all of this new digital legislation that we have seen in the last few years, like the Digital Services Act, Digital Markets Act, the forthcoming AI Act, AI Liability Act, Data Act, I could go on. So our objective now at the Commission is to assess as well the concept of digital vulnerability and to see whether the provisions in place in consumer law, but also more broadly, are sufficient to account for all types of vulnerabilities that are emerging in this new digital landscape. And to do so, we are first of all looking at the nature and magnitude of specific problematic practices that are often used as examples of digital vulnerabilities playing out. Now, I already mentioned one of those examples, dark patterns, a very hot topic in Brussels. But a lot of the practices we are looking at will also be covered in this conference, looking at the agenda, so you will hear much more in detail about some of the questions posed by the new technologies or the problems that have emerged. But the Commission's focus is, for example, aside from dark patterns, also on personalization in commercial business-to-consumer relationships, including in targeted advertising, but also we're looking at things like addictive functionalities in video games or the behavior of influencers on social media. So it may well be that what you could see as an outcome of this reflection are some concrete actions, whether it's enforcement actions, legal interpretation, or in fact new laws to tackle specifically these unfair practices without necessarily rethinking the underlying concept of vulnerability. However, the possibility of changing some of the core concepts in consumer law, such as the concept of an average consumer or vulnerable consumer, is now very much also on the table. So we're asking questions such as to what extent these two concepts are still adequate and broad enough. To start with, do they actually capture all of the relevant categories of vulnerable groups? For instance, those with a lower level of digital skills, or those prone to addiction, or those with financial hardships. And a question that I grapple with personally, should we really focus so much on the concept of vulnerability, or is it actually the average consumer benchmark or the baseline level of protection that may need adaptation to better reflect how consumers actually behave, not only offline, but also in the online world? On the other hand, we do have to acknowledge that the European Commission as an institution concluded not too long ago, so back in 2016, 2017, which was the time when we conducted the last fitness check of consumer law, which was much broader, looking at essentially the whole consumer acquis. But we concluded at the time that there was an absence of evidence of major problems in the application of these concepts of average consumer and vulnerable consumer. And in particular, at the time, enforcement authorities in practice did not see major obstacles to their enforcement activities purely because of these concepts. We did learn, however, that the concept of vulnerable consumer was not used very often in practice. It's more likely that you will see another concept of a targeted average consumer being used. So meaning you look at the practice from the perspective of an average consumer or an average member of a group that is targeted by a specific practice. In any case, we will pose these questions again, including to the authorities, and it remains to be seen whether the conclusions or the outcomes will be different from last time. I'll also now take this occasion to highlight some of the more legal positions that the Commission has taken vis-à-vis the concept of vulnerability, in particular in its guidance document on the Unfair Commercial Practices Directive that I had the pleasure of drafting together with colleagues 2 years ago. First of all, we clarified that in the Commission's opinion, the list of vulnerabilities in the Unfair Commercial Practices Directive is an indicative, non-exhaustive list, as confirmed by Recital 19. This means that you can already now cover multi-dimensional forms of vulnerability under this concept, including socio-demographic characteristics, behavioral characteristics, market environments, and so on. We also clarified that the concept of vulnerability, in our view, is dynamic and situational, meaning that a consumer can be vulnerable in one situation, but not in the other. So you can go in and out of vulnerability, especially in the digital environment. And we also specifically acknowledged that data-driven practices can exploit consumer vulnerabilities rather effectively, including concerning consumer interests, preferences, psychological profile, mood, and things like that. And we also made a statement that it is quite likely that the exploitation of these vulnerabilities in the digital context will have an effect on the consumer's transactional decision. Of course, depending on the circumstances of the case, the legal assessment may differ, but importantly, we also wanted to bring to the spotlight a very underused part of consumer law, namely Articles 8 and 9 of the Unfair Commercial Practices Directive, which establish the conditions for a so-called aggressive commercial practice. And we consider that in particular, these exploitations of digital vulnerabilities are likely to constitute a form of undue influence, which would be then an aggressive commercial practice. But of course, it's undeniable that despite all of these very ambitious interpretations that the Commission has put forward, the concept of a vulnerable consumer has many conditions attached to it, which makes it rather difficult to enforce. And ultimately, guidelines from the Commission are non-binding, so they are not the law. And these legal provisions that I've been referring to have basically not been amended since their adoption, which begs the question, are further legal changes necessary? And this is especially relevant given that the Unfair Commercial Practices Directive is a full harmonization instrument. So member states could not go further even if they wanted to. But I want to assure you that aside from these very specific consumer law questions I highlighted, the Commission is also asking some of the bigger questions about how to mitigate these structural digital vulnerabilities that are seemingly inherent to digital markets. And we have to ask also broadly whether the current legal framework, in particular with the Digital Markets Act and Digital Services Act, are really sufficient from the perspective of consumer protection. It may be too early to tell whether this is the case or not, because the enforcement of those acts has not yet fully started. But the boundaries of the legislation, the letter of the law, have at least become much more clear to all of us now. And in this context, we are reflecting seriously also about the possibility of reversing or shifting the burden of proof in situations where such digital vulnerability may be present. For example, if only the company would know or be in possession of evidence about the complexities of how the digital service works, or how the algorithm was used to target specific consumers and their vulnerabilities. So to conclude from my side, the fitness check of EU consumer law and digital fairness is set to conclude 1 year from now, so in the middle of 2024. It will present the Commission's opinion and view of what is the current state of play and whether the current rules are sufficient. If the Commission were to identify that there is scope still for further strengthening of the legal framework, then this would be a political decision that will be taken under the next Commission mandate with the next Commissioner in charge of the consumer portfolio. So technically speaking, the earliest you could expect something is 2025. Therefore, the Digital Vulnerability Project actually comes at the perfect time, because it is precisely feeding into our reflections in the fitness check process. And therefore, I'm also personally very excited, wishing you all the best and looking forward to reading the findings. Thank you so much.
Thank you very much for this insight we got into the projects and the current work of the European Commission. We will come back maybe with some questions later on. And now we will take into account the global challenge, and we will ask whether there are global answers for the global challenge of digital vulnerability. At least, how far can the important work, which is done on several levels of national, European, international, global. How far can the work which is done on the different levels inspire each other? Are there maybe some mutual inspirations of the work the international organizations are doing and the European institutions are doing and some national institutions are doing? First of all, in this part, we will get some insight in the UNIDROIT recent projects with regard to the new technologies. Anna Veneziano will give us this introduction into the relevant work of the UNIDROIT. Anna Veneziano, well known, is the Deputy Secretary General of the International Institute for the Unification of Private Law, UNIDROIT. She is, by my interpretation of this function, not only the coordinator, but the heart of the work of UNIDROIT, dealing with many projects, inspiring new projects, giving really push to this important international institution. She participated in preparing and in drafting of many UNIDROIT projects, including some projects of the UNIDROIT and other international organizations, as for example, the UNIDROIT FAO project in the negotiation of mining, agriculture and construction, protocol to the Cape Town Convention, but also she participated in the work on other levels as an expert for Italy in international projects, as an expert for the European Commission, and in the reduction committee of the draft common frame of reference of European private law. And now, today, she will show us what UNIDROIT projects can help with respect to new technologies and maybe to digital vulnerability.
Thank you very much. Thank you very much to our moderator for the very nice introductory word. I am extremely delighted to see you after some years, to see you again and to work together with you here. And many thanks to Alberto De Franceschi for the kind invitation. I am honored and delighted to be here, and to the University of Ferrara, who hosts us in this wonderful room, who puts together technology with beauty. So it's really to the spot. And also to the participants and promoters of the Vulnerability Project, of course, who made this possible. Now, I will try to look at this topic from the lenses of the work that we are doing, or we have done at UNIDROIT. As I understand, because it was very well explained in the introductory words, at least one of the main aims of the project is to identify the specificities of digital vulnerability as opposed to the more traditional paradigms of protection of weaker parties, and to see how this can be perhaps also translated into concrete rules to mitigate those risks. And in this respect, I have 3 points I would like to make, and they are in the bubbles here. In order to make these 3 points, I will refer to 2 UNIDROIT instruments, 1 instrument and 1 project. But before doing that, I have 2 caveats I would like to put forward. And the first one is that, as many of you know, UNIDROIT deals mostly, though not exclusively, with specific sectors of commercial law. And therefore, it does not mean that issues of vulnerability in general and digital vulnerability in particular are not existing, but they might be declined in a different way. And sometimes what we do, or we did in the past, was actually to even describe in the title of the instrument that certain transactions were excluded. Look at the UNIDROIT principles for contract law, for example, or to very expressly defer to overriding mandatory rules different in different regions and different domestic laws, to say we are dealing with a general framework, but be careful because there are more specific rules for weaker parties. But of course, all this is much more difficult when we look at the impact of new technologies, because as you all know, this tends to blur the traditional dividing lines, and therefore sometimes we do have to take this vulnerability into account, even in the rules we develop. And this is also connected to the second point the second caveat I wanted to make, because it depends on the type of instrument that we develop. So more traditionally, as you know, we tend to provide globally harmonized or uniform substantive law solutions to practical problems that may arise in cross-border situations, so to facilitate international commercial relations, and as it is very often traditionally said, to reduce transaction costs. But more and more do we also provide harmonized guidance to legislators, domestic legislators and other stakeholders, which serves the two functions of modernizing an existing domestic legal framework, or introduce guidance in new sectors, and this is of course the field of new technologies, where governments are actually actively looking for models, globally speaking. And in this case, in this second function, I think issues of digital vulnerability, blurring the distinction among participants in the market is certainly more evident. But allow me to start with the bubbles. And the first one, which is now highlighted in light blue, is actually something that might be obvious, but I would like to make this point, because the whole conference is about risks, is about problems, is about vulnerability, which is fine. But I would like to say that for us, in our projects, in all our projects now, technology is seen as an enabler to reach development goals, especially for developing economies. And this is something that it's important, because from warehouse receipts, for example, to factoring, there is no project at UNIDROIT that does not have a part on the interaction with technology, and not only to look at the sectors where technology is already pervasive, and you ask the question of whether this technology creates issues, imbalances, risks, how do you tackle such negative effects, but also to proactively provide best practices for the use of the technology as means to enhance efficiency, transparency, and cost effectiveness. And in the end, it's a trade-off, especially for developing economies. So the issue might be a bit different in a global perspective than in the European region in this respect. And in this respect, I would like to make one example, which is connected to one current project at UNIDROIT, and then for the risks and how you can overcome the risk, I will make reference to a newly approved project. So the project is the project on best practices of effective enforcement. So we are developing a set of global standards in the form of best practices, very flexible instrument, providing guidance to national legislators particularly, though not only, on how to develop, but mostly to modernize, enforcement procedures and mechanisms. And when we talk about enforcement, we talk about execution of creditors' rights. So it's actually something which is considered to be particularly relevant for the developing of credit markets, for investment, because it's looked at as one of the factors for the rating, for example, in financing, but also for a full access to justice. But there are concerns in many legal systems around the world about inefficient enforcement mechanisms, and this even in those systems which already have a developed contract enforcement framework on substantive law issues. And so what we found that was probably the best way to tackle these problems was to use technology as a tool to tackle the traditional obstacles to effective enforcement. And let's think, for example, the use of platforms or registries which may use new technologies as well, so not traditional registries only, and the benefits deriving from them in terms of limiting delays, costs of enforcement proceedings, enhanced transparency, which is particularly important in many jurisdictions, and enhanced effectiveness against in asset liquidation. If we think about online sales and creating secondary markets, I'm looking at Teresa a lot because she is dealing with these topics in our project. And here we come to the issues and the possible risks as well, because it's all good to say we have to be proactive and incorporate technology, but we have also to look at what new problems may arise. And so we are looking, for example, at issues which are more institutional or architectural in nature, like monitoring, relationship between the different organs, accountability issues, but we also look at issues which are more connected to the single participants, like respect of fundamental rights and so on. So I will not go more in details about this because it's still an ongoing project. It might be interesting for you to know that we also deal with enforcement execution on digital assets. This is also a part that we have to consider. But allow me to drink first. And then to go to the solutions to the risks, so to look at the issue of vulnerability. I'm very sorry, in this particular context. And the 2 points I would like to make are, one is more general, and this is something that I really believe in, and I think it's also shared by the European Commission, which is the role of harmonized, or in this case, international standards in enhancing the predictability and transparency of the legal framework, which in itself is at least part of the solution. At least it introduces more information, it introduces more certainty, more predictability, and in new areas, this is particularly important. The second is to look whether there are specific private or commercial law rules which address issues of digital vulnerability, and I will try to make at least one example there. So in order to tackle these 2 points, I have, however, to bore you a little bit with some information about this new instrument that has been approved by the Governing Council of UNIDROIT in 2023 in May. So it's really brand new. And it's actually the principles on digital assets and private law that many of you might already know because there was a public consultation on them. So a working group was established to develop these legal instruments containing legislative guidance, so it's soft law instruments, of course. The idea was that there was a need to provide commercial certainty and clarity in a new area, and again, the proactive role of harmonization of national laws seen as beneficial, considering that such transactions often involve a cross-border element and may occur without a physical location, but I'm saying things that all of us know. So the aim of the project was to provide best practices enable jurisdictions to take a common approach to specific private law issues. And I will go back to the scope of the project in a moment, but they are broadly relating to the holding, transfer, and use as collateral of digital assets. So it's very specific. And therefore, as I said, it's a soft law approach. The commentary are extremely important, as I will try to explain, because they provide more suggestions in a softer form than the principles themselves, and illustrations, which in this case I think are particularly useful because it's a new area. And it is not a comprehensive code. It's only where clarification was considered to be needed. There is a variety of digital assets covered, but there is a specific definition which narrows down the electronic records we are focusing on, an electronic record capable of being the subject of control, and control is also separately defined in a functional way. And then this slide, I think it's important for one reason. Since my point was that, the second point was that international standards are in themselves beneficial, I think the way those international standards are developed is important, matters. And so the more inclusive this development is, of course, the better it is. So we had, of course, as usual, an expert group representing different geographical systems and relevant fields of law. We had participation of many observers. The HCCH was extremely active, and we'll see in a moment why, in the person of Jerry Escolar, but also, of course, ANCITRAL, the World Bank, the IMF, the ACB, so the European banking authorities, the Uniform Law Commission, the Law Commission of England and Wales, ALI, ELI, and so on. And also some representatives of the industries involved. And, but this project was considered so important in terms of what governments were trying to do, and the dividing line between private law, commercial law issues, and the regulatory framework is really, again, not so easily drawn, that there was a need to involve representatives of government in a way which was not done usually for soft law, at least at UNIDROIT. So we created a steering committee, which actually was more of a sounding board, with representatives nominated by experts. They were all experts, but nominated by member states. So there was a kind of changing the way that we develop soft laws. There was then an open consultation phase, and then the approval by our organ. So this was the way the project was developed. And I promise I'll try to be brief, but of course, I'll be very happy to discuss this later on with all of you, and to refer you to my colleagues who know much more than I do on this topic. The first, I wanted to focus on the scope. What do these principles encompass? So this is the general scheme of the principles at a very high level. In the blue rectangle, which is on your left-hand side, you can see what are the substantive legal principles that are contained in the UNIDROIT principles. In particular, the fact that the digital assets can be the subject of proprietary rights, but there is no definition of what is the nature of such proprietary rights, because this is left to the applicable other law. They can be the subject matter, the object of collateralization, and these rights should survive insolvency. So those are the pillars. Then there is one conflict of law principle, Article 5, which was much discussed, I'm looking at Jerry because on the basis of that principle, we are now entering into a new, very exciting project, the first one, which is joint with the HCCH, and I'm also looking at Alberto, who was nominated by Italy to participate in this project, but many others are participating. And, but why is this important? Because while the conflict of law principle is rather general, it has a lot of comments dealing with some issues which are not covered, but the issues of vulnerability will be actually addressed in this new project much more than in what we have done. So it's a kind of caveat, look out for something which is in the making. Then there is an innocent acquisition principle. There is a part on custody. Why? Of course, because at least for some digital assets, this is important. And I will go back to the custody part. And then a part on security rights. What is on the right-hand side in the blue, dark blue rectangles? It's not a square. It's definitions and concepts. So in order for the substantive legal issues to be applied, there are some broad definitions and concepts. As I already said, a definition of what is digital asset in this concept, a very functional definition of control, a definition of what is a custody agreement, and I will come back to that. And then there is the concept of so-called linked assets, though the matter of linked, how you create the link and the rules governing the link is not covered by the principles themselves. And here I come to the limits to the scope of the instrument. We have a big area in gray, with gray, yes, other law, non-exhaustive list here. Other law just means applicable law, which is not the principles, which is actually the whole area of what is broadly called regulation, which is actually the law usually enforced by public authorities, such as the system of licensing, possible sanctions, and so on, and as well as other types of specialized aspects of procedural law, insolvency law, private law, which is not addressed in the principle. And here you have a list of them. But perhaps the most important thing to note is that there is another rectangle there in light blue, in this case, which is that the comments provide some guidance for legislators in relation to other law. How you can shape the possible links and legal effectiveness of them, examples of what is a custody agreement, what is not a custody agreement, additional rules for the protection of clients. I will go back to this in my last slide, so I'm already anticipated, I only have one more slide. And possible challenges for procedural law and for enforcement. And this is important because it's connected to the first topic that I have addressed, enforcement, because in the commentary a number of challenges that a state may face when formulating its own rules on the enforcement of digital assets are identified, and then it's left to the other project we are conducting to give more substance to this. So in order to address the last, first of all, again, the role of international standards in enhancing predictability and transparency. Very rapidly, I think I have already made this point, so this is the first effect of introducing this harmonized guidance in a very, just to clarify, to introduce a common terminology and so on, but also to better understand what this is about in legal terms. Many times, this is a bit also to escape this idea that this is code law, we don't need the law, and of course we know that this is not the case. And then the last point is, I have already dealt with this. The last point is specific private law rules to address digital vulnerability. And I will make just one example. There might be better examples, and if you have them, please let's have a discussion. But this is the example. The example is in the field of custody. And as you know, the custody section is particularly relevant, at least for some of the crypto exchanges. In the principles, the concept of custody is a functional one. In other words, an intermediary is a custodian if it is, and to the extent that it is providing custody services, even if it also provides other services, such as acting as an exchange, and irrespective of the label that it's used. Let's look at the definition of a custody agreement. There are some elements, and I think one of the most important elements is that it enables to draw a distinction between a custody agreement, which is subject to certain duties, and an agreement for delivery of digital assets, which where the client only has a personal claim as against the services provider for delivery, and the assets in question are available for the creditors of the service provider in the insolvency. So this is an issue that you might have seen has already been the subject of court decisions, for example, in the US. And here we see again in a rectangle that there is a presumption that if the service provider's client does not have control of the asset, the agreement is a custody agreement, which entails specific duties of the custodian towards the client, unless the agreement clearly specifies that the assets held by the service provider are available for distribution in case of an insolvency-related proceeding. So this means that the protection rule is just, let's make it very clear in the agreement, otherwise you fall under these rules. And then what I was saying before, that all other matters, many other matters are left to other law, but the comments give some guidance and say, perhaps you should have some rules on that. So legislators are invited to consider additional duties owed by the custodians to the client in a way of protecting the client, such as keeping a record of the digital assets, correlated to the maintenance duties of the custodian, replacement of missing assets under specific conditions, mandatory separations of digital assets, but it does not tell us how to do that. And here, I think one important point which you will probably address in the project is this flexibility, in the sense that the comments do not determine whether such duties should be a matter of private law, with private law type of redress in case of breach, or, broadly speaking, regulatory law, with sanctions, for example, different sanctions imposed by state, or a mixture of the two. I'm invited by the moderator to stop here. I will do so. Sorry if I took more time than it was warranted, and thank you, and grazie.
We have to thank you. It was a very rich information, and we are well informed now. Also, we will have some questions, and hopefully we will still have some time to ask the questions at the end. We have still 2 more presentations. Digital vulnerability in automatic contracting and the UNCITRAL work. Teresa Rodriguez de las Heras Baliel now will introduce us in this topic. She is a professor at the University Carlos III in Madrid, but she is, I think, not only a professor at this university, she is the leading Spanish scholar in digital matters. She is an expert working with UNCITRAL, but not only with UNCITRAL. She is a member of various expert groups of the European Commission, and she is an international scholar. She told me, and I got the impression just on the beforehand, that she spends 70% of her time in other countries discussing international aspects of our topic. The floor is to you.
Thank you very much for this kind introduction. It's indeed my great pleasure and my honor to have the opportunity to be today with all of you and be part of this fabulous panel surrounded by dear friends and very, very esteemed colleagues. Thank you very much, Alberto De Franceschi, for your kind invitation, and also my friends Camila, Marta, and many others that I can see in the audience today. So in order to talk about automated contracting and connecting this fascinating topic as to algorithmic contracting with the use-central work is indeed quite intended. The idea is, I have been working on automated contracting from the perspective of the European Law Institute work, and is very much linked to the European Commission intent of understanding to which extent the consumer protection legislation should be accommodated and adapted to the use of artificial intelligence in contract. But a few months ago, UNCITRAL decided to include in the project of the Working Group 4 on electronic commerce, a project on artificial intelligence and automation. If we put these two topics together, we have the opportunity, and that is exactly the aim of my presentation, we have the opportunity to put pressure on the idea of digital vulnerability and try to test to which extent is that vulnerability arising from the use of technology itself, even in transactions that are purely business-to-business transactions. So to which extent, and this is the core and the heart of this fantastic project, to which extent we have to go beyond the traditional vulnerabilities associated to weaker parties in consumer transaction, and we have to assume that there are other levels and forms of asymmetries that may require a specific legal solution. And that is exactly the reason why we wanted to connect the work of UNCITRAL, that is essentially, as you know, within their classical mandate and remit, is essentially focused on business-to-business transaction. But when we started to discuss automated contracting, suddenly we discovered here there is an asymmetry that may require a specific legal attention. So what is the research question that is triggering my presentation? So is the use of artificial intelligence and automation throughout the contract life cycle triggering digital vulnerabilities, exacerbating digital vulnerabilities even in business-to-business transaction, and therefore beyond the traditional or the classical vulnerability scenarios where we have a weaker party? So this is the main question. But in order to understand what kind of vulnerabilities we're talking about, I will go to other sub-questions, much more related to the consumer transaction, as Egeline has been explaining before. For example, this idea of vulnerability is indeed connatural to the presence of a weaker party, is indeed an assistant or virtual assistant consumer more vulnerable, or on the contrary, better protected? So should we indeed assume that the AI-driven decision adopted by the consumer is surprisingly not more exposed to vulnerability, but on the contrary, better protected? That is, in my opinion, a fundamental question that we have to solve, that is completely changing the rationale behind consumer protection. And that leads us to the second question that is also fascinating. Is this rationale behind consumer protection based on information and the existence of an informed consumer? Is indeed still working as a paradigm? Or we have to change completely the idea of information as the key, as the pillar around which everything about consumer protection is working? So as you can see, I would like just to talk about what is an automated contract, what are we talking about when we talk about automated contracting, what are the different projects that are dealing with these kind of issues. I would like to stress and highlight what I consider the main issues that we really have to explore and decide on, and finally, some findings related to this combination of automated contracting and digital vulnerability. So, what is automated contracting? Automated contracting entails the use of AI systems, or in general, automation. That means that we covered both deterministic algorithm as well as more autonomous AI-driven system. So we're talking about the use of AI system and in general algorithm for the purpose of either negotiating, concluding, performing, or enforcing contractual remedies between two contracting parties. So as you can see in this illustration, the automated contracting or the automated contract is the one concluded between the smart warehouse and the smart store by using this kind of AI system. What is the main question before diving into the question of vulnerability? What do we really have to solve first when we talk about private law and algorithmic contracting? The first and fundamental question goes to the basis, and it's about validity and enforceability. Can we assume that all these kind of actions and or decisions that the AI system assists to take or directly take are valid and enforceable? And in order to reply this question, can we simply apply the traditional but still fundamental principle of functional equivalence and technology neutrality in order to say any action driven or taken by an AI system is equivalent to the same action driven or taken by human decision? Can we apply a functional equivalence principle and therefore try to solve all these kind of problems? But if we do that, and definitely in the UNCITRAL work and the Working Group 4, we have already definitely formulated a principle with a significant level of consensus saying, yes, they are valid and enforceable, but this is only the first step. Because the second step is, even if we decide not to go for the very provocative route of allocating personality to the AI system, even if we say definitely this kind of AI system, even if they're highly autonomous, they do not have personality, if we do that, we have to solve the next question that is fundamental. Therefore, to whom? To whom we are going to allocate the legal effect that we assume valid and enforceable, that they are going to have an impact in the contractual environment, that are going to be offers, acceptance, renegotiation proposal. They are going to have action with contractual effect and contractual or even liability consequences. So the second fundamental question is to whom? And you will see in a minute that is not an easy task. It's not easy because even if from a purely dogmatic point of view, it's relatively evident to say we will allocate the legal effect to the person on whose behalf the system is operating, that on whose behalf is plenty of complexities when we are talking about autonomous system. And I will explain that in a minute. This is the question from the contractual perspective, but we need to combine that from the liability perspective. To whom we are going to allocate the risk and the liability arising in case of damages caused by the use of AI system. If we take a slightly different perspective as the one that Egelin was explaining before, that is the perspective of the consumer, we immediately realize that there are more evident and straightforward areas where digital vulnerability is evident. And I will explain you that in a minute. This is the kind of illustration that we have in mind when we talk about algorithmic contracting in consumer transaction. We have a consumer who is using, and in this case, virtual assistant, Alexa. Alexa is searching information, comparing information, providing information, but is also negotiating and concluding contract on behalf of the consumer. What new issues we have to solve? Please kindly take a look to the bottom of the slide. Once we solve the problem of attribution, once we solve the problem of allocation, we immediately realize that there are many additional questions that we have to address. For example, what if the virtual assistant itself, precisely because it's programmed by a third party, is provided by data coming from other sources, is evolving, is learning, is upgraded, in a way, is not a source of conflict of interest that the consumer is completely unable to prevent and manage? Is the idea of informed decision still the paradigm that we have to use? And if we assume that it is, how do we deal with this kind of new manipulation? Manipulative action that are not addressed to impact on the human decision-making. They are indeed addressed to impact on the process according to which this decision, this virtual assistant decision-making is operating. It's exactly the dark patterns that Egelin was talking about. So as you can see, new problems, new issues that maybe aggravate the digital vulnerabilities traditionally linked to the weaker party. Let me just provide you with an additional conceptual element that I need for the purpose of diving into the problem of digital vulnerability. As you can see here, we have 3 possible scenarios, and in each scenario we find different problems to address. We could be in a situation, left side of the slide, where the consumer is using ADM, automated decision making, but the trader is not. The second scenario is the consumer is a human consumer with no assistant at all, and the trader is using an ADM, or we are in a purely M2M transaction with 2 digital assistants indeed negotiating between them. In all cases, the problems are focused on what we called the supply contract. This is what we consider an algorithmic contract. And you will see how fascinating is this, because there we have to realize that there are other contracts that might be as well source of new vulnerabilities. Let me just explain very briefly. So we have a consumer who is going to conclude contract with third parties. These contracts are going to be negotiated and concluded and maybe performed as well by the digital assistant. First contract. Second contract. For the consumer to have this digital assistant operating on whose behalf required another contract. The contract with the provider of the ADM. Definitely a contract that we have to categorize, and we have definitely to feed into the consumer legislation as well. And the third situation that might be overlapping or purely in parallel to the previous one is what happened when the consumer is using a platform, Amazon, and within the platform, the negotiation is assisted or conducted by an ADM. So we have here 2 contracts. The first one is the membership agreement using the platform. The second one is the ADM provision. And the third one is the final contract that we are indeed interested in. In all this illustration, I am systematically referring to the idea of ADM, automated decision-making, or in general, AI-driven decision-making process. What is this? Do we have a definition of AI system, in particular in Europe? We do. In the Draft Artificial Intelligence Act, we have a definition that crystallizes in the process that you can see in the screen at the moment. As you can see, it's a process that is essentially collecting input from the environment, processing this input in order to produce or generate an output. This output could be a recommendation. This is the movie that you're going to love. This output could be ranking. This is the best hotel in Ferrara. This output could be an offer, could be an acceptance, or could be an action with significant implication in the performance of the contract. So as you can see, in all these scenarios, we have exactly the same process. Input, processed by AI techniques, learning system essentially, according to implied or explicit objective, and the output is generated. We cannot go further unless we discuss a little bit more about how these kind of systems are put in practice, how they are used in practice. And this is very important because in order to reveal how complex is the question about attribution and allocation, we have to realize that there are many actors involved in how an ADM works, is implemented, is deployed, and is generating the output that we need. And that is the reason why, please take a look at the right side of the screen, that is the reason why the attribution exercise is not evident, it's not easy, because we have a number of actors that might have impact on why this particular virtual assistant is recommending this product, is making that offer, or is deciding to renegotiate my subscription agreement. There are many data coming from different sources. There are many reasons why this system is deciding to act according to that particular criteria. And that is the reason, as you can see, why it's not so evident on whose behalf the system is operating, or who is liable in case of mistake or in case of damages caused by this particular action or this particular decision. Who is working on that at the moment? As I explained you at the beginning, the first scenario, the first framework within this idea of automated contracting has been started. It's very much linked to the European Union context. And in particular, in the European Law Institute, we published last year guiding principle for automated decision-making. And at the moment, currently, we are conducting and running a project on algorithmic contract that is first focused on this consumer interest of the Commission, but is going to be expanded to M2M transaction and B2B transaction as well. On the other side, we have the United Nations work on the automation and international trade that seems to be on the other edge of the spectrum, focused on business-to-business transaction. But we will see immediately to which extent this is a clear dichotomy, or we are, all of us, throughout this spectrum. But let me just please catch your attention and draw your attention to the middle of the screen, where you can see the work that the European Union is doing on AI, and in particular on AI liability. Why? You will see immediately that when we find a problem to solve in relation to algorithmic contract, for example, is this wrong decision a problem of mistake, so a problem of lack of consent or vitiated consent, or is a problem of liability? In all the cases, we have these two possible angles. Shall we solve the problem saying this is a mistake or this is a problem of attribution? For example, this decision of Alexa is so unexpected that I cannot attribute the legal consequences to the consumer because it's completely unpredictable, first possibility. Second, Alexa is learning in a way that is so unexpected and surprising that it is a clear mistake, therefore there is a lack of consent, contractual side. Or maybe we attribute the decision. Maybe we assume that this contract has been concluded on behalf of the consumer. The consumer is bound, but the ADM provider is liable. Is liable for defective product or is liable for any other ground that we can apply in this situation. So as you can see, liability and contract law should work together in this scenario more than ever. In the case of the ELI, just to give you a little bit more of detail on that, we are talking about algorithmic contract throughout the entire contractual life cycle. So from the very beginning, pre-contractual negotiation, to the very end, even in case of default. Some ideas in order to understand what are we talking about. For example, we think about Alexa initiating a negotiation, Alexa personalizing pricing, or Alexa suggesting a renegotiation of my subscription of Netflix because there is a better fee or price that I could benefit from. But what I really would like to you take a look, please, is on the very right side of the screen, a beautiful idea that we are exploring and trying to advocate for. Is really the consumer exposed to new vulnerabilities because all the characteristics of AI are indeed exacerbating, aggravating this idea of lack of protection, this idea of asymmetry, is opaque, is complex, is changing, is unpredictable, is out of control, is data dependent. Everything in our opinion seems to aggravate the unfavorable position of the consumer. Is that true? Or we have another possibility, the possibility of exploring and pushing what we call augmented consumer. Consumer who are better protected. Consumer who are dealing with information that is discriminated for them, selected for them, enhanced, clarified, thanks to the use of technology. That would entail a total revolution in consumer protection. a total change in the paradigm founding how consumer protection has been indeed designed and developed in the last decade. Let me just start concluding. Rainer, let me know if I am okay within my time. I'm going to conclude by showing you the key issues that we are discussing, and immediately after I will conclude in a minute with the findings and some questions for future work. So, key issues to discuss. The first one, we need to attribute the legal effect of this ADM or AI system, and in order to attribute, we can't either exploit or explore these two factors, control and benefit. I like those of them very much. The idea is we attribute the legal effect to the person who is in control and benefit from the use of this ADM for a particular activity, first possibility. Second possibility, to come back to a very abstract and dogmatic principle on whose behalf. And then we will discuss case by case what that means. Second problem to solve, all this idea of the information asymmetry has to be, in my opinion, totally revisit and reconsider from the very beginning to the very end. First, because maybe the asymmetry is changed completely. Second, because it's not a problem of asymmetry in the sense of quantity. It's a problem of information processing capability. So to which extent I can't manage as a contracting party all the available information. It's not a problem of availability, accessibility. It's a problem of managing, processing, understanding the information. Third issue, how to deal with error and mistake. Should we force this idea of mistake as an element distorting and interfering in the validity of the consent? Or we simply deal with this problem as an allocation of risk? It's a problem of malfunctioning of the system, therefore let's talk about liability. It's nothing about consent, nothing about intent, nothing about contract, it's purely liability. What do we do in this regard? Final key issue that we have to discuss very carefully. There are fascinating principles in the context of AI governance. The AI Act in Europe is based on the idea of transparency, explainability, impact assessment, essentially elements that are more related to the design of the system and how the system operates and how the system is governed. How do we use this element in the context of a pure private law analysis? What happens if it's not transparent? It's a problem of liability, it's a problem of regulatory infringement, it's a problem of lack of consent. So how do we transform and materialize this kind of regulatory requirement in the narrative of private law, contract law, and liability? So let me just conclude with a final slide where I try to show you all the different elements that I consider could be labeled as digital vulnerability arising from algorithmic contracting. As you can see, I have discussed most of them. They are related to information, asymmetries, conflict of interest, lack of control of the consumer in relation to the criteria. So in a way, it's a map of the issues that, in my opinion, should be discussed in depth. And this is, instead of going there, this is my last slide. Question for discussion and future work. The first one is, if we believe, and I believe and advocate for, technology neutrality is showing limitation now. Technology neutrality is insufficient, in my opinion, to solve the challenges coming from AI in particular. If that is the reason, if that is the statement, what is the reason? Why? It's because precisely there are a new source of digital vulnerability in the use of AI, and that is the reason why technology neutrality and functional equivalence are not working effectively, because there are a new vulnerability that we have to address, tackle, and diminish. The second question is, shall this digital vulnerability become a ground for legal protection, even in those scenarios where there is not the traditional weaker party that is going to be protected? So is digital vulnerability itself, as you in the project has raised, is indeed legal ground or a legal basis for protection? Can I claim compensation of damages because of digital vulnerability? Can I, for example, claim that my contract is invalid because I was in a situation of digital vulnerability? What that means in terms of procedural aspect, for example. And finally, if we talk about digital vulnerability, but who is affected by the digital vulnerability? Is the consumer assisted by the virtual assistant the vulnerable party? Or maybe it's the trader? Maybe the trader now is in a different and difficult position when they are dealing with augmented consumer. These are the kind of questions that we really have to bear in mind when we are working on automated contracting and digital vulnerability. Very happy to discuss further. Thank you very much.
Thank you very much to you. I think now we have approached some crucial questions of our 2 days meeting. We'll have time not only in our discussion in the next half an hour, but also in the next 2 days. Just because I think this was a very important contribution, which has shown us there is a need, as far as I understood it, there is a need of protection. There is digital vulnerability exists. However, following your approach, we should look for some other ways and for another subject of the protection, different from the traditional way of consumer law and different from the traditional subject of protection as the notion of consumer suggests. We will come back to this surely, but first of all, before we enter the discussion, we have the pleasure to get the paper of Geraldine Gaux-Escolar, which will introduce us in the work and the impact of the Hague Conference on Private and National Law. Let me say, we will now come to the most traditional, most famous international institution. Forgive me that I say to both of you, that's the institution which exists since 1893 and which deals since this time always with current problems, all the time, new problems. Geraldine Gaux-Escolar is the Deputy Secretary General on the Permanent Bureau of the Hague Conference on Private and National Law, with former experience as a counsel and advocate in international litigation and arbitration and in international institutions. And beside of this, she is an academic too. She is a professor at the National University of Singapore with a doctorate at the famous University of Leiden in the Netherlands. Thank you for coming to us.
Thank you very much, Chair, for that very kind introduction. And thank you to all of you here as well for being with me through this session. Allow me to thank in particular Professor Alberto De Franceschi for the very kind invitation to be here this morning, and to the rest of the Scientific Committee and the Advisory Board of this project. Today I have to balance the disadvantage of speaking after a panel of such eloquent speakers, so I'm going to pretend that's wonderful. And it really is, because they have actually described to you the issues which are on the table in much clearer terms than I ever could. So I'm going to build on what they have said and hopefully take it through quite quickly. I come from the organization known as the Hague Conference on Private International Law. We call ourselves the HCCH. It's the conglomeration of the English and French, and soon the English and Spanish short forms of the title of the organization. It's a bit of a misnomer. As the chair has said, it has existed since 1893. We celebrate our 130th anniversary this year. So we're quite excited about that. But we call ourselves the Hague Conference. And when I told my parents that I was going to leave practice to go work for the Hague Conference, my father then asked me, well, what happens after the conference? But it's a conference that has gone on for 130 years. It really is an international, intergovernmental organization. We're the only one in The Hague that has a legislative function. So what we do is we make treaties, we make guidance. We're like the United Nations, but specific to a field that we call private international law. And there we look at applicable law matters, the matters of competence and jurisdiction of courts, including the choice of forum. We look at recognition and enforcement of disputes, of decisions, and we also look at international cooperation mechanisms that allow these sort of issues to be easily resolved. Now, if I might, and I've already been preempted by this, in a previous life, I am a space geek. I like space things. So I was really excited to come to Ferrara because this is the seat of Nicolae Copernicus, and I thought that was fantastic. So I thought I'd start with a little story to help you here. When we talk about digital vulnerability at the HCCH, much like my friend Anna Veneziano has said, our mandate is not specific to digital vulnerability. We do a lot of different work. And so when I approached this topic, I thought about 3 different kinds of vulnerability. The first one is vulnerability in code, and that's where space comes in. On the 22nd of July in 1962, the National Space Administration of the United States, NASA, you'd be famous to NASA, launched Marina 1. Marina 1 was intended to do a flyby of Venus. It's a really exciting project. Approximately 900 seconds after launch, they had to destroy Marina 1 and take it down because there was a problem with the guidance system. One of the issues, the specific issue, was that in the code of the program of Marina that allowed us to track and to have its telemetry, there was a missing hyphen in that code. So the whole code had been written and was a hyphen that was missing. Arthur C. Clarke called that the most expensive hyphen in the history of humanity. It cost NASA at the point of time $70 million. In today's dollars, about $200 million. That's what it cost. So that's Marina 1, and that's vulnerability in code. We also have today, you heard many times already, vulnerability in literacy and in competency. And what we mean by that is this. In a conversation I had with my legal officer, Harry Cheng, we had a conversation that, in fact, there's only really one generation that knows how to use computers. We're all sat in a room here today. The generations before us didn't have computers. And the ones after us had sandboxes, like in the Apple ecosystem, where I would challenge children today to be able to code these things. Now, I learned about computers by actually physically building the hardware, introducing viruses into it, and learning to decode and debug that program. And I wonder how many people can do that. So there we see basically a vulnerability in terms of literacy and in terms of competency. And I do hope that with AI and this sort of thing, we'll have what my friend Teresa has said, which is augmented user, but we'll have to see what happens there. Now, the last vulnerability has to do with the speed of development. And this past Monday, we had an experts group sat with us in The Hague, where one of the considerations that they brought up was a matter of front-running the industry. With the industry moving so fast, what do we do with things like soul-bound tokens, with these things, these concepts that keep coming up? I desperately read every morning, 2 hours at least, on what's happening, and I never catch up. So the industry keeps going, and the question is, how can legal frameworks deal with this vulnerability in the speed of development? So that's what I thought we'd approach digital vulnerability from. Now, a bunch of words up there, just simply to tell you that we do a lot of work at the HCCH in relation to private international law issues, and we don't just work on it from a commercial, digital, or financial law point of view. There's also the matter of the protection of children and of vulnerable adults, and I'd like to go into that maybe a little more. So today, the matter is this. Here's the wonderful thing. All of us, we stand on a precipice today, and we can decide what will happen from today going forward. What does that mean? Today, with the digital economy, 2 things can happen. We can go the route of no one left behind, or we can go the route of really creating an even bigger differential between the people that can actively involve themselves effectively in the digital society and the digital economy today, and those who cannot. And therein lies the digital vulnerability. There has been a wonderful study, first in the European context, not just consumers, but also in terms of users and in terms of our young people, but also in the matter of the global context. And we find that people in rural areas with education up to a high school level or below are the ones who would benefit most from the digital economy, from the digitization of what we're seeing today. These are also the same sectors who are the most vulnerable because of the lack of competency and literacy in this field. So what do we do at the Hague Conference? We try to make sure that there's a progressive unification of private international law. It's a slightly different mandate in our sister organization, UNIDROIT, who deals with substantive private law, international private law. So we just invert the words, essentially. That's why we're so close. But at the ACCH, two things that I wanted to point out today. First, we facilitate cross-border interactions. That's what we've been doing for 130 years. And we do that between individuals and families, business and commercial operators, and public institutions across borders. In relation to the digital economy, we of course look at all the technological advancements, including the growth and uptake and the trends in those uptake in relation to the use of technology for all of our instruments. The one that you know best, probably, in this room is the 1961 Apostille Convention. I'm sure. You've had something apostolized, I'm sure, yes? Yeah, so you want to go across borders, you want to have your certificate. Instead of going through your Ministry of Foreign Affairs, you go and you get this wonderful wax seal on it. You have an apostolized document, and they will have to recognize at least that that's the public document, authentic, where it came from. Now, we have something called the Electronic Apostille Program, and by using that digital technology, we enable the use of this sort of conventions in the new digitized economy. So all of this, of course, challenges traditional legal concepts. As the chair has said, we are the most traditional organization, and so we try to catch up there. Why is this important? For every $1, every €1 that's invested in the digital economy, the yield is $20. That's the highest return on investment that any government can do with taxpayers' money. Why is that so? For non-digital investments, it's a 1 to 6.7 ratio. So that's a 670% increase when you put the money into digital or digital-linked investments as opposed to non-digital investments. And that is why it's becoming more and more important, not just to address digital vulnerabilities, but to get beyond that into augmentation of the use of the digital economy. So, what private international law issues surround digital vulnerability? And here I'll walk you through this and also talk about the things that my organization does. We'll start, I obviously cannot count to 12, but if you start at 12 o'clock up there, you see jurisdiction and applicable law over cognitive artificial intelligence and machine learning. Now, my friend Teresa Rodriguez de Laez has already talked about this in the matter of using cognitive artificial intelligence, attribution, how do you attribute, what do you do with liability and contractual issues. But there, of course, we also start to look at the matter of jurisdiction. So how would you have jurisdiction? How would you extend jurisdiction over a machine learning apparatus or an artificial intelligence or deep learning? How would you do that? And what kinds of courts would have that kind of competence? If you go over to what's probably 2:30, you also have the private international law issues surrounding digital and cryptocurrencies and payment platforms. Now, we have one whole project now focused on this issue, on these issues rather, all the private international law issues that come up in the use of central bank digital currencies, cryptocurrencies and payment platforms. Now, this is important not just within the system in Europe. Europe has, of course, the digital euro coming soon, hopefully, but in particular across island states. So you see, for example, in the Caribbean and in the Pacific, where cash is expensive. It's extremely expensive. You also see the issue in certain economies, for example, in Southeast Asia, who would like to de-dollarize their economy. So their economies are all pegged to the US dollar. They want to de-dollarize it. And how would you do that? 94% of the world's gross domestic product today come from jurisdictions that are either piloting or already have a digital currency. And we need to know what the private international law issues are. Professor De Franceschi is one of the experts that's been nominated by the Italian government to work on this project. Now we go a little further, and you see jurisdiction in the metaverse. The metaverse was very sexy about 2 years ago, not so sexy anymore. We need a good name for this. But with Google and Microsoft and Apple now entering the fray in the last month or so, we start to see issues of jurisdiction in that matter in the metaverse for contractual issues, proprietary issues, as well as torts and delicts. Now, what does that mean? I don't know how many of you are gamers. I'm a geek. I love gaming. So imagine if I wear one of those suits that allow me to experience what I see in the gaming world. So you can actually put on a suit now with a helmet, with a VR visor. And imagine this gentleman here does as well, and he does the same, and we play World of Warcraft. I don't know. So what happens is I smack you with my weapon, and you feel it in your face. Question, did you consent to that? And question, what if I break one of the tokens that you buy in the metaverse for that game? What is the tortious liability there? Is there tortious liability? And what kind of jurisdiction would we have when that metaverse transcends so many different kinds and places of jurisdictions? Going down, of course, you see the Internet of Things, and my friend Teresa has already spoken about that in relation to global value supply chain. So I won't touch on that, but obviously, once you have trade across borders, we also touch on work that UNCITRAL does and UNIDROIT also does in relation to what happens to those kinds of interaction. A bit further on in the orange, and this is a serious problem, is the disintermediation, and what do we do with the traditional state-centric cooperation mechanisms? So it's wonderful to have all the states together, we agree on conventions, we sign these things. This comes from 1648, from Westphalia, when you had the Westphalian system and these artificial borders. And the question is, in the digital economy today, is one of the vulnerabilities the attraction of this state-centric system? Does it still work? Why should it work? And if it doesn't work, do we have other legal constructs in place for international organizations? The answer at the moment is no, but we need to figure out what to do about that. Further on, you see digitized and online transnational litigation. Now, one entire division of the HCCH focuses on transnational litigation. And there we have, for example, the 1965 Service of Documents Across Borders Convention and the 1970 Convention on the Taking of Evidence Across Borders. That allows us to use technology to take evidence to serve documents, and that's a fundamental part of access to justice. If you're a defendant, you want to know that process is being served. And how would you do that? Very recently, in the Circuit Court of the state of California in the United States, it was agreed that you could serve documents through the airdrop of a non-fungible token onto the wallet of the defendant or the alleged defendant. The question, of course, is there is a digital trail, but what if that defendant never opens that token? What if the defendant rejects that from, if you have a wallet, I mean, I would never touch an NFT I didn't know, and suddenly it pops up in my wallet, I would never open this thing. So how would that work in the service of documents? Of course, we also take evidence across borders now, and just before the pandemic, quite serendipitously, we published a guide to good practice on the taking of evidence across borders by video link. And what does that mean in terms of procedural law and natural justice? If you're taking evidence across a camera, is it a real person sitting there? Have you seen those deep fakes of various different celebrities doing interesting things? What happens if it was a deep fake program? What if it is not? What if someone's coaching someone quite simply across a camera? And those are the things that we deal with as well in terms of digital vulnerability. Further up is the law applicable to digital assets and tokens. And then my very good friend Anna Veneziano has already spoken about the UNIDROIT principles. I'll speak about that project a little later. So those are the issues that from private international law surround digital vulnerability. And it all comes back to this CITES. What is CITES? When I first joined the organization, I thought this was a cool word. It simply means to locate something so that you can have a connecting factor. And that's so traditional today. How do you locate something? We know it's on planet Earth still, although now with space chain and all that, it might be in space. But without CITES, how would you have the traditional connecting factors that would solve all of these private international law issues? And together with that then comes a bunch of other questions. The pseudonymity of users and the decentralized nature of ledgers that were being used today. It makes the CITES of a transaction difficult to determine. What is the relationship between participants in a decentralized, disintermediated system? How do you characterize that relationship? What do you talk about in terms of that transaction? When you hold and you transact in digital assets and tokens, how do you characterize that? Is that merely contractual? Are there proprietary issues? What kind of laws would be applicable? There's a whole project about that we're really excited about. The contractual and proprietary effects of digital assets towards third parties. Innocent acquisition, for example, but other things, for example, the issuers of crypto securities, heirs in succession, creditors of insolvent digital assets holders, and we saw that in the last 36 months. That's actually quite an important topic. And of course, this is quite something interesting. Disputes related to the outcomes of self-executing automated contracts, which are deployed in distributed systems. It's difficult to determine which court would have jurisdiction and how to recognize and enforce the outcome of a DLT-based dispute resolution. And more we see systems like Kleros that allows tokenization of these dispute resolution mechanisms. And how would they then recognize and enforce these sorts of decisions? So we have several projects, as I mentioned to you. The one that we're doing in The Hague as a flagship is the Central Bank Digital Currencies project. Is in its exploratory phase. And there it really is a matter of the sui generis characterization of what digital currencies are. What are these things? Are they fiat? Are they not? I mean, are they crypto? Would El Salvador's adoption of Bitcoin be considered that or not? Obviously not a digital currency. All the difficulties you have with the traditional connecting factors when you talk about digital currencies, the disintermediation, what kind of law would apply? How would you determine the applicable law? Which court would have jurisdiction in relation to intermediaries? And how would judgments in CBDC systems and cross-border digitized payment platforms be recognized and enforced across jurisdictions? So that's one project. If you have any questions, ask Professor De Franceschi. He's the expert. I'm just the secretariat. So there is, of course, together with our sister organization, UNIDOA, a project we are proud of, which is the HCCH UNIDOA Digital Assets and Tokens Joint Project. It is the first institutional cooperation between UNIDOA and the Hague Conference, and we are terribly proud of this because it also leverages not just the expertise, but the resources of both organizations. So this is also right now in an exploratory phase, and it builds on Principle 5 of the UNIDOA Principles on Digital Assets that you've heard my friend Anna speak about. We're looking now at determining the law applicable in respect of a digital asset or token, as well as substantive matters that relate to applicable law. So linked assets, you've already heard about that. Digital twins and digital triplets. What do you do with soul-bound tokens? What do you do with novel assets? How do we do all that things and look at connecting factors? We also look at contractual aspects of it. How do you characterize these transactions? Do we talk about party autonomy, and if so, how? And of course, jurisdiction, recognition, and enforcement. I won't go into this, but just to mention to you that we are also looking in the digital economy in relation to the ramifications of technological developments on financial services and securities industries, as well as protecting weaker parties. And again, what does that mean? In 2015, we have the principles on choice of law in international commercial contracts. They're soft law, but those commercial contracts apply just as much in the digital world. So how does that work in relation to protecting parties? More and more, we see the digital economy as, with the dark patterns that Egelin talked about, a component of elder abuse. And many elders be losing their entire life's work and their entire life's pension and assets because of these sort of dark patterns. In 2000, we have the Convention on the Protection of Vulnerable Adults. In 1996, a framework convention on the law applicable for legal parentage and the protection of children across borders. Can we use these sort of family law concepts as well in the digital economy? We look at insolvency, which I won't go into, but we've already heard about that. So it basically is a matter of whether the black ball of insolvency rules needs some more additions for the digital economy, especially in terms of injunctive relief and unique assets. Intellectual property, of course, with artificial intelligence, big data, and NFTs is something that we're looking at and that we're working with the International Bureau of the World Intellectual Property Organization, WIPO. And this is really exciting. We're also starting to look at DAOs, decentralized autonomous organizations, whether they can be recognized in other states. How do we apply the Trusts Convention? I'm a common law trained lawyer. I don't know how many of you are here. But if you have 25 common law lawyers in a room, you ask them what a trust is, you'll get 100 different answers, essentially. But we're starting to see that decentralized autonomous organizations, DAOs, are starting to be used as charitable organizations, in particular in Islamic financing. So all that money is coming in as DAOs, and how would you regulate it? What kind of applicable law would apply? In particular for a Maverick DAO, how would you do that? So I'm going to stop here. You've already had quite a lot this morning, but of course happy to discuss this as you go forward. That's my contact details, and thank you very much for having me today. Thank you.
Thank you very much for this inspiring and lively presentation. Great success that you draw the attention. Great success that you draw the attention to you after 2 hours of other presentations. And maybe you was a little bit too modest. You didn't only give an overview on the international private law issues around digital vulnerability, but I think in many points you gave an overview and some very important hints to the private law issues generally on digital vulnerability. Thank you very much for that. Now we will have a short time, 10 minutes for discussion. The floor is open for any questions or remarks. Maybe we will collect some questions. Please. Yes. Yeah, you are. Yeah. Could you get a micro? No, the lady. Is there any?
È qua, prof.
The micro is on the way.
Thanks a lot for your presentations. There is a lot of stuff we can discuss. I have just a few comments or questions for our speakers today. The first one is about vulnerability in the sense, it is not very clear to me after this first session. Do you think is the old concept of vulnerability from the original Unfair Commercial Practice Directive that is under discussion here, or it is a new concept of a different nature, so different in nature, that we have to decide we need today because of the challenges of digitalization? And my second point is about technology, in the sense, technology is changing rapidly. So basically, how far we think we can rule on a changing issue, a changing technology, by a law that is slow in being passed, and then it could be not updated very shortly. So it could be that in certain occasions it's better to, wait and see. And has it sense to talk of digital generally, in the sense that basically we know, take the example of AI. One thing is machine learning. One thing is there are plenty of technologies, probably. Could we go for a general approach, or do we need a sectorial approach to these problems that you have raised? And basically, and finally, when we talk of fairness here, do we talk of procedures, basically? No, this point has been touched. In the sense, the role of procedures and design of the machine. This role is essential, we know, in the future, but what is the role of lawyers here? In the sense that when you rely on technology now to regulate or to enhance the knowledge of consumers, to augment consumers, no? Who is to develop the technology? In the sense, we have tools, but we can give a contribution as lawyers, but basically you have to develop something based off software, and who is going to develop this? I mean, we have Claudette, this is an example.
Please be brief, be short, because we have more questions.
But who is going to develop the tools? Who is paying for? Because they are costly. Thank you so much.
Thank you. The next question, we will collect the questions and answer all together. Here.
Yes, thank you. I will be very brief, and my question is, I think, very simple, at least when you ask it. So, what about the average consumer? Because this is something that Elgenon mentioned briefly in her presentation, and from what I understand, one of the main points of our exercise we are carrying out at this conference is to better understand to what extent we can go with the concept of vulnerability beyond the framework that we have right now in the EU law, namely beyond the framework that we have in the Unfair Commercial Practices Directive and all the case law built around it, which was much more a status-based case law and the status-based concept of vulnerability. So we are vulnerable because we are minors, because we are of the particular health, and so far and so on. Unless right now we are facing, in this entire discussion over digital vulnerability, I think a much more situation-based approach. And to what extent you think it calls also for reframing the average consumer concept, and to what extent we can leave the average consumer where it stands and simply think about more granular protective instruments and protective standards for the digital market, digital context. So this is my question. Thank you so much.
More questions or remarks? If not, I will add two questions from my side. One to, first of all, to Anna. Thank you to UniDroit that you have presented, to yourself, that you have presented the new technologies as enablers, not only as a danger and risk, as we as Europeans, and particularly as Germans, are used to see the thing, but enabler. However, the legal answer you present, isn't it a little bit old-fashioned of the 19th century? Or maybe a more modern US answer that means only dealing with the traditional private law concept without taking into account the side effects of progress, the need of protection or of care for some side effects. You will give it to the other participants, maybe some states, but shouldn't it be included in a modern private law concept? And my question to Evelyn Braun, how far would you recommend to adopt, to, let's say, to transfer the UniDroit definitions and general ideas into the European Union legislation? I think it should be useful to have some international definitions and to refer on the European level to this international level on the one hand, and on the other hand, maybe you have the problem I have mentioned, that these definitions and rules are not the protective European way, but more the US way. Now we will, if there are no more questions, we will answer all the questions going around the table, and every one of the speakers can also give some additional remarks, final statements, whenever she wants. Do you want to start?
Thank you very much. Sure. Thank you very much, Chair, and thank you for the questions that have been put. Maybe to the first speaker, your first question was, what exactly would be digital vulnerability? Do we look at the original definitions or we go further? My personal reaction would be to go further, because the original definition, of course, came from a specific context. And as we're seeing the new developments in the economy, we're seeing new kinds of vulnerability comes up, and also new ways of dealing with these vulnerabilities. So I would say that the scope is a little bigger. It touches a bit on the second question, on the matter of whether it's status-based or it's not status-based. And I think there, the matter really is the application of these sort of technologies and how it would work. And then to see the lacunae that would give us the vulnerabilities there. So that's the first thing. The second question is whether law is too slow, and whether we needed a quick way of getting things done. And here, I think I speak just from my own personal, so the caveat is I'm not speaking for this question on behalf of my organization. I've had many years of experience, in particular dealing with legal frameworks for high technology fields. So the one that I'm most familiar with is in outer space, and the Outer Space Treaty was concluded in 1967, 10 years after the very first artificial satellite. It's still valid today, and it still has 100-odd contracting parties. Now, what we found simply is that the convention having framework principles, so things that we agree on, that humanity would like for that technology, is important. And then the soft law rules that come after are quick to adapt. So the model laws and the legislative guidance and all that kind of stuff, that's much easier to help there. And that's why partially, one of the good reasons, but very good reasons, that the work of our sister organization, UniDroit, is excellent on this point. Because it really does help to have those kinds of principles and model laws and legislative guidance to move that quicker. So I think perhaps the law might be slow, but maybe not so. Now, you also had specific questions in relation to who's going to do this and what to do that. It's interesting, I don't know if you probably are better aware than I am, there are now startups actually offering services to governments on algorithmic law. So having these sorts of algorithms that write the laws for us, and so they design, let's go back to your third and fourth question, they do go back to the technology and how it's designed already in the laws and how that would basically apply across to machine, machine learning, and machine to business type situations. We haven't touched consumers yet because of the human rights involved in there and what will happen there. So I think that's the answer to your 5 questions. On the second questioner, the matter of the average consumer, that's exactly what the HCCH does. So our work really does do business to business, but we really go directly to the individual. So it's really the protection of the specific vulnerable adult. It's really the specific international commercial contract, and that's what the Hague Conference tries to do. We're pretty proud of it because what we try and do is to make sure that the procedures work. Without procedure, there is no natural justice, not the way we understand it as humans. Maybe a different species will have a different idea of it. But we need procedures and processes to ensure that we have proper access to justice. And I think access to justice is great. It does help with the SDGs, especially 16. But we also have then the knock-on effects of, for example, no poverty in SDG 1, access to capital and finance. How do we do that? By putting those frameworks and structures in place. And that's exactly what my organization strives to do. The European Union and the Commission does excellent work in terms of getting a framework together, but my organization tries to see how that relationship would work from Europe, extra-European, as well as, of course, the rest of the world that is not European. And hopefully there we touch then the lives of each individual, each business, whether it's an MSME or an MNC, doesn't matter really, but really each business and each transaction. And that's what we're focused at. So I hope that answers your question. The chair mercifully had no questions for me. Thank you.
Teresa?
Thank you very much, Cristina, Professor Ponchibó. Thank you very much for your questions. 2 points that I would like to add to Jerry's comment. In my opinion, the potential of digital vulnerability as a concept that can really stir up a new debate, breaking of the mold and thinking outside the traditional paradigm is to consider this concept as an all-embracing concept, different from the traditional vulnerability, classical vulnerability approach. I think this is the power of this concept, definitely. About Mateusz, thank you very much for your comment about average consumer. I think that we are in an optimal moment to rethink profoundly many components of our legislation, in particular the consumer protection. First, this idea of standards, having a standard of the average consumer and try to figure out how rules should be in relation to a standardized and completely unrealistic, inevitably, concept of average consumer. The second point that you mentioned as well, thinking of more granular application of the law that is exactly the opposite of a standardized concept and a standardized reality. And that should be linked to another beautiful project that we have been indeed involved, the personalization of the law. So how to combine more personalized law to accommodate more effectively a personalized reality. So we use technology to personalize to the maximum extent possible, but however the law is still standard, is still based on average and paradigm that they are not reflecting the reality. So I think that we are in this beautiful moment of making a revolution in the concept. Thank you.
Okay, thank you. We have the next topic, personalized law on the table. Anna?
Thank you very much, Rainer, in particular, for your provocative but to the spot comment and question. And I would like to say two things regarding that. First of all, I think that I think what Cristina said was particularly important. We are now talking generally about technology, new technology and vulnerability, but the way you decline the approach to vulnerability, especially in a global area such as the one which is approached by UNIDROIT and the HCCH and UNCITRAL, is actually we should look at the different sectors and what is the scope of the project. So in the case of the UNIDROIT project on digital assets and private law, actually it's a very limited scope which deals particularly with clarifying some issues on how to have rights in these assets because they are new, how to transfer, or, this is also a word which is loaded, but it's explained in the principles because it is declined in a different way when you have a digital asset, whether these rights also survive situations of crisis, what is the applicable law, and so on. So in this respect, it is almost obvious that there are a lot of issues which are not treated, but I think, in a way, if I may say, the beauty of this set of principles are the comments. Because in the comments you have hints to governments on where they could go, and those hints were not, we could not go further, but in the future one can build on them. And we were comforted in developing this by the fact that not only governmental experts participated, and we had a lot of them, not only for common law jurisdictions, but a lot of other jurisdictions, but also, for example, in respect to Europe, the central bank and the European Banking Authority. So those were the actors that were particularly interested, and they are very much into protection, and therefore that was okay for them because it's at a global level. And second point you made, and I will be very quick on that, is but actually if I look at the example you gave to us, this custody issue, for example, you are using very old methods to protect you know, the client and weaker parties. And my answer is, in this case, yes, in a way. So I think in this project, one of the questions could be to what extent mechanisms which were already used in some areas where a lot of thought was given to this blurred divide when you have a weak participant like financial markets. Can we translate this into this new reality? But in order to do so, we have to know very well how this reality works and what terminology we should use. And this is probably one of the, let's say, benefits of the project. But there are other projects where we have to be a little bit more innovative, like, for example, the enforcement project, and there everything that Teresa said about automation of procedures for enforcement. Can we stop them at a certain point because there is an opposition, there is a problem? We are now still working on these things, and they are actually go completely in line with what has been said by my colleagues and what will be discussed in this project. So thank you very much.
Thank you. And last word to the European Commission.
Yes, thank you so much. Indeed, a lot has already been said, and I agree with a lot what was said. I'll just comment on a couple of points which I think relate maybe most to also the same questions that the Commission is asking itself right now. First of all, about the definition of vulnerability, at least for the purposes of the conference and the project, I think we're going to have to go with a very broad definition. Probably each speaker has their own version, idea of what it encompasses. For my purposes at least, I also take the view that it's something broader, but it's still connected to the person, to a consumer. So their sort of abilities, as opposed to vulnerabilities in code or beyond, which are all also very relevant factors. Now, as for the connected question on what about the average consumer and how do all of these relate, I do see there a danger of focusing a lot on the concept of vulnerability and going as far as to say, well, we're all vulnerable. This has also the risk of watering down potentially the protection that was purposefully owed to some of the vulnerable groups, like children, like persons with disabilities. So indeed, we have to find a balance and think about what is the most effective way of operationalizing this concept. And that's why I gave the example of, instead of thinking about these definitions, let's think about the reversal of the burden of proof or concrete prohibitions of some dark patterns, or really tackling very pragmatically the actual practices that are at stake. And looking at what has come out from the Commission in the last years, I think it's always been a very pragmatic approach. It's always regulating a specific technology with very concrete rules. It's very rare that you will see more abstract concepts beyond the explanatory memorandum to describe the broader policy context. So let's see what will be the actual outcome of the fitness check and how our thinking will evolve, but certainly we're aware of all of these different elements, and indeed it may be that the average consumer can be a bigger focal point even than the vulnerable consumer. Now, as for the question of Professor Schulze, insofar how could we transpose or add some of these different projects and guidelines into European law. Well, in fact, there's a lot of work already ongoing. I mean, I'm only opening a little bit the side of EU consumer law and platform regulation and AI regulation, but there's a lot going on. In the area of digital assets, of course, we saw the MiCA regulation recently adopted. In the area of consumer credit, there are also negotiations completed on two very important instruments, namely the Consumer Credit Directive revision, the Distance Marketing of Financial Services Directive, which will be incorporated into the Consumer Rights Directive, and many, many other elements. So there are different Commission departments working on different facets of all of these issues at the same time. And that's not to say that we work in silos, but the issues are extremely complex and deserve indeed a dedicated treatment. And so let's see what will be the outcome of all of these different initiatives. And there will be a new commission coming, as I mentioned already, in 2025. So a new commission is new files. So you can expect to see some of these topics, which so far, and I think algorithmic contracting probably is a prime example, which have not yet received a full dedication in EU law, could be potential topics of interest for the next Commission mandate. So I'm going to stop there, but thank you so much for the great questions and great discussions.
I am very happy that we started our meeting with such a fruitful, inspiring, and rich first section. Many thanks to all the speakers on the panel and to all the speakers in the hall and to everyone who gave us his attention. I think after this hard work we have done, we have got the right to get a break, and even also the time is a little bit advanced. We should enjoy a 20-minute break. However, a group, this is only, I see, not necessary for all speakers, to the speaker. Okay, only this group. All. Okay, furthermore, I was informed that the speakers of all panels, or the following ones, and of this panel, should come to the outside of the aula at the bottom, the room at the left, for a group picture. Please don't forget to come there before taking your coffee, and then we will all have our coffee. Thank you very much.
Sind Sie aus Hamburg?
Ich bin aus Hamburg, ja. Du auch? Hast du Hamburg besucht?
Natürlich, einmal oder viermal. Ich habe in Tübingen promoviert.
Ah, okay, fein.
Max-Planck-Institut.
Max-Planck-Institut, ja. Mit welchem Thema hast du promoviert?
Also ich bin Zivilrecht.
Zivilrecht.
Ja, allgemein.
Also ganz klassisch.
Genau, ich habe über das Stellvertretungsrecht gearbeitet.
War eine Vergleichung mit Korean Law?
Teilweise.
Teilweise.
Also im Max-Planck-Institut von Hamburg arbeiten viele Asiaten, oder? Ich habe von vielen Asiaten gehört.
Als Gäste.
Als Gäste.
Also wir haben derzeit eine Kollegin aus China, die Doktorarbeit von Japan, also das ist ein Zentrum für japanisches Recht. Wir haben keine permanente Wissenschaftlerinnen oder Wissenschaftler aus Japan.
Nur als Gast.
Nur als Gast, als Gäste, ja. Researcher Guests, ja.
Okay, welcome everybody to our second session. We already heard quite a lot, I learned quite a lot. I introduced myself quite briefly. My name is Herbert Zech. I'm a director at the Weizenbaum Institute for the Network Society. And that's why I'm very interested in this whole topic of digital vulnerability, although I'm rather an IP lawyer and a liability lawyer, but we already had some liability law and IP law aspects, so I'm very, I pay a lot of attention to what I can learn today. I think we will now delve further into the concept of digital vulnerability itself. So what is it? What are cases where the problems with digital vulnerability happen? And as you can see, we are supposed to start with a talk by Cheng Li. There are, I gather, technical problems, so he will present via Zoom. Probably we can take him later, and we will start with the next speakers, if that's okay for you. And it's a great pleasure to introduce you to our two Korean speakers. The first one will be Byung-Yun Lee from the Korea University at Seoul, very eminent expert in the field of consumer protection law. You will talk about the protection of vulnerables in online marketplaces. You are, I gather, at the moment also head of the law research, just a second, of the Korean Commission for the Reform of the Consumer Protection Act for e-commerce. So you're really in a perfect position to explain us in more detail what vulnerability in online marketplaces means. And with that, I hand over the floor to you. Thank you.
Thank you for the kind invitation. Thank you for inviting me to this important conference in Ferrara. It is a great pleasure and privilege for me to speak at this event. In my short presentation, I will introduce a very narrow case, but an important case, I think. I will explore the challenges faced by blind persons in e-commerce, discuss the strategies that can be employed to promote their rights and interests in online marketplaces, make an overview of relevant laws and regulations in Korea, and highlight the court case in Korea related to accessibility on online marketplaces. Sorry, I didn't translate it in English. You read it in Korean. It is a very beautiful alphabet. I will briefly explain the current status of e-commerce in Korea. According to the report in 2022, Korea ranked 5th in global e-commerce retail sales share with 2.5%. The domestic e-commerce market share in 2022 was 70% for Naver, 50% for Souq, and 13% for Coupang, 6% for 11th Street, and so on. Unlike Europe, South Korea and American platforms dominate the Korean online market. In the case of online shopping, Korean companies are the main ones, and the open market is considered one of the most competitive markets in the online world. Naver, the biggest shopping mall, which has added a product sales function on its biggest online platform in Korea. Souq, a traditional shopping powerhouse, and Coupang, which has established a nationwide delivery system, are ranked first, second, and third. Perhaps the most common scene that comes to mind when it comes to vulnerability using digital products or assets in South Korea is when you place an order at a fast food restaurant or coffee shop. In the picture you see, the old man is struggling with the old woman because he can't order properly. In the next picture, the old woman has been buying for so long that the young people are screaming in the background. In the recent years, online marketplaces have become increasingly proper for consumers who prefer to shop online. However, these platforms can pose challenges to individuals with visual impairments or blindness who may have difficulty navigating and using these websites. I think in this case of e-commerce, blind persons are the most vulnerable. Blind persons face several challenges when accessing online marketplaces. One of the major obstacles is the lack of accessibility features that cater to their needs. Blind persons must rely on assistive technology such as screen readers to access digital content, but the technology can only be effective if the content is designed to be compatible. Screen readers function by scanning the text on the web page and converting it into synthesized speech, but they may encounter obstacles when the page is poorly designed or has formatting issues. In such case, it becomes difficult for blind persons to comprehend the content or make informed purchasing decisions. To improve accessibility for blind persons in online marketplaces, several strategies can be employed. These strategies include incorporating accessibility features, presenting information in alternative formats, providing personalized assistance, and implementing legal protections. Online marketplaces can incorporate accessibility features that cater to the needs of blind persons. Such features include text-to-speech, audio descriptions, high contrast modes, and keyboard shortcuts. Blind persons may require information presented in audio or other formats to access digital content. Online marketplaces can provide personalized assistance to blind persons to help them navigate the platform, conduct transactions, and resolve disputes. This can include signing or dedicated support staff, or providing access to virtual assistants. Regulations and legal protections can be implemented to promote the rights and interests of blind persons in online marketplaces. This can include anti-discrimination laws, accessibility standards, or consumer protection regulation to help prevent potential misunderstandings. Korea is also providing legal support in similar way. In order to help you understand the EMAT or SIG case, I will briefly introduce the relevant laws and regulations below. The Disability Discrimination Law Act of Korea has been established in order to prohibit the discrimination on the basis of disability and provide disabled persons proper remedies. The Act defines the concept of disability, disabled persons, and disability discrimination, and prohibits discriminatory practice in various areas such as employment, education, and provision of goods and services, etc. A discriminatory act prohibited under this act are treating persons with disabilities unfavorably without justifiable grounds. Second, applying disability blind standards that cause persons with disability to be unfairly treated. Third, refusing to provide reasonable accommodation to persons with disabilities. The cases for justifiable grounds are, first, refraining from a discriminatory act might incur an excessive burden or undue hardship. Second, discriminatory acts are inevitable due to the nature of particular duties or business operations. The remedies authorized under this act are compensation for damages, and second, order appropriate interim measures such as discontinuation of the discriminatory act. There are special regulations on prohibition of discrimination in access to information for persons with disabilities. Article 20 prohibits discrimination against persons with disabilities when they use and gain access to electronic and non-electronic information. Accordingly, Article 21 stipulates a duty to provide reasonable accommodation in information and communications. The concrete criteria for determining accessibility of websites is regulated in a notification of the Ministry of Science and ICT, and the Korea Web Content Accessibility Guideline 2.1 says, in order to guarantee web accessibility for visually impaired, alternative text should be provided for non-text contents such as images so that they can recognize their meaning or use. Finally, let's take a brief look at the EMAT case. In the year of 2070, visually impaired people filed a lawsuit against EMAT or SIG, that it was the second largest online shopping mall in Korea, that they were experiencing difficulties in purchase because they were unable to do so, and that this was an act of discriminatory conduct prohibited by the Anti-Discrimination Act. As a result of this lawsuit, the Seoul Central District Court made a partial ruling to pay 100,000 won, this is about 70 euros, each to the visually impaired. In addition, within 6 months from the date of finalization of the ruling, it was ordered to provide services through which online shopping malls can receive shopping information, such as product advertisements and detailed information to visually impaired people through screen readers. This is only the result of the first instance, and I read in the newspaper in the airplane that the second institution in Korea said they denied the liability of damages on ground there was no negligence of the web page. However, the lawsuit is still ongoing, and the Supreme Court makes many consumer-friendly decisions, so it is expected that the result of the second trial will be different. The third trial will be different. This ruling is interesting in Korea because there are not many cases in Korea where the weak are fully protected as the result of the first trial court. Korea is a country that cares more about business operators. However, in Korea, those who are seen as the weakest seem to be protected to some extent through national means, through traditional means. We need until now, no new regulation. In Korea, protection of digital vulnerables is still a major issue, and the concept of digital vulnerability in general has not been yet discussed. However, I believe that the next topic, dark patterns, will be moderated by the next speaker, could be the start of this discussion. Thank you for your attention.
Thank you very much for that interesting contribution. Topic I haven't thought about previously, but yeah, we shall start the discussion all in one package after all the presentations. So you already introduced our next speaker, so to say, Shindong Jung, who worked on the attribution of knowledge and is also an expert in consumer protection law. And you will now introduce us in more detail to the concept of dark patterns. Just a second. Thank you very much. Okay, the floor is yours.
Personally, it's a great honor to present at this University of Ferrara in Italy. Actually, it's my first time to visit Italy. So first of all, I would like to say thank you very much, and thanks to the organizers, especially Professor De Franceschi, for inviting me and for giving the opportunity to speak about digital vulnerability and online dark patterns. I addressed this problem, this topic, in 4 quick steps. First, a few words on the rise of digital platform economy and problem about online dark pattern. And I will then turn to the question how or why regulations on dark patterns is needed, especially in relation to digital vulnerability. In third step, I would like to show the legal framework which can be applied to the dark patterns problem in South Korea. And finally, I would like to introduce the discussion on the revision of Korean E-Commerce Act regarding dark patterns in Korean National Assembly. And I want to emphasize the importance of self-regulation in this matter. The recent rise of online platform has again triggered the debates whether the regulatory framework has to be adjusted in order to adequately reflect the changing market structure. In this context, the so-called online dark patterns problem is very often discussed. There is a mounting concern about dark pattern on online user interface of platforms that materially distorts or impair the ability of consumers to make autonomous, free, and informed choice or decisions. This is closely related to today's main topics, digital vulnerability. And for example, it's very easier to allow cookies, to allow collection of behavioral information on the website that denying them. In addition, a certain discount product is only available within 5 minutes. Such message, people who use, for example, hotel reservations platform on the internet often see such message. However, if same discount product is still available to consumer after 5 minutes, then we can say that dark patterns has been used by platform operator. Another example of dark patterns is to make it difficult, more difficult to terminate an online subscription service than signing up for a service, and finally to give up the possibility of contract termination. Actually, online dark pattern is an umbrella terminology referring to a wide variety of practices found in online user interface that leads consumers to make a choice that often are not in their best interest. Yeah. Now I'd like to turn to the question why regulation on dark pattern is needed. Yeah. Many dark patterns influence consumers by exploiting cognitive and behavioral bias and heuristic. For example, default bias, the scarcity heuristic, social proof bias, or framing effects. Actually, the effects and mechanism of such dark patterns are not limited to the digital environment. Such effects, such mechanisms are also utilized in the offline environment. So, their opinion that online dark patterns are not a big problem and there is no need for special regulation. For example, this discount product is only available within 5 minutes. Such message, we often hear this message in offline supermarket or in convenience store. This also means it can be very difficult to distinguish between aggressive legal marketing, but legal marketing and illegal dark patterns. However, the needs for dark patterns to be regulated can be explained for a variety of reasons. First, this online dark pattern can cause large-scale consumer damage, so massive consumer damage compared to offline transaction. In the case of offline transaction, for example, it can affect some consumers in the supermarket, in convenience store. However, in the digital economy, the large group of consumers who access websites can be affected at the same time. So in this context, I want to say there is a structural consumers problem. And second, in the digital economy, the effects on distorting consumer decision-making is much stronger than in the offline environments. In addition, it is very difficult for consumers themselves to recognize that they have been influenced by dark patterns and that information-based autonomous decision-making has been distorted. Making consumer click quickly without looking at all elements in the small monitor or mobile phone screen one by one in the digital economy is very easy. Hence, it is difficult for consumers to recognize such disadvantaged online user interface. This is why digital vulnerability should be considered in this problem of dark patterns. Third, the online user interface can be changed in very short time and at very little cost. This makes it easy to test the optimal dark patterns on environments with little time and with little effort. This is also different from offline transaction. And this characteristic provides online business operators the best environments for easy access to consumers' bias and consumers' heuristics. Finally, it should be noticed that so-called tracking dark patterns or targeting dark patterns are possible for individual consumers. Consumers' online behavioral information can be used for personalized dark patterns, and in this case, minors should be especially protected. Distorting choice and decision by use of vulnerability of individual consumers, this is also different from offline transaction. And on other hands, there is an opinion that the dark patterns problem can be solved through the exercise of consumer withdrawal rights. Once a consumer exercises his right of withdrawal and return the products or goods purchased under the influence of dark patterns, then it may also be considered that consumer is fully protected. So someone can say there is no significant problem regarding dark pattern, but as already said, in many cases, in my opinion, in most cases, consumers don't recognize that they are affected by online dark patterns. And even if consumers know they're affected by dark patterns, it's very hard, it's very difficult to expect a consumer exercise of withdrawal rights, especially in small daily transaction. It's also called the question of rational indifference of consumers. So therefore, it is important to prevent online platform operator from using online dark patterns. Of course, this issue is not a sudden problem. There have already been many similar problems in the past, and most countries have regulation that prohibit deceptive commercial practice. The Korean E-commerce Act also has explicit regulation that prohibits such deceptive commercial practices. For example, according to Article 21 of Korean E-commerce Act, an e-commerce operator should not attract consumers by using deceptive methods. Because of very general and very abstract nature characteristic of this provision, about 70% or 80% of dark patterns problem can already be solved in Korea. For example, dark patterns of hidden advertising. This is solved by the general provision that I mentioned without difficulty. For example, just last week, a Korean big tech company, Naver, was intensively covered in the media and the newspapers because some advertisements by artificial intelligence could be dark patterns. So the Korean Fair Trade Commission has begun an investigation So in this case, my son got a first grade in mathematics, was posted in social network service websites, which could be misunderstands that a mother or father left the post who was worried about her or his child's mathematics grade. But this comment is actually advertisements of a private academy. Yeah. Such case is easily solved by applying Article 21 of the Korean E-Commerce Act, because deceptive commercial practice is prohibited in principle. However, regarding the question of how to solve the remaining 20% or 30% of dark patterns problem, an amending revision of the E-Commerce Act is currently discussed in Korea. This is also called a phenomenon of new dark patterns in Korea. Such regulation, such legislative necessity was also confirmed in a survey. According to survey conducted by Korea Fair Trade Commission just last year, more than 70% of Korean citizens say new legislation is needed to supplement to the regulation. And as new dark patterns with such legislative needs, the following are mentioned in Korea. First, giving more prominence to certain choices when asking the consumer for a decision. And second, repeatedly requesting that the consumer make a choice where the choice has already been made, especially by pop-up window. And third, making the procedure for terminating a service more difficult than subscribing to it. Maybe it's interesting for you, for European citizens, because these three types of dark patterns are also provided as main example of dark pattern in Digital Service Act in EU. So this is the proposal for amending of E-Commerce Act. Yeah. So Article 21B provides the following. The e-commerce operator shall not perform any of the following practice in operating an online interface. Online interface is defined here as a medium between consumers and e-commerce operator, as software such as website or mobile application. And so first, this is related in giving more prominence certain choices. So for example, it prohibits the practice that may lead consumers to misunderstand as if they can select only certain options. And second, this is related to pop-up windows. The third is pop-up window. And second is related to making the procedure for terminating service more difficult than subscribing to it. The characteristic of this provision in proposal can be described as following. First, the provision lists a limited number of types of dark patterns that are prohibited. In other words, it is not a general provision that prohibits dark patterns. It's different from European Union. If the general provision of prohibition is introduced, then Korea could flexibly regulate various types of new dark patterns. In this context, the general prohibition definitely has great advantages. Yeah. However, in Korea, there was opposition on the part of online platform operators to provide abstract and general prohibition regarding online user interface design. According to this opinion, if the act is revised, then many companies will lose their user interface UI diversity and use only unified monitor design. So therefore, Korea, the authority decided to prohibit only a few specific dark patterns as a first step. Yeah. In addition, only sanctions according to public law are provided as legal effects in case of violation, and the consequences according to private law are not provided. Therefore, compensation for damage under the general civil law is possible, but e-commerce acts as a special law does not provide the aspects of private law. Yeah. So, because there are doubts about function of consumer private law related to dark patterns. First, we can say it is difficult to prove the damage. There is difficulty in assessing damage, especially in small daily transactions. And in Korea, the representative actions related to compensation for damage or class action, American class action are not approved. Yeah. And even if the consumer law prohibits the use of dark patterns, so-called self-regulations of traders can play an important role. This is because self-regulation can prevent the use of dark patterns by business operators themselves most efficiently. Government authorities are unable to monitor all of the operator dark patterns used. If business operator comply with self-standard for consumer protection in design online user interface, then the problem of dark pattern could be solved without applicable sanction in criminal law, and administrative law, or in private law. So currently in Korea, communication between authorities and business organizations regarding dark patterns, there is going on, and the possibility of self-regulation are being discussed. Actually, personally, I'm not satisfied yet, but I'm looking forward to the success of the self-regulation regarding this problem in Korea. And also personally, I'm interested in how the issue of dark pattern in the European Union is discussed and how European consumer law will be enforced. Yeah. In this context, I'm looking forward to the exchange of experience between Europe and Korea in this field. Thank you very much for your attention.
Thank you very much. So, do we have... No. Okay, so we proceed with our next speaker, Mateusz Gruchowski from the Hamburg Max Planck Institute. And you talk about the paradigms of digital vulnerability in a post-consumer society. The floor is yours.
Yes, indeed. So until my presentation is on, just a few words of gratitude, first of all, for the invite to this conference. I'm extremely happy, extremely honored to be here. And I think also regarding the topic of this conference and how somehow targeted our presentations are, it is a great pleasure to listen to all the papers and interventions. Secondly, I'm also very grateful to the organizers for accommodating me in the second panel today, because after lunch, unfortunately, I will have to leave for another conference in Berlin tomorrow. But still, I'm very happy we managed to organize it in the feasible way. And now, coming to the digital vulnerability in a post-consumer society. My paper is not, or is not yet, a paper with which I aspire to set forth any normative political proposals for the reform of consumer law or rethinking of consumer law, maybe to some extent. But what I'm primarily trying to do in this paper is to observe a market phenomenon and a legal phenomenon to some extent, which I think may give us some very insightful perspective on what is consumer vulnerability nowadays on the digital market, and to what extent the accounts of consumer vulnerability we have right now in our discourse about vulnerability, about consumer concept, average consumer, and so far and so on, are a little bit over-limited regarding how consumers act on the market nowadays, what are the consumer interests, what is the consumer harm. And to start with, probably the most puzzling part of my title for you might be what is the post-consumer society. And here I'm using as a working definition, the definition given by Frank Trentman in his seminal book. You probably all know, The Empire of Things, which is like the Bible of the consumer, of the history of consumer society, of consumerism in Europe and globally. And he gives a definition of post-consumer society as the society where there is a growing interest in experiences, emotions, and services, a revival of repairing, and the spread of leasing initiatives and sharing networks enabled by the internet. Probably many of the elements of this definition are quite familiar to you because we are all working in consumer law. We are constantly facing both the digital aspects and all the sustainability, environmental protection aspects of various evolutions that consumer patterns, consumption patterns are undergoing nowadays. But for the sake of this presentation, I would like to focus only on the first element of this definition, so of the post-consumer society as the society where consumers are much more interested in obtaining some experiences, emotions, building some social relations, and so far, rather than in acquiring goods and services such. And why does it matter? Because, again, as you probably all know, and it's a very trivial thing to say in this room, European consumer law has been conceived, has been created, conceptualized as the law of the welfare state sometime like in 1960s, 1970s, upon the German order liberalism, the rise of the welfare state idea in the Western Europe, and so on. And at the outset, this concept was very much concerned with the economic dimension, like purely economic dimension of consumer participation in the market. Why? Because this is how the consumption looked like at that time. Remember, it was the post-Second World War society with the mass consumption, with consumers who were very much interested in acquiring tangible goods like cars, new electronic piece of equipment like early TVs, radios, and so far, rather than in pursuing some non-economic interest on the market. And consequently, the whole conceptual framework of consumer law we have right now has been organized around the economic ideas. So first of all, consumer interest, understood as economic interest. So interest, first of all, in being properly informed, in not experiencing the information asymmetry on the market. And secondly, not experiencing the asymmetry, not experiencing the bargaining power asymmetry or the consequence of this asymmetry. In what regard? In the regard of the economic decisions we make about acquiring certain services, certain goods on the market. And to point out it even again, we are talking here about the services, goods, where we can easily quantify or easily determine the economic value of them. And consequently, also the concept of consumer harm that had been transplanted or strongly inspired by competition law has also a purely or almost entirely economic dimension, so it's understood as a situation where a consumer participation in the market is limited, where consumers are experiencing some structural problems, structural struggles on the market. And now, when we think about the current discourse about the digital vulnerability, and of course this diagram is a little bit schematic, it's a little bit superficial, but I was trying to at least summarize the main threads of the discussion about digital vulnerability, where in the present-day discourses in the EU, but also in the US, the vulnerability of consumers on the digital market is mostly related to contract-related vulnerabilities. So the way how consumers may be manipulated, how the dark patterns may affect consumer choices, and so on. Secondly, also new types of goods, so digital content, new types of threats related to them. We all know about it. And then the data-related vulnerability. So first of all, how the data is being collected. So this entire idea of surveillance capitalism, data capitalism, we also know about. And the algorithmic decision-making, so personalization, ad personalization, price personalization, and so far. And in the post-consumer society, or in the consumer society where we have some patterns of this post-consumptive behavior, we are approaching a different set of phenomena that the existing framework of consumer law in Europe, but also in the other parts of the world, is not very well equipped to address. So first of all, consumers are acting in the environment where certain elements that previously were completely out of the market are becoming massively commodified. And it's not only about data. We all know about commodification of data, about data as the counter-performance, but it's also about emotions, experiences, social interactions. Think about some like everyday examples, Facebook, TikTok, Instagram. What those platforms are doing, they are delivering certain services to consumers. Services in the form of certain IT architecture, which allows consumers to enter the platform to build social relations, social interactions with the other users of the platform. But of course, it's not only about social media, but social media perhaps is the most vivid, the most conspicuous example of such practices nowadays. Also, consumer attention is being commodified everywhere on the internet. In a consequence, consumer interest can be harmed in many different ways than it used to be harmed in this like classical consumptive world where it was the economic interest only or primarily that was in the scope of interest of consumers. So for sure, consumers can be harmed in terms of their psychological dimension, psychological way of functioning in the market community or in the society. Again, we all know about, for example, Facebook papers, the Facebook leak, which clearly indicated that certain groups of consumers on the Meta platforms, on Facebook, Instagram, are being systematically harmed in order to, with regard to the self-esteem, self-appreciation that those platforms are creating for them. Secondly, something I call, and this is the term coined by my friend from New York, by Sarah Dadouche, identity harm. So consumers who take part in the present-day market society are very deeply interested in also expressing themselves, in pursuing certain political, moral, ethical, whatever else values by the market choices they make, and also by the communication they produce and share with the others online on the platforms such as Facebook and Twitter and so far. And now, what the consumer can do about it. So here on the slide, you can see just two examples of how this looks like nowadays. And those examples are quite early, so we are still at the very beginning of our way in understanding what it means for consumer law. But these are 4 decisions, like 2 pairs of decisions of Bundesgerichtshof, of the German Supreme Court, which all tackled upon the Facebook user agreement, and they all applied the 9313 directive, so the Unfair Contract Terms Directive, in order to review the terms of service of Facebook in 2 regards. So the first pair of decisions found unfair Facebook user agreement's terms that are awarding, are granting Facebook arbitrary power to fully, without any constraints, without any user intervention as well, moderate the speech on the platform. So for example, to remove certain posts or to suspend somebody's account. And the second pair was concerned with the use of nicknames. And again, the question was whether I can present myself as Mateusz Grochowski on Facebook, and is it the only way? Or can I also present myself as Mickey Mouse, for example, or as Alberto De Franceschi and use some fake nickname? And again, Bundesgerichtshof said such provisions in the user agreement are unfair. And why? Because what the Bundesgerichtshof said is that those provisions are infringing freedom of speech, which also, amongst other dimensions of this right, should be considered as the market value, which should be effective horizontally in the relation between Facebook and its user. In other terms, Unfair Contract Terms Directive was used here as a gateway to introduce certain fundamental rights into the user platform agreement. And of course, what we need here, and Bundesgerichtshof was not very much concerned with this aspect, but it's somehow implied in those decisions. What we need here is the acknowledgement that what Facebook is providing to users is a consumer service. That it is a consumer agreement where certain goods or services are traded between the supplier and the consumer. And in the earlier decision of the higher land court, regional court, I don't know what's the best translation into English, Oberlandesgericht Munich of 2019, there was clearly, explicitly a mention of the Facebook services that are rendered to consumers under the platform user agreement. And now, coming back to my previous diagram, we can a little bit reframe how else we can consider digital vulnerability. And here I gave you, again, a very sketchy, let's say, summary or overview of how the digital vulnerability in the post-consumer society may be understood or how it may arise. So first of all, these are all the threats related to consumer personality. So to the way how consumers are acting in some online social interactions, for example, online platforms, all the issues related to defamation, related to personality rights infringements, also related to the way how we as consumers can use services provided to us by platforms in order to express our own identity, our political views, our social views, our religious beliefs, whatever else we want. And then the quality of services, because of course, if it's a consumer service, consumers may have certain expectations regarding the quality of those services. Let's say, the standard of how those services should look like, not only in terms of the economic dimension, of course, but also in terms of to what extent consumers can follow those personality-related values. So, for example, to what extent platform can or cannot exercise private power over platform users. To what extent, I don't know, the platform may tolerate fake news or may tolerate some hate speech. So to what extent consumers may or may not expect that platform such as Facebook or TikTok or Twitter will be a safe speech environment where consumers will be able to feel secure. However, when we look into the framework of European consumer law or European law in general, we can see a growing split. And this split became particularly vivid on the grounds of the Digital Services Act. Because Digital Services Act, as you know, is upfrontly not a piece of consumer legislation. So DSA is trying to do a lot to deny that it is a consumer legislation. It's trying to be a regulation on its own terms, so to say. And as you can see in the Recital 10 of the regulation, we are having a very clear, I would say, exclusion. We have this formula, it will not preclude, it will be without prejudice, but it is in fact an exclusion of application of the consumer law acts to the matters that are regulated by the DSA. Of course, it makes sense for the sake of clarity, for the sake of some legislative purity of this structure. But at the same time, it seems that European law right now is missing the fact that platform economy is also a consumer economy. So we must have more bridges than gaps, more places where we try to find some common denominators for regulation of platforms, regulation of speech, regulation of information online, and the classical consumer concepts, classical toolbox of consumer protection. What seems to be the way forward, at least as we have the European Union right now in its current shape, is that in the course of time we'll see more and more gaps in the current system, because on the one hand we'll have DSA, on the other hand we'll have the classical consumer law, and many overlaps, but also many places, many situations, many types of interest that will be covered by neither one nor the other act or regime. And the German case law, I think it's a very good illustration that some general clauses and some open-ended standards of European consumer law may act as gap fillers. So they may be used in order to provide protection, in particular the individual protection to consumers, in the areas where both the DSA and the more specific consumer law acts are turning out to come short. Secondly, of course, in order to better grasp the specificity of those new consumption patterns online, we have to rethink or reconsider some of the basic concepts in consumer law we have right now. Apart from vulnerability and weakness, also consumer interest, transparency, consumer harm. As we could see, the German courts were trying, at least in this semi-explicit, semi-implicit way, to do. And finally, it also seems that fundamental rights, in particular the fundamental rights that have a direct take on the online participation of individuals, such as freedom of speech, such as freedom of religion, such as freedom of political views, will be or may become more and more important and may become, to a growing extent, introduced into the platform regulation, into the everyday platform functioning through the general instruments of the European consumer law. So with this in mind, I would like to thank you for your attention. I know it was very introductory, very sketchy, but I will be very happy to hear your more detailed questions. Thank you.
Thank you very much. It seems we still do not have a connection, so we can go directly to our discussion. So the floor is now open for questions and remarks from the audience. And I see one right in the center. Do we have a microphone?
Thank you very much for your wonderful presentations. It was an honor to listen to them. I'm Carolina Guanta, Associate Professor at Utrecht University, and I have a question, I think, for all of you, but perhaps primarily for Mateusz. And we are at a conference dealing with consumer vulnerability. I'm also a consumer scholar. I believe in consumer vulnerability, but I think that we also need to perhaps listen to a voice of a devil's advocate and ask ourselves, what is too much consumer vulnerability? Because if we look at situations with dark patterns, and we also saw the accessibility questions, we still see that there can be differences between the types of harms and also the types of consequences that vulnerability can have. Given the fact that we do not have endless resources to deal with everybody's individual vulnerability in all situations, then the question is, where do we draw the line? We also heard earlier in the morning the question of digital literacy. I think, in my humble opinion, that we got to this place where we do not really know how these platforms exercise power over us because there wasn't enough digital literacy, for instance, in the regulators, perhaps even in research, to understand the implications. So how do we actually create a very concrete concept of vulnerability that we can work with? Thank you.
Who wants to answer first?
Okay, so I think I'm the primary suspect for this question. So I think I completely hear you on your skepticism about vulnerability and as a concept, as some kind of a label or explanatory tool. And I think this is something that was already partly addressed in the discussion after the first panel. So, and I think it was Egeline who said this, that vulnerability is a very generic concept. And I don't think we can, and I also don't think we need to make it as precise as, for example, the average consumer concept or any other general concept we have in consumer law. I think vulnerability is more a sort of a catchphrase we use in order to address various new types of consumer weakness or consumer proclivity, propensity, but not necessarily it is a tool that would carry out any normative or any sort of like concretely legal meaning with it. So this is my sense. And in the same way, by the way, vulnerability functions also in, for example, in the US. So in the US discourse, in the US legal theory, vulnerability is much more a concept used as, again, as a catchphrase to somehow dismantle the neoliberal imaginary in the US regarding the digital market or market in general, rather than to be understood as like a precise technical legal term. It's more this idea that because everybody is in one way or another vulnerable, and in some market context, for example, being consumers, being children, being employees, we may be vulnerable in a situational way, we deserve protection from the public power. So we deserve, let's say, higher care. And I think our discourse in Europe, although we use different conceptual framing, is more or less the same. So I think like from the very outset, the concept of vulnerability, especially since vulnerability became to be revoked somehow, to depart from the Unfair Commercial Practices Directive as such and be understood as a term on its own, we are very much using this term as, again, this general label that, look, there is something wrong in this part of the market or in the other part of the market. Some users are vulnerable. So now let's think what might be the duty of the business party or what might be the duty of the state or of the EU to intervene and to provide some protection in this particular market or social fraction. So, thanks.
Thank you. So should we call it digital harm rather than vulnerability?
Probably, but harm to me carries a slightly different semantical context. So harm is more about something that already happened, that harm was done, that somebody was harmed. And vulnerability is more about some potential harm, so some being prone to certain harm.
Okay, thank you. So the next intervention is by Anna Veneziano, I think. Yeah, here in the first row. Oh, of course, sorry for, yeah. Because your presentation showed us an example of a vulnerable group where we have specific digital risks. Please.
It is a very difficult question, what we must solve through all the seminars they are planned for 3 years, I think. But I would emphasize another point of view, was I think Professor Anna Veneziano mentioned in the photo session that that aspect of emphasize negative features of technology is too much in this concept of digital vulnerability. I think there are also ways to increase consumer equality, to improve positive aspects of technology that can help strengthen the consumer position. That must be built. We now find deceptive patterns from the business side. But we can strengthen and make technologies to strengthen the consumer side, then it may be no more problem. And I think that the excessive patterns of the business side was always there. But there was no, we couldn't find this excessive patterns of business sides because they are not patterned in the platform. But now the platform is patterned in a platform, so we can find it. This is the problem. And I think we must think about how, in what regard we should accept the deceptive patterns of business sides. Because it was already there, and they must sell the same product, sometimes much not cheaper than we call it cheaper, expensive. One was also when that is a new problem we have, that we cannot see, but now we can see these patterns of business sides, and we must think about it, how we regulate it. I think that is my...
Thank you very much, because that was quite intriguing. In your presentation, you mentioned this rule in Article 4, that there is an obligation for reasonable accommodation for visually impaired people. So this is an interesting case where vulnerable groups, traditional vulnerable groups, get a kind of extra protection, and you have an active obligation to provide digital means to take care of these vulnerable groups. So this, I found it quite intriguing. I wonder whether you should call this digital vulnerability or digital measures in connection with vulnerability, but I'm getting ahead of myself. So then, thank you very much. You want to add something? Fine. Anna Venezia.
Thank you very much. I have two quick questions, and one stems from the discussion you just had now. So it's actually more easily understood if you have something like a visually impaired person, and there might be ways to recognize and therefore to apply any remedies if you don't follow this more specific protection. And I was wondering whether in a more general discourse on vulnerability, nuances in who is in the market and participating, especially in view of the fact that there might be different interests that are not necessarily only commercial. How is it possible in the end to really recognize the different situations, and would this be done only then exposed if there is a litigation, and but it's not predictable sometimes from the other side. So this is a little bit of a doubt. And the second question is more general, and perhaps it can be discussed later on in this conference. It's the influence of the supply chain, which I'm sure you are taking into account. So if you only talk about one contract, how can you really ensure that the discussion on the due diligence and all these issues that are now to the fore can actually be accommodated? Because if you cannot have one concept of vulnerability, you apply everything to one contract, and then you cross borders, or you cross the borders of the EU, and there's nothing out there. So thank you.
Who wants to go first? You.
I didn't understand the first question. Can you mention? Shorten
Sorry,
the question.
The first question was this. You very effectively showed that there is legislation in Korea dealing with specific groups of people who might be especially vulnerable because they are, for example, visually impaired. And I was wondering, however, since whether the concept of vulnerability can be nuanced to take into account different degrees and types of vulnerability, for example, an elderly person, or how can actually this be predictable from the side of the offeror, let's say, or the service provider, and or whether this would be a question of ex-post litigation. So it's a little bit trickier, let's say.
Okay. You talked about flexibilities in general clauses, or?
It is a very difficult question, I think, because blind people, we know they are blind people. But we vulnerable people is a very difficult to clarify the people who are vulnerable people. And therefore, I think we talk about we must maybe in sector or in situation go further and look in situation, sectors, and some other criteria. I think normally vulnerable situation in digital wie sagt man, Umgebung, environment doesn't exist now. There's not. We have a circle discuss about wie sagt man, consumer. We have two concepts of consumers, normally. Or consumer who can think right, yeah? And a consumer who is vulnerable. This is already exists, this concept. It is only a new field that comes to the digital environment, I think. These two concepts already exist, but the second concept is rising up with the digital environment, because many people are living in the digital world, and they experience more vulnerable situation or deceptive patterns from platforms. But I think there's not yet or good concept or it built enough to have this concept, I think. Yeah.
So again and again, it emerges that maybe we should really differentiate between vulnerable people and digital technology and average consumers and digital technology. But that's just a remark from an outsider. Anna, please.
Thank you very much. Thank you very much for this presentation, all of them. I only have 2 points to raise at the moment. We can discuss later for many other issues that has been raised. The first one is related to dark patterns. When we discuss dark patterns in Europe, and Egelin has discussed that in her presentation, we try to identify to which extent dark patterns are unfair commercial practices. But when we have dark patterns in automated contracting, and the dark patterns are aimed to manipulate the automated decision making, the virtual assistant, the question that I would like to raise, and if you would like to share your views as well, is to which extent is indeed the same? Are we talking about the same situation? Is the same to carry out or deploy an unfair commercial practice in order to exploit a situation of the consumer? Is that the same to a situation where I manipulate a virtual assistant that is, for example, assisting me in comparing information? So is right to achieve that result? Dark patterns manipulating automated decision-making are unfair commercial practices, even if the rationale behind unfair commercial practice are inevitably linked to the idea of a consumer who is misled, who is in a way interfered in his decision. So that would be the point, if you would like to share your views. And the second point, Mateusz, is for you in particular. It's very thought-provoking, your presentation, and I agree very much with many of the ideas that you are suggesting. And my question is very provoking, I think, as well. Don't you think that when we use the term consumer, and all what everything is this concept entailing, we are in a way perpetuating many of the paradigm and the rationale that consumerist society and not the post-consumerist society is entailing. Because for me, it's difficult, and I don't like indeed to use that term, that when we're using Instagram for the purpose of expressing our opinions, we are not consumer of services provided by Instagram. And definitely, if my personality is affected, it's not a consumer harmed. It's something clearly beyond that. So don't you think that consumer is a concept that is in a way delaying the change of paradigm in consumer law and in protection mechanism? Thank you very much.
Thank you. We can start with the second question.
Well, so it is a provocative question indeed, and I'm not sure I can give you any final answer right now. I've been never thinking about it from this angle, but for sure, as you said, the word consumer conveys lots of implicit meaning and implicit assumptions about, yes, everything you said. I also completely agree that the way how we consume on Instagram, on TikTok, is completely different from like the classical patterns of consumption, but the framework we have right now as it is. So in order to, for example, control the terms of service of Facebook, for instance, we need to either look for the economic elements in the Facebook user relation, or we have to broaden our understanding of consumer harm, consumer interest, and so far. Maybe at some point we'll devise a completely new conceptual framework. I hope it will be a coherent framework, not a framework where we have separate regime for online consumers and separate regime for offline consumers without too many points of overlap or of connection in between, but I hope it is possible. For the time being, I have no idea what it might be. Of course, we can look for other terms. We can think of client, we can think of user instead of consumer, but I think what really must be done is rethinking the entire concept of the individual who takes part in the market nowadays, who enters the market either online or offline, and the acknowledgement that those individuals nowadays are not the same consumers who were buying first TVs back in 1960s. So this is probably what we have to do, and we have to translate this observation somehow on the legal concepts we use. But
thank you. And the second question about AI and consumer influencing?
Actually, I didn't understand your question exactly. Did you ask me
Happy to repeat.
about manipulations?
Yes, the idea of dark patterns are usually, even in Europe as well, and you explain in Korea, usually linked to the design of an interface that is going to interfere in the free decision of the consumer. For example, just manipulated by very difficult letter in the interface that I don't know, I cannot see properly, for example, that there is a particular withdrawal button, for example. So we're talking about human being misled by dark patterns by the design. My question is, have you already considered in Korea as well the situation where these dark patterns are aimed to manipulate the virtual assistant, the ADM, the automated decision making, the AI system that is involved in the contracting process? Thank you.
Also, explicit, there is no clearly discussion on such problem, but I think it must be considered, of course, because the most contracts is concluded with artificial intelligence in today's. It must be, it can be, and it is already considered.
I think the dark patterns is deceptive patterns that influence the free decision of the consumer. And in automated contract system, there is no free decision. So I think it is a fairness problem because it is implemented already through the systems design maker. Then it is not fair. And this is our fairness problem, I think. It is not a decision of free will problem.
Teresa, you
Maybe.
mean...
I never thought about it. Oh, interesting question. Thank you.
Thank you. Teresa, you mean that we have kind of two different regulatory regimes kind of overlapping, classical AI regulation and consumer influence. But I think that's what happens. We had dark patterns before. They were maybe simpler, less elaborated, and if you combine the concept with AI, or you called it heuristic concepts, yeah, then it gets much more powerful, and you can decide where to regulate it better, probably. Okay, I think I forgot, Anna, that you have a second, well, I had a second question. Is it, discuss it in the next panel. So one more intervention, please. No, okay. Okay, at the end of the room? Yeah, go ahead, one more.
Thank you very much. My name is Craig Conniff. I'm the Karsh Professor at the University of Virginia School of Law. So I'm in many ways the outsider here because I do come in with the sort of cross-Atlantic perspective. And I just kind of wanted to endorse the previous comment regarding thinking about the paradigm of the consumer, right? Because, I work in health and privacy law. And about 5 years ago, I wrote a piece that contrasted the way in which we talk about the patient or the consumer, right? And the idea of transparency versus autonomy. And it seems to rely upon, both seem to rely on very different paradigms. The consumer is a market participant who has autonomy, who knows what to do, right? Whereas a patient is vulnerable and can be vulnerable. And so I do think that, you know, if we talk about a consumer and we talk about vulnerability at the same time, to someone schooled in the American tradition of vulnerability, Martha Feynman's work, etc., it seems difficult to put to think about a consumer as being vulnerable, at least in the way a consumer is traditionally used. And I think that, you know, so Mateusz, when you talked about, for example, the idea of, you know, the market, right? The minute you begin to introduce the idea of a consumer situated in a market specifically and vulnerability in that context, then it begins to invite the question, well, what about a firm, right? So if a firm has a lack of bargaining power in the market, if vulnerability simply means lack of bargaining power, then can a firm be vulnerable, right? And at that point, the concept of vulnerability, at least in the American tradition, seems to get stretched a lot. And so if we cannot think about the idea of vulnerability solely from a market perspective, right? And if the word consumer is one that is fundamentally embedded with the market perspective, then what is the correct term to use? And I don't know about client, but I think that the broader idea I would suggest is maybe situating the individual not just as a market participant, but as a, but within a broader socio-political concept, right? So the idea of citizenship as well, right? Because obviously when you're expressing opinions, you aren't just acting as a consumer, but you're acting as a politically situated subject as well, right? And so there's a range of ideas, and maybe that this is it's just the impoverishment of the English language or the political concepts we have so far that are situated within the sort of neoliberal ideology, as you pointed out earlier, Mateusz. But I wonder whether the term consumer can carry the weight, that vulnerability, which I think is inherently a normative concept, can bring to it.
Thank you. Who wants to comment, answer?
Well, so I'm not sure really what should be the relation between vulnerability and the concept of consumer. In the European context, vulnerability in terms of consumer market participation was devised, was introduced into EU law at first as the term which was used to somehow pinpoint, indicate the groups of consumers who are atypical to the extent that it makes them more prone, more fragile, so to say, in the market relations. Now we are talking about vulnerability, which is more, as I said before, situation-specific, not status-specific, so which is more specific to the type of market interaction or the circumstances of the market interaction in which we involve ourselves as consumers vis-à-vis a business party. Regarding what you said, and I'm not sure if I fully got your point about vulnerability in the US thought vis-à-vis the consumer as a market actor, but well, I don't think so again, maybe I will put it in different terms. All the things we are talking about now are just labels, are just catchphrases like consumer vulnerability, and so far we can play around them, and probably the key aspect, the key question here, what particular economic or social sensitivities or social agenda we put under those labels. And to me, what's happening with vulnerability nowadays in the US, especially under the influence of fluent political economy movements, at Emory University, there's the whole big project about social vulnerability. It is an attempt to somehow mobilize vulnerability to go beyond the classical concept of consumer as the actor on the liberally conceived market, and to understand that certain features or certain situations in which individuals function in the reality around us can make them more prone to, for example, abuse of power from the business, or to manipulation, or any other sort of negative social consequence externalities. So, and I think, sorry, this is my last word, I think, as I said before, in Europe, although we start from a different point and we frame our discourse in a slightly different way, we are more or less trying to do the same, especially at this conference with the concept of digital vulnerability, which is an attempt to rethink, reconceptualize how we frame, how we understand weakness on the market, but weakness on the market which can be also a spillover of some social weaknesses or some individual weaknesses, for example, some behavioral constraints, biases, and so far.
Thank you. So I have one last intervention, Shandong, please.
Regarding dark pattern, I want to say a small point. I'm really interested to how the provision about dark pattern of Digital Services Act in EU will be enforced. Actually, I'm co-working with Korea National Assembly and Korea Fair Trade Commission regarding this problem, and I proposed the general provision as in Europe. But the platform operators organizations, as always, this interfere the innovation of platform economy or the liberty of design UI. How can the governments to regulate? So the general provision is strong regulations. So they say so. In this context, yeah. So I'm looking for for the exchange of experience. And in addition, I want to emphasize the digital vulnerability. Is there here people who belong to econ in the field of neoclassical economics? I think we are all human. So at least partly in digital environments or regarding dark patterns, the concept of consumer, average consumer, must be changed. This is my opinion. Thank you very much.
Thank you very much. And with that, we are at the end of the second panel. I close our session and leave you to a well-deserved lunch, and we recommence at 3 p.m. sharp. Thank you very much.
Thank you, Alberto, for this kind invitation. And as the moderator, I should introduce our speakers, but I'm sure you all know them. They are leading and renowned researcher in the field of EU consumer law. However, to fulfill my duties as a moderator, I will introduce each of them. And our first speaker is Irina Domurat, and Irina is adjunct professor at the Universidad Adolfo Ibáñez in Santiago de Chile. Previously, she was associate professor at the Central University of Chile, postdoc at the University of Amsterdam, and the Ministry of Justice in Berlin. She holds a PhD from the University of Copenhagen and researches European private law in its political economic context in the field of data, consumer finance, and housing. And today she will discuss the relation between digital vulnerability and private autonomy. The floor is yours.
Yeah, thank you, Monica. Welcome everybody back from the lunch. I hope you had a good break. I was sad to see Mateusz leave because in many ways I hope to be continuing the discussions that we had, or that you actually started with him on the concept of digital vulnerability. So I have a rather conceptual argument to make. I also didn't submit a paper because it's still not ready in my head even. So I would be happy to discuss whatever you think makes noise in this presentation. Thank you, Alberto, for inviting me. I'm super grateful to be able to be here today. The fact that I don't have a fully fledged paper yet is also mirrored in this very not cool title. It's just digital vulnerability, autonomy, privacy, because I will talk about these three concepts to you. I do have an argument that I would like to present, and that is that digital European private law, which is European private law applicable to the digital sphere, is about autonomy. And this is why we have to talk about autonomy. And I think when we talk about autonomy, we also need to talk about privacy. And I think this is a neglected debate in consumer law, in European private law, and also in digital vulnerability to different extents. We will see this. So I think it's a problem that we don't talk about privacy. And I do think that the concept of digital vulnerability has the potential to change this, to connect autonomy and privacy. So my assumption is that, I'm happy about the cheers. My assumption is that privacy is a necessary condition for autonomy. This, of course, is nothing new. I didn't invent this, and I'm basically following a model, or rather theory, of informed consent that was put forward more than 30 years ago by Faden and Beauchamp. And they define, or they conceptualize autonomous action as intentional, based on understanding, and free from controlling influences. And I think it makes sense to use this three-pronged approach because it forces us to think analytically. And I think privacy belongs to the first dimension of what autonomous action is, because they say intention has basically to do with the formation of a kind of authentic, truthful will, which arguably develops in conditions of privacy. Then there are the other two dimensions. The one that European consumer law and European private law emphasizes is the third one, is the expression of will, which is the freedom from manipulation. But I think we have to go kind of anti to this and talk about how will is actually formed. So let's talk a bit about autonomy. I mean, all the concepts that I'm touching here have kept awake philosophers for centuries, and I will not be able to find some kind of, I don't know, put an end to the debates, right? But I think it's worth reflecting on it. So autonomy can be associated with many, many things. It can be kind of a sense of empowerment. It can be kind of breaking free from the cage, right? So freedom. It can be, yes, freedom from manipulation. It can also be freedom of choice. All these ways to see autonomy point at parts of autonomy, I think. What they all have in common is that they're grounded in a liberal idea. And that is the idea of self-authorship, to be the author of one's own life story. There are, of course, many, many different theories and many ideas of what this precisely means. On a very abstract level, I think we can group them into individualist accounts and relational views. The individualist account puts emphasis not just on the capacity of individuals to reflect rationally, but also on some kind of authenticity of will. So we are autonomous agents if we are able to act rationally upon a value and a desire that we genuinely identify as our own. This is also often called a proceduralist view on autonomy because it puts emphasis on the process in which we are able to form this truthful, genuine desire that is not imposed from anywhere but is truthfully ours. The relational view, on the other hand, is not really on the other hand. It's actually just an extension of the individualist view, I think, because it says, yes, we have to be and we are self-autonomous agents, but our desires and values are kind of filtered through social contexts. But they both have in common, and this I think all ideas of autonomy have in common, that there's a liberal understanding of self-determination and self-government. Privacy is a concept that is also very contested. I will come to analyze those two concepts in European private law in a moment, but I think it's also worth thinking about what privacy actually means, because there are many different ways to perceive privacy. The first one, I think this came about at the end of the 19th century, is that privacy is about the preservation of a fundamental space for the development of the human self. And this means that I can define what is the boundary of my private life and where does public life start. So this is my private space. The first ones to conceptualize it and talk about the right to privacy as such were the two US-American judges, Warren and Brandeis, who talked about the right to be left alone and the possibility to retreat from the world in the context of rising mass media, newspapers, rising gossip. And they said you should have to have the right to not be written about, basically. And they said that this right to be let alone is similar to the right to property. Then this became like the basis for other elaborations that have to a more or less extent agreed with these two. So privacy can be about now limited access to a person. It can be about the possibility to develop intimate relationships. And lately now, especially in the law and political economy literature, Julie Cohen is an example, privacy is considered a space for the development of the liberal self. Again, we have liberal roots here in the context of privacy. For most of these authors, privacy is instrumental to another value, be it autonomy or, whatever you want, actually. The only one that says that privacy has an inherent moral value is Charles Fried, because he says without privacy, we are nothing. We are not able to enter into any human relationship, including friendship, love. We will not be human without privacy. So there's an inherent moral value to it if we want to follow the moral account. A second strand of the privacy literature focuses on information control. So what happens here is that the boundaries are maybe not so strong on what is my private sphere, but I get to decide what is my information and what gets to leave my sphere of influence and what stays. This is the very traditional classical account of Weston that introduced this idea of control of information. Posner has taken this up in law and economics and has said that privacy also includes the right to secrecy and conceal information. And also Fried, who attaches the moral value to privacy, says that in the end, this is about how information is controlled. The last strand is the most recent strand, that is privacy in the political economy of large-scale surveillance. And here it becomes a bit more tricky because privacy is considered a social practice. So it's not so much about spatial, be it geographical or timely, whatever, ideas of privacy, but privacy is considered a social practice, which inherently means that this is something that develops in a relation. So I found basically two main accounts of this. Solovey says privacy is a set of valued social practices that can be disrupted, for example, through large-scale surveillance. Angelique Cohen, again, the law and political economy scholar, says that privacy is a social practice of boundary management to create a breathing room for the development of the liberal self. Again, here we have the roots in liberal thought in the concept of privacy. However, they do put emphasis on issues of power that can affect behavior. So if we are constantly surveyed, we will change our behavior. I'm not even talking about manipulation here yet. This is some kind of much more innate process. For both scholars, privacy, though, is an instrumental value. It depends on, and it derives its value from its connection to other values that we incorporate based on our relation with our social context. In sum, because I want to go to what does this have to do with European private law, privacy is a necessary condition for autonomy. We need to talk about both together, also when we talk about European private law. It serves as a space for the creation of a breathing space for the development of the liberal self. The notion of autonomy is a liberal one, and privacy here serves both the individualist and the relational understandings of autonomy. It serves the individualist account of autonomy that puts emphasis on authenticity of desires and values, because it puts emphasis on the process, right, to form an authentic, general free will. And it also emphasizes or serves the relational character of privacy in the digital sphere because it can put emphasis on differences in power. I don't have to explain to you what these differences are. I think we all agree if we are in this room. So autonomy and privacy and digital European private law. I am taking up a bit the distinction that Mateusz also did between consumer law and data law. And I think actually it's also problematic that we talk about these in two different, they're privacy scholars and then they're consumer lawyers. But it makes sense to look into, or to try to see what is autonomy and privacy, what kind of role does it play there. So in consumer law, I think we all agree that it is based on autonomous human beings as consumers. Consumers are autonomous. This is the reasonably circumspect standard. In EU law, we have this in European private law in the idea of freedom of contract and negotiation. Or if there's no space for negotiation, we control unfair terms and practices. However, I think that this unfairness control serves, again, the ideal of autonomy, kind of ex post in a way. And it doesn't change the basic outlook of autonomy of consumer law. The exception to this rule is a protection for persons that are considered autonomy impaired. We have already, somebody already today mentioned children. We will hear more about children tomorrow. Or old people, or whatever. But it's always specific groups of people, and the reason why they need special protection is because they are autonomy impaired. I think that this is a narrow view of autonomy, thinking about what I just told you. It puts emphasis on autonomy as freedom from manipulation, which puts emphasis on the third dimension of autonomy, expressing that will, that first has to form, right? So I think because we don't look into the formation of will and intent and negotiation will, if you want, we neglect also the role of privacy. And the absence of autonomy is considered an exceptional individual shortcoming that cannot be remedied, but this is just, we consider this just a specific group of people, so that's okay, we help them a bit. In data law, this is not much different. The GDPR is largely based on the idea of autonomous individuals that can manage their rights. So I have to be an autonomous individual to be able to exercise my right of erasure, cancellation, data portability, or to object to being made subject to automated decision-making. I need to be an autonomous person to do this, and I need to have the will to express this and to have to form that will in the first place. So GDPR and all data laws based on consent, well, there are other legal bases, but from the viewpoint of autonomy and privacy, it's consent. And the rule is we manage our rights. The exception, again, is special treatment for special people and special groups of data, sensitive data, and again, groups of people that are considered non-autonomous. I think the GDPR only talks about children and no other groups. So similar to consumer law having a narrow view on autonomy, I think data law, I don't call it data protection law, I call it data law with good reason, incorporates a narrow view on privacy. Privacy is conceived of as control rights. I control information, so this is Weston and Posner. This is not all the other rich literature that there is on privacy. Which means that the authenticity of desires and the will to be able to subject it to data processes and intent and consent is actually neglected. And this is curious because there is a few references in the GDPR to free will, and this is completely under-conceptualized. So it says that consent has to be based on free will, and the only example that is in there is, the power, the difference between public authorities and individuals. And in the private sphere, it's only employers, where free will might not be present. But it's also not clear what this does do to consent. It's not clear whether it actually invalidates consent. It's not clear. So by leaving out the commercial sphere and private sphere, apart from labor relations, also power struggles are neglected. So it is here where I think the concept of digital vulnerability, and here I will come to the end, can help. I think it can help to protect consumers better in the digital age. I think it can also, to pick up on this idea that maybe we are not always consumers and maybe we shouldn't be, it can also just protect us individuals better in a political economy of informational capitalism, basically. And it can have an impact on both the average and the vulnerable consumer standards. But, and here I'm very happy to be here because I think this concept of digital vulnerability still can become better. And I think it should adopt a thicker understanding of what we mean when we talk about autonomy and privacy. So generally, I think we agree that digital autonomy is about, digital vulnerability, is about the impaired autonomy of consumers, of all consumers in the digital economy vis-a-vis companies. This is because this is commonplace. We have large-scale surveillance. Companies look for ever more marketing strategies to basically get consumers to buy stuff that they need, or maybe want or not, but it doesn't really matter. But there's this huge potential for manipulation that is also being used, as we know. As far as I know, we have two accounts that deal with vulnerability, digital vulnerability, in a very conceptualized way. The one is the BEUC study by Helberger and colleagues from 2 years ago, and the other one is the book by Galli from last year on algorithmic marketing practices. Well, I don't want to do injustice to the title, but something like this. So Helberger et al. See vulnerability as structural and relational, and they do mention privacy. They say that lack of privacy is a potential source of vulnerability, but they do say that they themselves don't elaborate much on this connection. So they mention privacy, but they don't really say what it does other than maybe leading to vulnerability. And Galli offers a layered view on vulnerability. He's working with Lunas, an Argentinian scholar, a concept of layered and relational vulnerability. And it starts with an architecture in the digital field. It's a digital architecture, then privacy, that can lead to vulnerability, then specific situations that can make us vulnerable, and then on top come personal characteristics. So this makes very clear, and they are conform with Helberger and al., that we are not all similarly vulnerable. However, because this has been mentioned before also various times, that we move in and out states of vulnerability, I don't think that that's so true. I think because of the architectural nature of vulnerability in the digital field, we are all always vulnerable. And this might not be a cool policy option or a thought for policy, but I think, I don't really know when we could not be vulnerable. It's so that the practices, the marketing practices are so insidious that we don't even know, that literacy won't help either because we don't even know what we are educating for, really. So Gali also mentions privacy, and he says that privacy can act as a shield against showing vulnerability, or that these vulnerabilities can be exploited. And I'm finishing. In both accounts, privacy is instrumental to autonomy. It's made very explicit in both accounts. And lack of privacy can be a source of vulnerability, but as I said, it remains under-conceptualized as a necessary condition for autonomy. So, this is my last slide and I finish. I think the concept of digital vulnerability can really help to protect consumers and individuals better in the digital sphere, not just from manipulation, but also just from large-scale surveillance that is happening. But in order to do that, and in this way, actually, it would also connect very nicely any reforms that are maybe underway, not just in consumer law, but also in data law. But it should do so with a thicker understanding of what privacy is, and mention the connection to autonomy. So again, even if I bore you, privacy is a structural and necessary condition for autonomy. We cannot be a reasonably circumspect consumer without being private people also. But this understanding of private person has to go beyond what the GDPR offers, which is I control the information relating to whatever I think is important in my life. It relates to us as human beings. And just, it actually doesn't matter what it relates to, because I get to decide what I want my privacy to be. And this is more than just informational value of my data. So I'm very happy to be able to discuss this with you. Let's make digital vulnerability better. Thank you.
Thank you. Thank you very much for your valuable insights on consumer autonomy. And our next speaker is Fabrizio Esposito. He's a Bocconi and EUI alumnus and assistant professor of private law at the Nova School of Law in Lisbon, where he coordinates the master specialization in business law and tech. Fabrizio's research focuses on the interaction between law, economics, and technology at the theoretical and practical levels. He's acting as a class rep in class actions against Google and Apple related to their App Store fees. And today he will discuss the implications of digital vulnerability for EU consumer law. And the floor is yours.
But thanks for the sign about the mic. As I said, I am a bit nervous. So there were already so many inputs. And so I have questioned whether I wanted to change the structure of my presentation last minute, and I decided that perhaps is not the best course of action. So maybe because in Portugal it is so important to give a contextualization, what in Portugal they call enquadramento, I decided to approach this discussion about digital vulnerability by trying to save as much as possible of a previous, and I find for me it was very transformative, round of interdisciplinary discussion about private law that had to do with what we learned from behavioral scholarship. And my personal way to make sense of that idea was in a paper that is called A Dismal Reality. And the point and I would like to start from that to reflect about these discussions on digital vulnerability. The main difference between that debate and this debate is that debate was primarily theory-driven. So there was no significant change in the world that prompted that debate. The change was primarily a change led by the fact that psychologists started to do new things and managed to sell them to economists, and then economists managed to sell them to lawyers. So that was the change. This time, the change is technology-driven. So this is an important difference. But the underlying theme of my presentation and my understanding of the idea of digital vulnerability is that conceptually we can rely a lot on what the literature on the behavioral turn has done. Because essentially what is happening is adding a hyper, not a hyper, but a hyper dimension to this dismal reality that we have already accepted exists. So the lessons and then the connection with the idea of digital asymmetry and some examples of digital of forms of digital asymmetry and examples of these hyper-dismal reality, and then I will conclude with some cautionary notes about things that we may try perhaps to do better in comparison to the last round of scholarship. So what we learned that the understanding that we had taken from the 60s and the 70s from economists, but really from a variety of different sources, was very optimistic about the individual decision-making process, the capacity of the legal system to support and empower the individual through disclosure, the capacity of the market to sustain empowered consumers, and the conclusion out of that is that consumer law was expected to do more than what was originally believed. What I personally like to think is also one of the things that we learned, but I do acknowledge that perhaps the scholarship is divided, and perhaps I am on the losing side of history on this one, is that the legal system as it was, so the good news, in my understanding, was that even if there was a certain theoretical consensus on a lot of optimism, all of those things, actually the legal system, the EU legal system, the way in which it evolved in that conceptual context was still quite good in the sense that we never really expected consumers to read standard terms in Europe, just those very important terms that you would say you cannot really exercise your autonomy if you are not thinking about the price of what you're buying. But even there, over time, we have been very, very generous to consumers, and many other areas, some of which, like for example, free ticket boxes bans, are explicitly justified on the basis of behavioral insights in the relevant recitals. But what I will put emphasis on in the last part of my presentation is what I had called conceptual porosity, and that is the idea that there are certain core concepts in EU consumer law, and mainly weakness and asymmetry, footnote, not vulnerability, can really do a lot of work in order to import from other disciplines insights that can be useful to make consumer law work better. In the previous literature, we had the nudge. I would say that in this literature, we have this idea of digital asymmetry as the pillar on which the discussion is being built. It has 3 dimensions, and I will challenge the idea, or at least I will put in lower font, smaller font, the idea of relationality, because at least 2 of the examples that I think are really, really central to the idea of digital asymmetry rely on actually reducing the relational context in which the consumer is making its decision by operating on the architecture thanks to data-driven techniques. So the hyper elements, right? And this is another point of contact. So the very successful idea of a hyper nudge already in 2016 had built conceptually a strong relationship between these 2 literatures. So in my understanding, what we should be doing as consumer lawyers in 2023 is look outside legal scholarship and figure out how to incorporate into existing legal arguments, concerns about what is happening to consumers on the markets. And I would say that there is a middle-level conceptual framework for doing that, which was imported from competition law, and Mateusz already mentioned, which is the idea of the theories of consumer harm. And if there is one book that makes an excellent job in showing that this is the case, is the book by Christine Riefa and others. I'm not super convinced of everything that they say in that book, but that book gives us the possibility to incorporate things that had already been said and things that have been said afterwards. And it does also a rather important thing, I believe, especially for doctrinal legal scholars, which is it allows to look at existing legal doctrine and doctrinal decisions that have been made through these outside lenses to try to make explicit some ideas, because essentially the theories of harm work in this way. There are different scenarios. These different scenarios exist if certain assumptions about markets and consumers are satisfied, and then this leads to certain interventions being more or less justified. So you reverse engineer the choice made by the legislator, and you get an understanding of what was a plausible idea that the legislator had in mind where certain decisions had been made. Why is that important? Because if the empirical evidence shows that perhaps it is not really the case that those assumptions hold, then you have a straightforward, it's like a crab move, but then it goes very, very effectively in the direction of supporting institutional change. So the very first area where with Mateusz that has left, we played with these ideas was with regard to the notion of transparency in the UCTD. And our claim is that if you apply some ideas that were already present in Riefa's book, but that I think I clarified a little bit better on the JCP, you have this sense that systematically, regardless of where you put the bar between the average and the vulnerable consumers, there are going to be situations where the average consumers perceive certain things and the vulnerable consumers does not. So by using always and only the average consumer standard as benchmark for the application of the transparency test of the UCTD, considering that the interest of these two groups of consumers are not aligned, you systematically put them at a disadvantage. And we do not need to decide what is average and what is vulnerable because it will remain the same, right? You expand the concept of average consumer or you narrow it, there is always going to be a group of consumers that are not going to be protected by the average ones. So you can't simply fix the concept of average consumer to protect them. You need to allow courts to look at transparency also from the perspective of vulnerable consumers. And here, this is a first example of a problem of lack of relationality. So the assumption in our understanding is that often the interest of the average and the vulnerable consumers are aligned. So if the average consumers exercise the discipline factors on traders, this is going to be beneficial to the vulnerable consumers as well. But the minute this element of relationality between the average and the vulnerable consumers is lost, the game does not work anymore. And another area where even more effectively and by design, the interest of some groups of consumers are disembedded from the rest of the market is when you manage to identify consumers that have, for whatever reason, a higher, would pay more for something, and you disembed them from the protection of an impersonal price, and then you have a problem. Okay. The former Office for Fair Trade in the UK has analyzed this super well. I have tried to show that even if explicitly the European legislator has decided only to give to consumers an information requirement that I do not honestly believe it is quite useful. If you press the GDPR, then it actually grants you a right to an impersonal price, and on these grounds, with Mateusz, we embarked in an edited volume project where we exactly learned that this is something that also in other jurisdictions is actually possible, and you can design a regulatory framework built on the idea of the impersonal price that is actually going to protect all consumers from exploitation. A work that is still ongoing, but I'm quite proud of because I'm doing it with a master student of mine, and I think that there is potential for a publication here, is essentially claiming that by design, not one single element or another single element of social media as we currently know them are an unfair commercial practice. Why? Because they are designed throughout the life cycle of the product to match very closely our dopamine cycle, and they are designed and they are taught, they have been taught at Stanford, right, for the purpose of making people addicted to them. So perhaps that is quite problematic, and it is, if I know very distinguished colleagues, none of which is in this room, who have a problem with these social media. So perhaps it is not about the average or the vulnerable, it is about the fact that this should stop yesterday. Dark patterns is also part of this hyper-dismal reality, and I don't think there is any need to develop on this concept in this context. But again, what the dark pattern literature is trying to do, and in this context it is the most advanced one, is trying to create its own new taxonomies to make sense of the many ways in which in the digital context we can be harmed as consumers. And again, I would say that even in that literature, the difference between the average and the vulnerable is immaterial. This is perceived as a problem that is there and needs to be solved to the benefit of everyone. The cautionary notes. The first, and I will not develop on the first, is that oftentimes we manage to rely on we need to rely on non-legal research, but oftentimes the non-legal research we rely upon was not designed with the important legal question perfectly in mind, so it does not exactly measure what we need to know, and then we have to do with it, and then what we say is tentative, and then we cannot really feel that we can say, we can go to a judge with this one because the judge is going to believe us. So perhaps people who have won money to do projects on this kind of topics could consider to show to the rest of the community that there is a better way to do that. But now I'd like to go instead to the idea of conceptual porosity. Distinctions. The average and the vulnerable. And in some documents, the disengaged. But let's leave the disengaged aside because it is actually not a legal dogmatical category. In other literatures, we have these distinctions, right? So we had the rational choice theory consumer, and then we have the bounded rational consumer. And then in some other economic literature, they speak about the sophisticated and the naive consumer. And then we can speak about vulnerable and non-vulnerable consumers. What we need to be very careful about is assuming that dichotomies designed in a certain discussion that have their own functional rationality, rational versus bounded rationality, or sophisticated, and especially this is really clear with sophisticated versus naive consumer, is meant to show how the outcome would be for consumers that are not capable of using the invisible hand in a way that is to their advantage, okay? This does not necessarily mean that the average consumer, according to EU law, is going in a certain context to be able to do that. And the minute in which we make this assumption, which is beautifully symmetrical, right? So I do not have a very visual mind, as my slides can show, in comparison to many of my colleagues, but it would be so nice, right, if different epistemic communities working independently came up with distinctions that map each other perfectly. But perhaps it is also a little bit surprising if that were to happen. So we need, as the last people in the supply chain of ideas, right? Because then after us there is brute force, yeah? Because that's the thing about the law. After us there is brute force. We need to be careful in building the doctrinal arguments that allow us to then go to a judge who is going to ultimately be the person with the control over that brute force, on how we use these notions from other disciplines to build, and we plug them in our conceptual distinctions. When we don't, so for example, an hypothetical example that I chose that has no explicit connection with the title of this conference, if we assume that vulnerability in social sciences means vulnerability in EU private law, okay, then there are certain inferences that follow as a matter of legal doctrine, because concepts have referential and inferential dimensions. So if we say that they mean the same things, then you plug them into legal doctrine and certain consequences follow. The first consequence in the area where vulnerability is more explicitly taken into consideration is that it becomes a paper tiger, because applying Article 5, Paragraph 3 of the UCPD is way harder than Article 5, Paragraph 2, because you need to show that that particular reason of vulnerability was clearly identifiable and it was foreseeable and so on. And you have to claim it. So, and outside the UCPD, according to the current structure of EU private law, vulnerability does not really play a role. It doesn't play it in the UCTD, in the UCTD, it doesn't play it in the Consumer Rights Directive, and so on. So there is a lot of value in what has been researched empirically and what is being conceptualized by other disciplines. But the minute in which we assume that this has to do with the vulnerable consumer of EU private law, my understanding is that we are actually reducing the level of potential effectiveness of EU private law, and I think this is not what we really want to do. Now, I think, for example, that in the two different passages of the guidelines, we have two different understandings of vulnerability non-legal, right? So in the first one, and this is the position that makes sense to me, this non-legal idea of vulnerability can be used to inform both consumer images. Then, and perhaps Mattea is going to talk about that, I do not know exactly how to apply Article 5 when the pool of consumers is one person, right? So the test to that end seems to me very difficult. But if the way in which the notion of vulnerability that we see in the second sentence seems to be different and creates exactly that kind of problem. So the version that I actually had in mind of my main claim is that this reality exists and exists for all European consumers, be them average or vulnerable according to the doctrine. Thank you.
Thank you. Thank you very much for your enthusiastic presentation. And now the third speaker is Emilia Miszczenic. She is an associate professor at the Faculty of Law at the University of Rijeka, and she's an awarded scientist in her field of expertise. She obtained several awards like Croatian National Science Award, Award of the University of Rijeka Foundation, recognition of the Croatian Ministry of Science, Education and Sports, Award of the Republic of Croatia for her outstanding academic and professional results, and her scientific work has been cited by advocate generals in cases Perenichova and Meta Platforms Island, etc. And today she will be talking about the gap between digital fairness and transparency in EU consumer law. The floor is yours, Emilia.
Thank you, Monica. Yes, I will watch for this. Okay, I will be more practical, I think, and I will speed up. First of all, I want to thank to Alberto so much and to the organizers of this wonderful conference for having me here for the second time in a row in beautiful Ferrara. It's such a lovely opportunity. As you can all see from the title of my presentation, I will shortly address the gap which exists between digital fairness and transparency when it comes to consumer law. It's actually an issue that we are all addressing here in one way or another. So to start with, in my draft paper, I'm first addressing a question, I would say, or an issue, and asking a question, what is going on in EU legislative arena? And as you all know, a lot is going on, even too much. And I don't intend to bother you with all possibly applicable legal acts to a certain B2C online transaction or their inconsistencies or conflicts, such as, for instance, between some provisions of the recently adopted Digital Services Act and the UCPD. Maybe Matea will talk about it or not, or some general notions or terms that also, of course, contribute to this gap and sort of create legal uncertainty for the market players. What I do intend to address shortly is what we have all heard today are these important concepts such as average and vulnerable consumer. And what I will ask is maybe another question, in which way the current rules on information duties and transparency requirements, so from the existing legal frameworks, are affecting the position of the consumer acting on a digital market. Basically, I'm asking a question, are they empowering the consumer as it was intended with the information model, or potentially weakening his position on the digital market? So to skip this slide, so in line with this conference topic and discussion, I first started to contemplate on the question, are we all vulnerable in a digital market? And if so, why? And in order to provide a plausible answer, I first started with the basic things, and I wanted to create this main distinction between the definition of the consumer and the concept and the image of the consumer staying behind all these various definitions across various EU consumer directives. And I, of course, will not again go into details because we are all familiar with the definition that consists of these two cumulative elements, which has been so many times interpreted by the Court of Justice, including the dual-purpose contracts as the second part of this definition. But what I intend to address really shortly, because we have discussed it so much, is this concept or the image of the consumer as a person staying behind these various definitions, because I think it's a decisive factor for the better understanding of the consumer as a person on this market, acting on this market, and its relationship to the businesses. And this leads us, of course, to this discussion that we are having today, and it's not surprising that the fitness check public consultation is questioning whether the concept of an average or vulnerable consumer should or could be complemented, or do we need additional benchmarks or factors in order to understand it better? So because the concept as such was created and developed under the Court of Justice when interpreting the UCPD, but of course where you can see, I will not repeat, we all know who an average consumer is and defined as a reasonably well-informed and reasonably observant and circumspect. But what this concept that we are looking at of an average consumer that became sort of a benchmark for the consumer protection and interpretation of various directives, not only UCPD, but Consumer Rights Directive, Consumer Sales Directive, UCTD, and so on. What we need to acknowledge is that there are actually quite many concepts and images of the consumer, and that this average consumer, depending upon the circumstances of the case, can transform into a weak consumer, as you can see from the Oceano Gruppo, or also called by Vanessa Mack Calimero consumer in the book, famous book on images of consumer in EU law, edited by Dorota Lekwiewicz and Stephen Weatherhill. It can also be an ignorant consumer, as known from Duarte Huero's case, who is unaware or does not appreciate the extent of his rights, or of course vulnerable consumer, as acknowledged by the Court of Justice as so many legal acts, and we see it here on the slide. So differently than the definition itself, the concept or the image of the consumer changes upon the personal and factual circumstances. What leads to another question in the context of the digital environment. Does an average consumer becomes vulnerable when he steps into the digital market because of the risks of the market, or he's vulnerable prior of stepping into that market, or both? And here is what I think we need to do, and I'm trying to do it in my draft paper. It's a distinction between vulnerability in general and this digital vulnerability that we are discussing here today. And when it comes, I don't intend to go into details. In my paper, I will try to draw an analogy with the financial sector, when so many of us have, I'm looking at Irina because she wrote so many papers on consumer credits, and in banking sector and in payment sector, we wrote so many times about vulnerability when it comes to consumer in this sector, for instance. So, but in general, what I wanted to say when we are looking at the concept of vulnerability, I think it's to be looked at from two main angles. And of course, the one is related, as we can see on these slides, an example from directives and regulations that relates to the specific needs of the person, yes, acting on the market. And another angle relates to the particularity of that market and the risks related to that market and its products and services. So there are two main angles to be looked at when we are discussing the vulnerability. And when we put all that into the context of the digital environment, when it comes to digital technologies, I believe that we all tend to transform from an average to a vulnerable consumer, simply because we do not have the capacity to understand this very complex IT language, programming language standing behind the distributed ledger technologies, JavaScript, I don't know. We don't understand the functioning of the algorithms. What makes this structural imbalance that we were discussing before between businesses and consumers so much stronger or worse in the digital environment. And it leads us, as BEUC report stated, so many of us quoted BEUC report today, 2021, to this digital asymmetry, where our choices are not run by rational or informed decisions, but quite very often manipulated by algorithms, by other digital techniques, by profiling, by manipulative design, by different dark patterns, as we have heard. And as we all know it, behind every manipulation, there is a sort of a misuse of an information. And this leads to this, I would say, second part or the main part of my question. And this is the question whether the information duties or the rules on information duties and transparency requirements can contribute to balance this digital asymmetry that we are discussing today. And although I do not really believe that the digital asymmetry can be cured, let us say, by a right to a right information, I do believe that more transparency and better regulation of mandatory information obligations or duties could contribute to this balancing act. But of course, the question is, where do we stand today? And again, we don't have the time to go in details, and I don't intend to bother you with all these examples. These are just examples describing to all of us what we already know. We do not we do not stand at a very good place when it comes to regulation of information duties. Here are examples, for instance, just to look at the Consumer Rights Directive requiring from traders to provide more than 20 pieces of information to a consumer. And the question is, and it always was, of course, how can an average consumer who becomes weak and vulnerable when stepping into a digital market comprehend more than 20 complex information about a certain product or service under precondition that he gets the information. And all these information, as you can see from the second example and the second slide, they have to be provided in a transparent manner, meaning in a clear and a comprehensible manner. And this leads to another key question that is relevant for traders, for businesses. How can the trader possibly provide the consumer with such an amount of information in a clear and comprehensible manner? And what we see here is a direct conflict between the transparency and information duties. So it's not just about the quantity, of course, it's about the quality of information. And I would say that this current overextensive regulation and ineffective regulation of information duties is working to the detriment of both parties, creating high compliance costs for businesses and actually not providing protection to consumers. Of course, the best way to see it is through an example, and here you can see just an example of consumer buying something online, ticking different boxes, accepting cookies, privacy policies, terms and conditions, usually hidden somewhere in some small corner of the website. There again, it depends upon the web design. This is just one example of a certain web design of a certain trader. But it is most likely that all those information that you have seen before in the legal framework, pre-contractual information, or at least some of it, will be merged within the box on terms and conditions. The content of which, of course, the consumer already ticked and accepted. And as confirmed by so many studies that we have seen today from different presentations, of course, from European Commission sweep action, maybe this one is a bit outdated because it's from 2020, but where it was confirmed by the commissioner that 2 out of 3 web shops, they allegedly complied with information duties and transparency requirements, and here are some other results. There were some other important information missing, and I will skip that part. I'm scared from Monica. Sorry. And here there are again examples from many examples from the Court of Justice, from the European Union, basically confirming that with more digitalization we witness less transparency. And on the following slide, there are just some excerpts, important one that I at least consider important from different cases. From content services to Etiqueta, when 10 years ago in content services, the Court of Justice was reluctant to inform consumer via hyperlink in the website because it's not a durable medium, while 10 years after in the Etiqueta case, this is an acceptable way of informing the consumer, however, without prejudice to receiving a confirmation of a contract, including the pre-contractual terms and conditions and so on. But what we can also notice, if we look at this case law, from content services to Etiqueta, is that the role of these pre-contractual information that you have seen previously on the slide transformed. And that basically the pre-contractual information, as you have seen in this example of the consumer buying and ticking, accepting terms and conditions, they sort of became post-contractual information. Yes, because the consumer was ticking and usually he gets them once the contract already is, let's say, signed in this electronic way. So, and this leads us, of course, to the question of the main question, and this is the question of transparency. And due to a lack of time, again, I will not go into these stories or general approaches on the principle of transparency. I will just shortly address the fairness, transparency, and the fairness of terms, contractual terms available online. And so let us look at the different, again, examples from the case law. So once the consumer was provided with pre-contractual information after the contract conclusion, as well as with the contract and its conditions, we all know that he's usually not able to change a thing or to affect the content of the contract. And on many occasions, he does not read, or even if he reads, he does not understand the terms and conditions that are supposed to be drafted in a plain and intelligible language. And of course, this lack of transparency is affecting consumers' choices, and it leaves us without an actual choice. And it brings, of course, it all brings this fairness into the question. So to wrap it up, I would say, and this is not something that is new, because you see the cases. These are some of these cases, of course, and you know them. And on the second slide, you will see now the settled case law related to the consumer credit and UCTD are not typically linked to the digital market. But to wrap it up, we would use the interpretation of the transparency requirement from this settled Court of Justice case law and applied by analogy to the digital market, where our choices, meaning online contracts, are guided by unfair or manipulative designs, where essential information is not really available to us or provided in a good time before a conclusion of the contract, where we can enter the contract, but we can never leave, as we have heard today, an example of digital subscription contracts. We can hardly talk about transparency and the fairness in the digital environment. And I have received the sign, and I will finish, I will wrap it up. So, of course, this is not a hot water that I have invented. This is nothing new. We all know about these issues, and they have been addressed so many times by different legal scholars, by Consumer Protection Association, by European Commission in the fitness check, by BEUC, and so on. And there are so many proposals that I'm also addressing in my draft paper, such as, for instance, you can see Luzak and others, they are talking about tailor-made consumer information. Professor Sergio Camara Lapuente emphasized that we need to optimize the information process, how the information is delivered. Professor Weber, again, he's proposing maybe principle-based approach instead of detailed rules when it comes to disclosure and informing. Colleague Professor Grochowski he, with his associate, he developed a great paper on algorithmic transparency and explainability. Then there is BEUC, Fairness by Design. You can all see the fitness check, TNC summary, reminders, consents. But what I think, I, of course, acknowledge many of these proposers and agree with many of them, that at this point, what we need to do is focus on optimization of information duty and maybe look forward to this less is more doctrine. And I think we should put focus on providing essential information to consumers on a durable medium when when concluding contracts online. And also what I think we should consider seriously is the introduction of some more practical guidelines when it comes to transparency requirements. And this might prove, I think, useful both to businesses, to traders, and consumers. And of course, this can be done in so many different ways, not only by amending the current regulation, but also with the help of digital technologies. So I think actually that we might improve and even strengthen the transparency and fairness in the digital market by the use of digital technologies, but I will not, of course, reveal how I will write it and put it down in my chapter, so you will have to wait. Thank you so much for your attention.
Thank you, Emilia, for your presentation and for respecting the time limits. And last but not least, Mateja Durovic. He is a reader in law and co-director of the Center for Technology, Ethics, Law and Society at King's College London. And previous to this, he was an assistant professor at the School of Law at the City University of Hong Kong. And Mateja holds so many degrees, PhD and LLM degrees in EU consumer law from the EUI, LLM degree from the University of Cambridge, and LLB degree from the University of Belgrade in Serbia. And Mateja was a postdoc research associate at the EUI, visiting scholar at Stanford Law School and at the Max Planck Institute of Private International and Comparative Law in Hamburg. And he worked for the legal service of the European Commission, as well as a consultant for the European Commission, BEUC, and the United Nations. And his work was published in leading law journals like European Review of Private Law, European Review of Contract Law, Journal of Consumer Policy, and by most prominent publishers. And he's a member of the European Law Institute, Society of Legal Scholars, and Society for European Contract Law. And his presentation will focus on the UCPD.
Well, thank you very much, Monica, for this very kind introduction. You know, as they say in Italy, gli ultimi saranno i primi saranno gli ultimi. That's always my hope for being the last one. No, jokes aside, it's really my great pleasure and honor for being in this wonderful panel with great friends and great colleagues. So I'm the last one, you know, and I don't have slides because my idea was, okay, I want to say something that, you know, try to follow up something that has not been yet said. And of course, you know, my huge gratitude goes to Grande Alberto. I mean, you know, in academic world, there are conferences and there are Alberto's conferences. So, I mean, he's always, you know, really managed to organize everything so well and gather great people. So I'm very honored and very pleased to be here. So, my kind of topic and what I want to cover in my paper, what kind of the idea is, how the notion of vulnerability is supposed to evolve and to address all of kind of dangers and all of the situations which are brought by the ongoing process of the digitalization. Because we all live in these times of the fourth industrial revolutions, and it's incredible the pace at which kind of the economy, the world, the market, and especially the technology develops. So there is always this continuous race between, you know, development of technology and, you know, on the other side, development of law. And when I was a kid, I liked watching these cartoons, and, you know, when there is always some bird which can never be caught. So I always have a feeling that, you know, now consumer law really desperately tries to kind of catch up with all of these issues brought by the process of the digitalization and actually not being able to really kind of properly address it. I would say that, you know, in my paper, I have three kind of main questions that I'm addressing. The first one is, you know, what is actually this vulnerability and what it means kind of in the context of the digital world. Second is, I mean, that comes from the answer to the first one, you know, why kind of this notion of vulnerability has not been kind of clarified and why it has not been redrafted. And then the third question is kind of the normative one, where I kind of try to explain, you know, how can we improve protection of, you know, consumers in the digital world, in particular vulnerable consumers, by kind of, you know, redrafting of the framework secured by the very powerful provisions of the Directive on Unfair Commercial Practice. Now, when we talk about the notion of, you know, this idea that there are some consumers which are kind of more vulnerable, which deserve kind of higher level of protection, which deserve to be paid particular attention to by the legislator, by the policymakers, by the, by the judge while acting on the market. This kind of idea is, from the perspective of EU law, not so new. I mean, we have kind of heard here, okay, it was in EU consumer law, it was first the directive 2005, that for the first time in the EU consumer law has codified this kind of notion, and then eventually this was confirmed by the directive of 2011 on consumer rights. But this idea has been already in place for many years, because, for example, if we look at the case decided by the Court of Justice of the European Union in 1989, Bouet case, that was already kind of, mentioned this idea that, there are some consumers that are more vulnerable due to their kind of low level of education, and thus they're more exposed to diverse kind of, problematic forms of commercial practices from a trader. So that's kind of already kind of the beginning. Then on the other side, the old Audio-Visual Media Services Directive also has the idea we need to protect some categories of kind of, citizens which deserve more protection, focuses on children. That was kind of the first, probably, European piece of legislation, focus on protecting children as a very particular category of citizens. And then, we have this kind of directive on fair commercial practices. But it's very interesting then, to try to understand. And, I think, I don't know about you, I mean, we had excellent speakers here today, and I don't think it's a problem with the speakers. I think it's a problem with the notion that, did we really understand what is vulnerability and who are really vulnerable consumers? I mean, this Emilia's introduction, was really great, Are we all kind of in the digital world, are we all vulnerable? Who are these, And, if we look kind of at the papers, we always have this issue that, this notion of vulnerability is so problematic, it's so difficult to understand it. But on the other side, the case of the Court of Justice of the European Union, this is probably the field where it helps us the less, because it's so difficult to properly understand it. And then on the other side, I'm really following very closely now the developments in the UK in the post-Brexit context, because as you are all familiar with, UK consumer law has primarily developed as kind of, the influence of course, UK being a member state, so it has to completely transpose all of the provisions of the directives. And it has always been, the most problematic in this kind of system of rules that were kind of in a way even representing legal irritants to the traditional English law. This kind of the idea of the average consumer and especially vulnerable consumers were always, praised to be the worst ones because they brought a lot of legal uncertainty. It's not clear what they meant. And now in the context of Brexit, when I was kind of, my opinion, what would be the first kind of part to be changed would be exactly this kind of average vulnerable consumer. But interestingly, the question is with what to replace them, huh? And we can see these kind of discussions in the UK that, when we're kind of discussing, okay, let's try to clarify this notion, it's very, very difficult. So in that sense, when we look at the notion itself of vulnerability as kind of developed in European consumer law, it's kind of already very ambiguous, unclarified, has really many different meanings. And now we have reached a different level when we have kind of this kind of digital vulnerability that we need to discuss without kind of, having clarified the concept itself. And that poses a lot of problems in practice. And I think, in the concept of the digital world, things have become more complex. Why is that? Because I think that, if you look at kind of our society, I really think that, citizens can be divided into three groups, depending on their age. And they are all equally kind of, but in their own different ways, vulnerable in the digital world. Because we have this kind of elderly population that completely kind of grew up without, the smartphones, without the new technology that's used to type. Let's say if academics, they're kind of PhDs on the old-fashioned, typing machines or whatever. And, for them, it's really kind of, okay, not academics, but, for the elderly population, it's kind of struggle to adapt to these challenges. And, you had in Europe all these protests continuously, where some of the mottos that were kind of that were displayed was, we are not kind of stupid, we are just kind of old. And that, all these people now need to rely on the different applications to pay their bills, to check, their kind of bank accounts, etc., and they struggle. So in that sense, they're much more vulnerable for potentials which are kind of brought by this kind of, the new technologies. Then second generation is mid-generation. I think many of us kind of would belong to that one. That, we are kind of, we were the first one that we kind of had really to work very hard, and that we are kind of exposed to these issues. But in a way, we are vulnerable because we are in between. We live part of this digital world and the kind of regular real life, and we are exposed to different issues. And I mean, I've always, laughed when people use these examples, someone like Emilia saying like these subscriptions, how easy it's to subscribe, how difficult it is to unsubscribe. And then, everything, how people do not know to use this. And then I end up myself, being subscribed for 6 months on Amazon Prime, not being able to unsubscribe. Exactly, and then, what kind of, I can always use myself as an example, but that's kind of difficult thing. And then there is this third category, which is, I think, particularly problematic and vulnerable, and we can also see that in the context, for example, of the AI Act, are kind of children which live their lives actually in this digital world, and that's where kind of they're exposed to the most of the risk. So that's kind of really interesting that we need to have these differentiations of people depending on their kind of, their kind of education when it comes to this technological development, how to be protected. That's kind of my kind of one of the observations that needs to be made. And then it's also very interesting when we talk about, again, what kind of problems are being kind of faced with it, in the context of vulnerable consumers. I think someone has presentation tomorrow on exactly TikTok, and I just published a paper on that, exactly on the pan-European cases against TikTok. TikTok for years in a row has been the most downloaded application in the world, that also in Europe. And who are its main users? Teenagers, no? Especially kind of vulnerable category of consumers. So children have been kind of really traditionally really exposed to all these dangers, and there was always this idea how traditional kind of consumer law can help them. And all this happening in this kind of, as I said, like in the world where we kind of live really in the data economy, where kind of our data is being, stored, it's first being collected, then it's being stored, and then it's being used. And there are some kind of, I mean, if you talk to data analysts, what kind of they claim that only 20 to 25% of our data that's being collected is actually being used. That still majority is being stored somewhere and, waiting for the opportunities, waiting for technology to develop in the future to be kind of used, for targeted advertising or, for that kind of personalized pricing or whatever. So in that sense, we really kind of live in a very particular kind of moment of the society of this kind of transition. And I think, partially when we talk about vulnerability, when we kind of talk about the legal landscape and legal design, I think it's very difficult to come up with the right legal solution, legal answer, how to kind of, to protect vulnerable consumers. Because even if we kind of, try to say, okay, we understand what kind of vulnerability means in practice, we understand who vulnerable consumers are, we understand what are the potential dangers. The issue is that technology is developing at such an incredible pace that, the provisions that are kind of being developed slowly get out of date. I mean, if you look now at the Directive 2005, it's been kind of in the Asian world. So the solutions are kind of basically two. One is to kind of, let's say, to update the list of the practices. That's something that's being done of the Annex 1 of the directive, try to add those that are kind of, something partially already has been done in that context with the Modernization Directive of 2019, where we have these 4 new practices, exactly reflecting the dangers of the digital world. But then the problem is if we kind of go with that way, okay, we target some practices which exist now, but the question again remains, what happens with all these new practices that they develop in the future? Because the problem with the kind of the general clause is always that it brings a lot of legal uncertainty. And that's something, I mean, now I know for all of us here, that doesn't sound a big problem, but if you talk like kind of, to all these people working in the innovation sector, working with the startups, they really have a big, and someone asked me to talk about the article, was it, Fabrizio, you mentioned Article 5, as well, that I should say something. When I talk to people in the industry sector and I ask them, about all these dangers for the consumers, they always complain about this Article 5, saying, we don't know what it means in practice. It brings us a lot of dangers because we do not know whether we comply with kind of all the consumer law legislation, or we do not. So, in that sense, we also need to be careful, especially kind of, in this context of the European Union, trying to be at the forefront of innovation, that the legal landscape is also something that supports innovation, and that's kind of the balance between the two can be really problematic to achieve in practice when we look at the kind of the future legal landscape. But again, what is very interesting about, I have a feeling also, when we look at the other sectors, I mean, we look at the DMA, which almost has no words about, vulnerability. Then, Digital Services Act mentions it kind of briefly, but in totally different context than traditional European consumer law, in the context, primarily some characteristics like, sex, like gender, like race, sexual orientation, whatever that can be used, for the purposes of targeted advertising. I mean, in that sense, I mean, that's again to me another kind of issue that will kind of might open this question of in the future of how we should really understand vulnerability, in particular kind of digital vulnerability, and it's something that will need to be clarified in practice. So I mean, a lot of things about vulnerability. I don't want to repeat and these kind of the ideas because this has already been a lot mentioned. But as I have said, and as we are running out of time, I just want to conclude. So these are kind of the three ideas that I will try to address in my paper. First of all, what is kind of the traditional concept of vulnerability, and then in particular, what is this digital vulnerability that needs to be addressed by the UCPD? Second is why this issue has not been clarified and why it's kind of so problematic, why it has been emphasized also if you look at like the policy documents, we can see that's something, being very ambiguous, and eventually, trying to come up with some proposals. But I'm just thinking, with this kind of concept of vulnerability, it's very difficult to come up with something that would really kind of work in practice and that would be kind of really properly applicable. But if you kind of come to me and ask me what is the alternative, I can tell you I don't know. But we definitely need to work, and it's been kind of, it's great that, this is the conference topic for this one and the next 2 years. And I know that, I know Monica, like I know she mentioned to me, she's an editor of the encyclopedia. Can I say, is it public or it's secret? Okay. And I know that, I think that was the most attractive topic to write about, digital vulnerability, what it means in practice. So that's something, that we all need to kind of try to clarify. I'm not sure how successful we'll be, but anyway, looking forward to the discussion. Thank you very much.
Thank you, Mateja, for your presentation, and thank you for 5 additional minutes for our discussion. So now it's the time for discussion. Do you have questions, interventions? What do you want to know from our speakers?
Maybe everything is clear.
We need micro, Catalina.
Thank you so much. It was wonderful once more to listen to your presentations, and I will once more try to play devil's advocate just to get a little bit of debate going on. And so I hear again also of course, in a conference about consumer vulnerability, the theme of, for instance, consumers being overwhelmed and consumers being exposed to too much information. Now, a lot of data is collected from them increasingly and in more sophisticated ways. So what do we expect also consumers to do? So that's the consumer empowerment kind of narrative that we have also seen in European private law. Do we really expect regulation to solve everything? Do we want, the fairness check to just tick all the boxes and say, yes, we're just going to keep, we're going to increase our vulnerability standards or increase the average consumer standards. We're going to consider more and more practices to be unfair. But will that really solve the fact that we're dealing with this massive literacy issue still? And I want to just portray this. I was having a conversation with a media scholar who focuses on children's activities on social media. And we were saying that right now it's, the parents who played their data away on Farmville, on Facebook, are supposed to train their children in digital literacy when they go on TikTok. So that's a little bit of an abysmal image. So what do we have to do also on the side of consumer empowerment? I'm very curious what your thoughts are. Thank you.
Thank you. It was a question to all of the speakers?
Yeah, to all speakers.
Okay. Who would like to start? Oh, maybe this question, and could you please answer this question, and then we...
Maybe I can start, so maybe you can continue. Yeah, it's a good question, but a tough one. You have seen the slides in the beginning. I don't think we need more regulation. I think we also need less regulation. We have too much regulation, and we see that it's not, as I have already criticized, not effective enough. So the question is, of course, now we will see with the fitness check where it leads us. Do we? And it, as Christina this morning said, it all costs. I mean, amendments and changing all the regulatory framework, everything costs. So the question is, of course, whether do we need to adjust this, what we have here, this acquis, or should we, erase everything and start all over again? That's not, I'm not sure, what's the exact, of course I would like to start all over again and have a fresh start and do it properly, but I don't think this is impossible. So I think that's at least my opinion. I think we can work it out with this, what we already have. And I think we have, somebody said, Fabrizio, I think, or with some examples from different directives, we already have something, and we could improve it when it comes to regulation. I think one thing is when it comes to, rules on information duties and transparency requirements. I don't think there is, of course, we need some efforts, but it can be done. It can be done, I think, quite easily through certain amendments, but regulation per se, of course, it's not enough. We need to combine the regulation and reality. What I skipped a sentence because I was so hurrying and rushing because of the time limits. What I wanted to point out actually with this slide is the gap that we are seeing not only between transparency and fairness, but what we are seeing between legal regulation, as we have imagined that it would be, and the reality. This is the online reality. Where are all these rules that we are presenting across EU directives? As I said, some are in the box terms and conditions. So we need to adjust, I think, both, and to the benefit of both parties. I don't think it's only about consumers. I mean, for traders, it's very difficult. For those who want to be, there are traders who want to be fair. I don't say it's, of course, today we are discussing a lot about manipulation, but I recall from many seminars where I was working with younger people and traders who asked me practical guidelines where they can find some solution and how can they act fair so they can keep these customers. And I was, clueless because there was not a single guidelines for them that could point. So I think a combination of both. And when it comes to the second question, I think Matea would be better, the literacy, but so far as I have seen, there have been so many literate people who were also manipulated.
Yeah, I think, Catalina, great point, great question. Thank you, Emilia. I mean, yeah, I agree. I think literacy is very important. This digital kind of working on that, I think it's very, very important. But again, I'm just thinking, there's something maybe which is possible mostly in the Western world, in Western Europe. So, I mean, what about other parts of the world, So that's always a very interesting question. And, also with this question of the technology, when you kind of speak broadly, what you have mentioned, for example, I worked on two kind of interesting, new technology and how they're kind of changing consumer landscape. For example, smart contract was one. And it is very difficult now to kind of find really areas where kind of consumers are being endangered by smart contracts, where in practice they're being used, and it was such a big topic some years ago. And whereas kind of on the other side, your metaverse, which is also being talked, you already have a lot of consumers, a lot of children as kind of, players, especially in the context when metaverse is being used for games. So, I mean, I think that's kind of one of the big problems, because things are developing at an incredible pace, and some things, become very interesting, some things, simply continue to kind of live, and that's where kind of it's worth investing, literacy, and it's worth, educating consumers, whereas some others simply die out. I mean, I just told you another example. I checked with my students, for example, Couchsurfing and Airbnb started more or less at the same time, and now everyone knows about Airbnb, but Couchsurfing completely died out. So it's also, again, very interesting, how on what to focus, and that's one of the big problems. And of course, I agree with Emily what said about regulation. I mean, it's better. Yeah. Thank you.
So, if I may, I want to be a bit more radical here. I think literacy is nice as a nice idea, but it won't solve the problem at all. So, especially if what I'm trying to convey here, if we think about how important privacy is. So, in a context of large-scale surveillance, none of us is, how can I say, the master of our own minds anymore. We cannot assume this at all. And we should also not think that just because young people can type fast and are so hyper-connected, they know better what's going on. They don't know. We have talked about these, all the dangers that there are. It's all protected by business secrets. We just don't know. We can try, but we cannot understand. Maybe also on the fringes, some like privacy geeks, they know and they're able to protect themselves by putting I don't know how many funny machines into their apartment so that nobody can track them. But this is not a standard that we can demand from everybody. I think here, when it comes to privacy and surveillance and the impact this has on the digital sphere and the digital commercial sphere, we cannot be afraid of prohibitions. Just prohibit stuff. Be more courageous. Be, to a certain extent, at least think about decommodifying data. I don't understand, of course I kind of do, but like I don't know why we should not be able to change that. So we need to be a bit more courageous. We need to think about prohibitions. The AI Act is not bad, right? But it's not enough. We need privacy by design and need to enforce it. We need to rule out dark patterns and enforce it. We need to prohibit commercial profiling and enforce it. The enforcement is another problem, but I'm just an academic, so I can just talk about what we should do. And I think this is how we can take care of what I think is the first layer of vulnerability, which is privacy. We first have to take care of privacy, and then we can think about specific situations, commercial contexts. Then we can think about personal characteristics, levels of education, literacy. That's all fine. But if we do not think about privacy and rule out that our data is being collected, and we don't even know for what, because it's supposedly a business secret, there's no way that literacy can do anything. And I think regulation is just fine. I mean, I'm not saying prohibit everything, all digital companies, but prohibit certain practices. Ciao.
For example, why are we still allowing infinite scrolling? We know it's terrible. Why do we allow apps to have so many push notifications by default? Why are these things allowed? In what reasonable version of the good these things are desirable?
Yes.
Right?
Why can I not, to take up your example, why am I still, I just moved from Chile, I'm still getting 50 emails because I'm supposedly subscribed to something, and I constantly have to unsubscribe, and it takes me, I think I'm the only idiot here in the room that actually I opt out all of the cookies, and I don't know how much time I spend on this. Why should we, thank you, why should I do, why do I have to do this? Why? Yeah, exactly. It's nothing crazy.
But why? Why are they entitled to the default of my time?
Exactly. What a good law person. Yes?
No? Very rapidly. Now, I just wanted to put in a short dialogue your interventions, and I think it's interesting to do. Starting from the very first intervention, it's great you mentioned old references to Austin and Cohen. Actually, the first person in the US to connect privacy and vulnerability was Ryan Callow. He wrote this paper just saying that privacy, and the point, I think it's very interesting, you mentioned Florencia Luna, layers, and I would use the layers element that you mentioned, and that I used a lot in my book on vulnerability and data protection to reply to the criticism or the provocations in particular of Fabrizio and Matteo. because I think we have this seduction of final definitions. And we think that we have the definition of vulnerable person, and then we don't have, or we are very formalistic and say, well, it's in Article 5, and then everything else we should use other words, asymmetries, etc. But layered vulnerability is very interesting. We all accept that we share a minimum layer of vulnerability as consumers, regardless of whether Article 5 just use it as a benchmark for the average. And then we consider the context based on power dynamics, based on infrastructural situations, based on fundamental rights at risk in that particular context as a consumer, and not just economic interest, and how this is shaped with my supplier, with my counterpart. So I think that, just wanted to connect and see if there are any reactions, connecting the layered approach to the Article 5 vulnerability. But I see there is maybe another question, so maybe, I don't know, I'll pass the mic. Yeah.
What is your? Yeah, okay. Yes, hello. Thank you so much for an excellent panel. Very interesting and very closely related, obviously, to the fitness check questions. So I actually wanted to ask, well, first of all, maybe I should just reassure you that both of these views, the ones that we have enough legislation, let's make do with what we have, but also let's be more ambitious and prohibit things, let's question the targeted advertising business model, let's question the different features, design functionalities like infinite scroll, auto-playing of videos, all of this we are considering, and everything is on the table. But my question is, it's something maybe more general. I was inspired by the data protection or privacy connection earlier. What do you think about this idea of a fairness by design duty, or some kind of positive duty for traders to be fair, including in the way they design their services, but also in general? So any thoughts on that? Would that be useful in the context of digital vulnerability, or do we have enough vague, general, principle-based clauses that we should look elsewhere? What do you think? Thank you.
Thank you. Mattea, can you start with answering? We have 4 minutes, so 1 minute for you.
Yeah, good point. I'm one of the 2 academic advisors to the project with Hans-Rutte Neuke, so I think that was also the idea. I support it, so I think it's a very good idea. I think it's a very good way forward to actually use technology to protect consumers, to have this, as you say, positive approach. I think it's same as, I think it was you who mentioned we don't talk about digital vulnerability, we talk about digital fairness, exactly, to be with this positive approach. I think I agree with this, but just we need to be careful how to design it. So.
I don't know. I have also already said in my presentation that I agree with that proposal because, with more transparency, of course, you achieve more fairness, and there are, as you said, we should acknowledge that there are traders who want to be fair, but what they need are practical guidelines, how to do it. What they do in practice is that they simply look at the other's website and copy-paste their terms and conditions, which are usually not fair or transparent enough. So, of course, there are those who do that on purpose. There's always a question whether there's intention or there's simply a lack of knowledge. I would always say there's a combination of both. So we need to work on both aspects. And so we need to also offer something to traders in order to achieve this fairness. So I completely support fairness by design. There are, of course, some technical and practical ways how to do it with the help of digital technologies, but as I said, there have been so many work on it, and we are proposing our new proposals in chapters. So,
can I? Sorry, I also have something.
What Gian Claudio, I do agree, but it is the case that consumer law has its own doctrinal structure, and all consumers are weak. And then there are some consumers who are vulnerable. And we need to make sure that we translate whatever other people are saying in those languages, because or we change that language, because we decide that everybody else is speaking in another way, so consumer law has become an outlier. Or when we translate it into consumer law lingo, we need to speak that lingo.
I think weak consumer is something that we should get rid of. Because it's a very, just generally, because you mentioned it, because it also means that it's like a personal issue of the consumer, and somehow it doesn't really convey the structural problem. But, well, okay, just my 5 cents, unsolicited 5 cents on what you just said, to talk about fairness by design. So I'm not really sure what it means. I feel a bit like I'm now being the devil's advocate here. What does this mean? To me, it sounds like let's force companies and somehow, because it sounds good if we like incorporate them and then they don't feel left out and we are so into the market and so companies still feel free what they're supposed to do. But then in their actions kind of telling them that they have to be fair and take into the account of the other, I find this is going to be super difficult to monitor and also conceptually difficult, because I think most of us here agree that there is a specific model of fairness, just like a specific model of justice. Hans Miklitz, being the elephant in the room here, is being adopted by the EU. So that is very related to market, to internal market, for all competence reasons we know. But I'm not sure whether this will really help anything in the digital sphere. We're just creating more monitoring problems, and I think it's a bit beside the point. And it will not be able to, it will not be able to make us do away with the possibility of prohibitions. I think it's actually easier and maybe less costly, if that's an argument, to just rule out stuff that we think are unfair, instead of involving the companies that, let's face it, all have the same objective, which is to sell more of some product or service, which is by nature not the same interest that consumers have or that a regulatory body should have, right, that is concerned with fairness. It's just about what do companies want is diametrically opposed to what consumers want, unless I am convinced that I need this product right now. But this is not a natural coincidence. We are manipulated into this. So making companies in charge of shaping this fairness model, I find that problematic. Sorry if I'm...
Okay. I would like to thank our speakers for sharing your insights with us. Thank you once again. And now we have 20 minutes coffee break, and then we will start with the last panel today. Thank you very much.
That's a very hot mic. But yes, I'm delighted to have the privilege of chairing the last panel. As you can tell, I am not Tatiana. Some of you may have guessed that. But I was honored to ask to fill in. My name's Craig Conniff. I'm a professor at the University of Virginia Law School, so I think the only American you have the misfortune of having up here for the conference. And I hope that you don't judge the rest of my country based on the job I will do here. You can also tell I'm very relaxed, you know, dressed for the last panel and dressed for where I come from. Anyway, so without further ado, I will go ahead and just introduce our panelists, and we'll embark so that we can wrap up and you know, have a wonderful evening together, which I know has been arranged for us. So we have some wonderful speakers today. First, we have a joint presentation by Catalina Goanta, who's an associate professor at the University of Utrecht, and Jerry Spanikis from the University of Maastricht. Then after that, we'll have Iris Benner from Queen Mary University of London, followed by Piotr and Katarzyna. I apologize, I don't want to mangle your last names, from the University of Krakow. And we'll have Isabel Wildhaber, who will close us out. So without further ado, we're going to keep the order as it was in the program because for technical reasons, as you just found out. So if you want to go ahead, I'll be giving 2-minute warnings. Just one note, Iris has to leave a little early, so if at some point you see Iris leaving, just so you know that's the, okay, please, go ahead.
Great. Yeah, thanks for the introduction. Thanks for the invitation. It's so good to be here. Apparently, we have the panel with the many first-timers or one-timers. I think we have the only US person. I'm the only computer scientist. I don't know where Giovanni maybe is. Okay, we have more. Great. So, yeah, we split the presentations in 2 parts, and you might suspect which part each of us is going to focus on. I'm going to describe the first part and talk a bit about recommender systems, how they work, and also present some examples of research, right, measurement research on specific phenomena which might involve consumer vulnerability, and then Catalina will take over presenting the legal aspects. So on social media, right, we have lots of discussions about personalization and recommendation. And while they are similar, of course, there are differences in the sense of how exactly they will work and what they entail. And I think also hearing the discussions today, it's kind of important to know what is behind this terminology so as to know what you want to regulate or perhaps what exactly you want to measure, let's say. So with personalization, we mean exactly the modification, alteration of content. Could be a newsfeed, could be a price change, could be content change based on some personal characteristics. And of course, personal characteristics can be anything that can relate to individual. On the other hand, recommendation, which could be seen as a form of personalization, is exactly this reordering or filtering of items. Again, could be social media posts, could be commerce items, anything that can be ranked, based on the behavioral profile of a consumer, usually using historical data. And then these cover, again, the algorithmic part, as we call it, which is just one side of the story. If you are following, for example, the Twitter files these days, the Twitter recommendation algorithm is public. You can just go and download it. Probably you won't figure out much about what exactly you are going to be recommended, just because there is no information yet about what kind of data they are using. So the other part is exactly what data is going into either the personalization or the recommendation. And here we have like explicit data in the sense of previous likes, ratings of products, items, content that is relevant to your profile, and could be any kind of implicit information, which also perhaps the thing that is most intruding in the sense of might be video watch history, how many seconds you watched on a video, or which items you clicked, which items you viewed, right? Everything can be combined. We are going to talk, at least in our presentation, our paper, a lot about YouTube recommendations. So we figured out that it would be nice to also explore a bit more specifically what we mean by recommendation, I guess, in YouTube videos, and will come up also in some example studies we have later on. And again, here, if you see the figure, which is from a paper describing the YouTube recommender system, again, you see that we have the blue parts, which could be exactly the algorithmic curation, where I have the candidate generation, which videos perhaps I would like to show the user, and then the re-ranking of this, so as to go exactly from the hundreds to dozens. For now, and for good reasons, we cannot see 1 million videos at a time. We need to see only 10, and then we see the rest in maybe more clicks. So it's important to have this re-ranking procedure, and then the user history and the context goes in order to determine what should be the ranking. And you see this blue source below, which comes in and takes into account any kind of other candidate sources. It could be also external information, it could be ad information or anything else, which will affect the ranking, along with the video itself, right? The video features, the video characteristics. Okay, so given this background, we have picked two papers from the computer science realm to explain also, what we do in computer science in this domain. So, because again, I heard a lot about today, consumers are vulnerable, and I guess at some point we will discuss it, that we need to know how vulnerable they are. So in computer science, we have this saying that whenever you make a claim, either you will prove it with your experiments, or you will cite previous work that does it, right? So we don't write that much about opinions. So what I want to say is that if you're going to make an argument that consumers are vulnerable, you need to be able to prove it. In this first paper we have included here, we see that they are studying exactly YouTube conspiracy theories and how monetization takes place there. And again, it's a measurement study, meaning that, I don't expect you to read the abstract, but what I want you to focus on is that there are almost 200,000 ad impressions from more than 6,000 advertisers on YouTube. And the idea is that, okay, the authors was, let's check the conspiracy channels against some other general YouTube content and check what happens with the ad impressions. Are they more, are they less? Are they different? And the first finding is that there are way less ad impressions on the conspiracy videos, which is one finding by itself. But also what's very more important is that the content and the type of ads that are being included in such video content. Right, so again, as I showed before in the recommendation, there go some characteristics about what is the video about, and that will determine perhaps what ads you're going to be shown. If you see here, we highlighted the fact that deceptive, or let's say predatory ads account for, let's say, 50% of all impressions in the conspiracy channels, which is only 1.4% for the control group, so the general YouTube. And if you're wondering about the content, what authors found is that, you can have from the get-rich-quick schemes, essential oils for immortality, I guess everybody's interested in that, or 5G-proof underwear, right? So here there is the question about consumers that are on social media in order to, and maybe they are more prone to conspiracy videos, for example. They're also prone to all these kind of different ad targeting just because of the content they are consuming in that sense. So there is like a kind of a double scheme of how we are targeting, how these specific people are being targeted. There's a specific category here as well, which includes like financial ads, and include all this kind of self-help business and finance ads, and they have been, again, accounting for 11% of the conspiracy ads, conspiracy videos, and the ads shown there. And that was like way less than 1%, way less than that for the control group, which shows that, the ads targeting consumers that maybe are consuming different content that maybe, let's say, the general population. They are really also shown different ad content. So this is kind of one paper. The second paper I want to talk about before I hand over to Catalina is about exploring, let's say, pathways on YouTube, specifically radicalization pathways. You might ask, okay, what is a pathway? And it's like when you're on YouTube and you start clicking and then you end up in the next video, you are following a path, right? So, and the authors wanted exactly to explore if you start your navigation on YouTube from a specific, let's say, channel, how possible is it, and with many, maybe with how many clicks, let's say, you can end up in some radical channel. Again, the radicalization here is that's a study case. It could be applied for all kinds of other contents, right? If you want to explore, for example, the conspiracy channels we explored before, or any kind of other, I guess, harmful content. And they had, let's say, more than 300,000 videos from almost 350 channels in different categories, like media, normal, let's say, videos, if we consider media as normal these days, the alt-right and the intellectual dark web, which are considered communities, let's say, not radical, but let's say still a bit on the fringe spectrum, and then the alt-right channels. And what they did is that, first of all, they explored the more than 72 million comments there and wanted to find, okay, is there an overlap between the two communities? And here I'm showing you some figures. Again, I don't expect you to go over the figures, but what I want you to understand is that in the first part, in the upper part, if the lines are close together, it means that these communities have sharing the same, let's say, type of people and same commenters, in the sense that the green is the alt-right, and then the red is the alt-right, and then if these lines are close together, it means that the people commenting in the channels are the same, so there is some overlap between the communities that are commenting on the alt-right and the alt-light and so on. And the second figure shows exactly what is the evolution of when somebody comments, let's say, first time in the alt-right, and then where they came from. And again, there are the lines that are going up, which means that there is some probability, let's say, that if I started my navigation video in the alt-light, then if I do some clicks, there is a high possibility that I end up in the alt-right channels. I leave you with this, which shows exactly if the recommendation engine, right, which is exactly the algorithm we're discovering, enhance these transitions. And here there is a slight detail that we have no data, let's say, to do this in a personalized way, because, of course, personalization works in more convoluted ways on YouTube. I would have to know your profile in order to assess exactly what content you are being shown. So with this note here, again, we can see that it is possible, more possible, let's say, to go in 1, 2, or 3, or 4 steps, let's say, from alt-light and the intellectual dark web communities, but it's also still possible to, again, from these channels to navigate easily to the alt-right communities. So it is possible to find this content in some clicks. So this shows exactly how maybe the recommendation engine will enhance such transitions. Yeah, and I think with that, I leave it to Catalina for the second part.
Thank you very much. Also, a very warm thank you to Alberto for his absolutely flawless hospitality here and the invitation to participate in this conference. It's really great for me to be able to also share Jerry as a common good because he's a computer scientist who has been doing research with lawyers. So please do reach out to him if you have any additional questions, particularly on recommender systems after the conference. I'm going to take it a little bit back to the legal discussion. So if we look at recommender systems, and particularly on social media, I ask myself, and this is a direction in my research and the research that we have been doing with Jerry, what if we take content moderation as a form of, an expression of consumer protection? So far, content moderation has been something that we have spoken about in the context of, disinformation and freedom of expression and perhaps media protections. But what if we actually look at consumer protection and we try to use current architectures to identify, so therefore detect vulnerable consumers, and try to facilitate perhaps creating a better and a safer environment for them. So in this context, I also want to take a step back and tell you a little bit more about content monetization. So we have social media. We heard earlier today this idea of, going on Instagram and kind of expressing yourself on Instagram. The reason why we are in this economy where everyone is gathering data is also because the internet has been such an innovation that nobody really knew where it was going. It was a very curious innovation. And also, very importantly, consumers wouldn't pay for digital content, in the 90s or in the 2000s. So this is where different models of web or content monetization have emerged. I want to talk to you a little bit not about content monetization in general, for instance, from the perspective of Google. I think we also have Google in the room, so perhaps at some point we can discuss that in the Q&As. But all of these channels in the YouTube study that Jerry just presented, these channels are riding the wave of monetization from a user perspective. So what is different today than perhaps 15 years ago? The veil is coming off. The gloves are off. Social media is a shop. You have microtransactions. You have a lot of digital content that people pay for. It is a place where you go for services. It is not this, or at least solely, the ideal of I'm going to go there, it's the public square, and I'm expressing myself. In this context, we can see some different business models, and I don't want to emphasize all of them. This is just a kind of an overview that I keep on updating. Initially, together with Isabel Wildhaber, who is on the panel today, we have been mapping some of these business models, and they generally expand throughout the years. But I want to refer to two particular business models that were very much present also in the YouTube study. So, for instance, the ad revenue, the fact that YouTube is going to pay a creator or a user who is generating views. So that was the eyeball, the attention economy. If you manage to generate views on a channel, then you can get money indirectly from advertisers. But you can also sell stuff. So you can sell the 5G protective underwear. And that is something that happens off platform. So we have here two layers of vulnerability that were explored with this example of the YouTube study. The fact that we have social media content that we could argue. I'm not going to go into any conspiracy theories in particular in case we have any flat earthers in the room. But the thing is that you have a specific type of content. The question is freedom of expression on the one hand, on the other hand, science. It's a very big societal debate. And also, if we're speaking about social media content, the legal framework is very difficult and very sophisticated, and also very difficult to interpret, because there will be a very high threshold to determine some content as illegal. Can you really say that someone who is presenting some space lasers theories is actually engaging in illegal content? Perhaps to the extent that that is a disinformation campaign, to the extent that that is an information operation, perhaps there can be some malicious intent behind that, and perhaps then that is illegal content, also according to the Digital Services Act, but perhaps it is not. However, if we just look at the off-platform goods and services, so if we look at the examples of the different types of goods, things are a little bit clearer. They're a little bit closer to home for us consumer scholars, because if you're going to say this elixir gives you immortality, and it doesn't, we have a consumer law problem that is very concrete, because that is either, for instance, perhaps if we're speaking about an illegal product, maybe a product that has been recalled through SafetyGate, then we have a very clear prohibition from selling such products. If we have materially inaccurate claims, or even in the situation of conspiracy theories, that there are certain risks, that Alex Jones would say you have to buy these vitamin pills because otherwise the government will make you gay, So if there are these kind of risks associated with behaviors, then also the products are being portrayed in this very kind of undue influence way almost, right? So that's why if we don't fall under the practices on the list, on the annex of the UCPD, we for sure fall under the umbrella of the aggressive practices, because here we're talking about really widespread scams. And if we don't speak about scams and about people who really believe that a specific product is going to confer certain medical benefits, then perhaps we can also just draw back on Article 5 of the UCPD. So the idea here is to consider the fact that we have instruments in consumer protection that we can use to provide content moderation standards and to use the architectures that platforms have been providing all sorts of targeting advertising support with for their business partners to perhaps use that in consumer law enforcement. How would that look like? We see we can identify with this web measurement study. It's not a behavioral study. It doesn't change when it comes to perhaps, I don't know, different samples from different countries. We have, we can draw facts from what we see on social media platforms, and these facts show we have these particularly potentially dangerous products. Consumer organizations and consumer authorities can investigate them carefully, and then perhaps they can ask even in more automated ways for the deletion of the specific channels or for the deletion of the content where these products are being portrayed. I think, yeah, one thing very interesting about Article 5 is that it also has this credulity aspect that I think in the context of conspiracy theories could be interesting to consider. And lastly, just as an example of enforcement that is happening right now in this field, not necessarily very automated enforcement so far, but the DGCCRF, the French Consumer Authority, is already prohibiting with its new influencer law, prohibiting practices such as the advertising of goods that are going to be considered therapeutical, but then actually in actuality they are not, and they are already taking down these kind of goods. So the French authority is creating a little bit of a revolution in advertising. We can see that influencers in France are reacting very, very adamantly to that, also in positive ways, but this is an example of how things can look like if we consider consumer protection as a source of content moderation. We look forward to engaging with you in additional questions. Thank you.
Thank you very much for that. And from now, we'll move from consumers generally to the consumers of credit in Iris's presentation. Please go ahead, Iris.
Okay, so first of all, thanks so much, Alberto, for the invitation. I'm really honored to be here. So my presentation is on digital vulnerability in the consumer credit sector. This is a really important topic because there has been an exponential increase of digital and financial products, and the consumer credit sector has been profoundly transformed by the digital transition. And as a result, we can see new lenders such as peer-to-peer lending platforms, and also online sales by traditional providers has increased. And related to this, we can also see that the fintech companies use increasingly artificial intelligence and big data to assess creditworthiness of consumers. And this raises questions with regard to personal data and also how much consumer protection we have here in this kind of practice. And overall, this development means that there has been an increase in financial and digital vulnerability. And some reason for this is, first of all, that there is an increase of short-term high-cost loans that are sold online, and also the pandemic has further increased vulnerability of consumers. In my presentation, I will focus on some of those topics, and it is divided in 5 parts. First, I will provide a brief overview of the advantages and disadvantages with regard to digitalization in the consumer credit sector. Then I will touch upon the increase of crowd lending platforms and how this impacts on consumer protection. And then I will briefly also discuss the increase of artificial intelligence to assess credit, to assess if consumers are credit worthy. And then finally, I will evaluate the existing credit regulation in order to see if it is suitable for
the current environment. So let me start with providing you a little bit of context with regard to digitalization of consumer credit. There are several benefits for consumers. First of all, there is a better digital access to information. Consumers can now compare different financial products via the website. There are more choices and funding sources than before, so that this can increase consumer integration, provide them with a stronger purchasing power and invest in their future. And finally, we can also see that there is faster and easier access to credit. Now, there are also obviously some downsides. First of all, with this fast-paced environment, there's less time for reflection, and that means that consumer might be incentivized to purchase products using credit that they cannot afford. And then also there are more complex products online, and that makes the decision really difficult. And what is special about the credit sector is the contracts are really long-term. So for instance, a mortgage contract can have a duration of 20 years or 25 years. So therefore, this decision-making is really crucial, and sufficient information is key here. And then finally, there are some regulatory gaps, just because the regulator doesn't manage to keep up with this fast-paced development. Here are just some slides that show the impact of digitalization on market players, and we can see that the commercial bank have significantly decreased, and at the same time, there's a huge increase of online banking penetration in the EU. And that means that consumers have less possibilities to interact in person in order to get advice about certain products, and have to rely more and more online in order to access credit. And this can lead to consumer and digital vulnerability, because recent reports have shown that there are aggressive online selling practices that lead increasingly to high-cost short-term credit and can lead to over-indebtedness. And in addition, credit is often granted without actually checking affordability. And recent statistics have confirmed that many countries are therefore witnessing a marked increase of private debt. For instance, here you can see there are 10 to 33% of EU households who have arrears in mortgages, rent, or loans. And as a result, there's a risk of over-indebtedness, evictions from housing, and also exclusion from society. Now, there has been a lot of debate about this current development in the credit market. And for instance, Ramsey and Ferretti have highlighted that actually the EU credit regulation framework is not working effectively, and there is a need to adapt it, especially to the digitalization. And therefore, the EU Commission is actively assessing the current legal framework in order to see how the legal regulation can be adapted to the digital environment, and how can it tackle household debts. And so here key questions are, first of all, to what extent does the EU law cater for new kind of lenders such as peer-to-peer lending, and how do we ensure fairness and tackle over-indebtedness in the digital environment? Now, in order to come up with an answer, it's first important to understand how this increase of crowd lending platforms impacts on consumers. And here we can see that there has been a strong increase of those platforms. Here you can see the slide here, and these platforms are particularly focused on peer-to-peer consumer lending rather than peer-to-peer business lending. And what happens is that these peer-to-peer lending platforms, they use a digital business model connecting those who need money directly with those who can finance consumers. And you can see here how this works in practice. So usually the borrower contacts the platform, the crowdlending platform, and makes a loan application, and then the platform connects the private lender to the borrower and makes an assessment of the credit worthiness. And if it's positive, then as a result, the consumer receives a credit. Now, what is really special about this process is that the entire process is handled by the crowdlending platform without really that the investor, so the creditor, is connected with the consumer. And another really important development is that those platforms use a different type of creditworthiness test than the traditional credit providers, because they use big data to assess the affordability of credit. And here it's important to mention first Article 8 of the Consumer Credit Directive, because it requires financial providers to assess the consumer credit worthiness on the basis of sufficient information obtained from the consumer. And here the key goal is to avoid over-indebtedness. However, as you can see from this provision, it's really vague. And in addition, the European Court of Justice has provided really broad interpretation of this provision, which means that the creditors have a broad margin of discretion in the determination what type of information needs to be assessed for this creditworthiness test. And the fintech companies, so the P2P platform, focus, as I said previously, on big data analytics as a substitute for classical assessment. And they use all types of data, such as consumer shopping, internet browsing, social media, and they use this data to mathematically then determine the credit risks of consumer. So it's used as an alternative to what the traditional lender will apply for the assessment. And this raises question, first, how effective this creditworthiness test is. Does it really help to avoid over-indebtedness, and is it fair? Now, in order to see in which way the consumer credit regulation tries to tackle consumer vulnerability, we have to assess the EU Credit Directive of 2008. And it has two key objectives. First of all, it aims to promote a single credit market, and it also tries to provide a high level of consumer protection. However, it has only a very narrow scope. It only applies to credit agreements ranging from 200 to 75,000 euros, and excluding also many other types of agreements, such as mortgages or overdraft facilities. What does it mean? It means basically that all those agreements that fall outside this the scope, for those ones, there's no consumer protection with regard to credits. And this has been criticized because it means that there's no protection from over-indebtedness. And a second feature of this directive is that it focuses strongly on information disclosure. It means that the directive requires that the consumer receives detailed information already at the advertising stage and then also at the pre-contractual stage. And the idea is to render the consumer aware of the risks and condition of the contract. In addition, it contains some key rights that are particularly important in the digital environment, which is, first of all, the right to withdraw from the credit agreement within 14 days. And this is essential because, as I highlighted before, the credit provision online is really fast-paced, and this right provides the consumer with a cooling-off period, as it's called. So it provides the consumer with the possibility to reassess, is this really suitable, is it necessary, this credit, and he can withdraw if he realizes it was really more instinct-driven than a good decision to make for the future. And the most innovative part of this directive is the focus on responsible lending. And there are two key parts to this. First, the duty to advise the consumer, and second, the obligation to assess the creditworthiness of the consumer. And here, it is important to see if this also applies to P2P lenders. And however, there are some limitations to this regulatory framework because, first of all, what has been criticized is the focus on consumer information. Because here the consumer is seen as a rational decision maker, while in reality empirical evidence shows that individuals are not always able to take rational decisions, especially online, and are often manipulated by advertising. And this affects naturally specifically also vulnerable groups, such as the elderly, the young, the uneducated, which also might lack digital knowledge. And hence, there is an information overload, and therefore there should be a better, more focus on quality rather than quantity. And the key question is, how does this apply to P2P lending, to online lending platforms? And here, it is interesting to notice that those lending platforms are mainly regarded as credit intermediaries. However, they do not impose certain creditworthiness assessment on those platforms, because this is really only addressed to the creditor. And this is a key problem, because a key reason why we have over-indebtedness is that credit is provided for those who cannot afford it. And therefore, I would just like to finish here with some recommendation for regulatory reform that would be necessary to tackle digital and financial vulnerability. And that is, first of all, to provide a broader coverage of the Consumer Credit Act. And that means that this would also cover the crowdfunding platforms, that they have to assess effectively the creditworthiness of consumers. And then there is also a need to clarify the creditworthiness assessment. Currently, it's too vague, and it lacks somehow deterrence for the providers to comply with this requirement. Thirdly, there is a really essential need to enhance digital and financial literacy of consumers. And then there is also a need to adapt the regulatory framework in order to ensure fair treatment and good conduct. These are recommendations that exist at the international level. For instance, the World Bank, the UN, and also the OECD have recommended that there is a need for best practices in credit regulation, but this hasn't been implemented yet, and that is essential in the online sector. And then finally, what is essential is also to provide debt advice services and personal insolvency procedures for those consumers who are highly indebted, to allow them to get a second chance and to integrate again into the economy and society. And that brings me to the end of this presentation. Thanks very much for your attention.
And I did promise Iris that we'd be done by that she'd be done by 6. So, but do you want to Q&A at dinner for Iris? Yeah, is that right? Yeah, or do you want to do 2 minutes now? Okay, totally fine. All right. So Iris will be available at dinner, and so thank you very much, Iris. So moving on then from consumers of credit, we now move on to consumers of other financial products like insurance. So we turn now to Piotr and Katarzyna.
Oh, yes, of course, please.
My presentation, how do you...
So good afternoon, dear ladies and gentlemen. We are very pleased to be able to talk to you about some aspects of vulnerability in the insurance sector. I mean, we, by my colleague Katarzyna and our colleague Ewa Cichowicz, who deserves to be with us. She did the bulk of the work as an economist, but sadly could not join us today, but played an important part in this project. So let me tell you briefly what we will be talking about. So it will be about the data, some technical issues of law, and then a little bit about the beauty of Ferrara. Let's move on with the first part. So reversing a little bit the order of how we approach the vulnerability. I mean, as a lawyer, I thought some years ago, reading works that pass sharp judgments on empirical reality, like Ben-Shahar, the failure of mandated disclosure, shall we not reverse the order and look how the consumers, buyers perceive the market, and then only consider whether rules are well designed and whether they work. And to this end, we have outsourced a market survey to a professional firm who examined the representative sample of Polish society with respect to insurance products. The survey was complex. Some of you in the audience have done us a great favor by checking some of the language versions. It ran online in several languages, but we are talking only about the fully representative sample which was handled by a professional firm. And what came out is fairly interesting as a preliminary empirical stage in looking at the market, so the sectoral view, as Professor Poncibo said in the morning, and then perhaps taking this as a baseline for hypothesizing about whether some legal acts might apply to certain forms of market failure, since UCPD and so on. So these are small steps in getting to see the big picture. So the first, I hope you can see it, sorry for the typo on the left, the first piece of information we get that there is a relatively high level of acceptance among Polish consumers for, let's say, for the digitalizing the market, mainly the offer and the conclusion. So there are no standout either on the positive side or on the negative side results. More specific data are available here. So our questions concerned the familiarity of basic concepts of the digitalized market. So going from the up left towards down right, you see that comparison websites are very well known. They might be agents, they might be brokers, it depends. It's different in different jurisdictions in Europe. In Poland, there are agents or multi-agents, but they are very well known. Many consumers use them. VA or robo-advisors, they are actually simple chatbots because underwriting decisions as it stands now are taken exclusively by people, I think in most, if not all jurisdictions in Europe. So it's a melody of future. Also, automated claim procedures are very well known. And then usage-based insurance is only emerging, so most consumers are not familiar with it, and telediagnostics even less. And then what is interesting, and I think this will bring us to the specific part that Katarzyna will be talking about, namely what consumers might be concerned about when they approach the digitalized channels. Yes, and I see it as a kind of empirical basis for seeing typical patterns which may be then used in concretizing open textured VAC provisions of UCPD, unfair terms, directive, and so on. So certain failures that will allow courts to make a consistent case law. So what we see, the consumers see as advantages. So speeding up the process of buying a product or concluding a contract, simplifying, expanding the offer both in terms of an offer by a firm and also individualizing, personalizing products. So let's say consumers can be won for that type of channel, which implies so high level of confidence. So they may be overconfident, they may be tricked. Yeah? So this I would say opens up a way of looking at this in terms of legal acts that may be applicable. And then a negative view, what might be seen as a risk when dealing with digital channels. And to begin with, as a contract lawyer, a consumer lawyer, you look at it and you say, these are actually public law concerns, namely cybersecurity, data security, or they are afraid of providing too much data. So these are not things that contract lawyers or consumer lawyers will immediately think about. These are, I would say, more general issues of cyberspace and digital economy. And I think it provides us with a nuanced view that not all issues that we usually debate in contract on consumer law are perceived as most prominent by consumers. Yeah? So now we move to a more technical issue of insurance law. Insurance law is an outlier, is Kafkaesque, regarded as tedious, complex, bleak, and it has many tricky issues regarding the delineation of concept of whether a policyholder is a consumer. Katarzyna will show that the application of several directives may be possible, but there are open questions to it. So Katarzyna will provide a hypothetical case, and we combining two transactions. Now over to you.
Yeah. Need the mic. Okay, so I guess you can hear me well. And I would like you to meet Prospero. Prospero is a Polish citizen. He lives in Poland, and there he surfs the net. And one day he is tricked by a very persuasive, personalized advertisement into buying a phone with an insurance. He will use that phone for both professional and private purposes. Well, the problem is that Prospero thinks that there is only one transaction involved, one contract, and he's pretty sure that he has the status of the consumer, so he can benefit from the protection of the consumer. However, when you look at his legal status, you will find that depending on which aspect of this transaction is considered, different definitions of consumer will apply. And these various contexts, and in these various contexts, he will have different statuses. He might be an entrepreneur of a very special class who will benefit from the consumer protection. He might be an ordinary consumer, but also he might be seen as a consumer who requires special protection, and now the problematic thing, due to digital vulnerability. So if we look at the sales contract that's there, under the current directive, we've got the definition stays the same of the consumer, but the problem is that in the Recital 22, we've got stated that member states are entitled, are free to determine that in the case of dual-purpose contracts, where this contract is limited, is concluded for both professional and private purposes, and the professional do not prevail, then this person can be treated as a consumer. With this, we come up with a conclusion that probably under the directive, if the member state does not go to broaden the scope of the definition of the consumer, then within the scope of the directive, we have a very narrow definition of the consumer that does not include dual-purpose contracts. So under the directive, our poor Prospero will not be a consumer. However, our Polish legislator had a very smart idea he wanted to broaden the scope of application of consumer protection, but in a different manner from the one that was foreseen by the EU legislator. So he said, okay, the provisions concerning consumers shall apply to, and that's nice, to a natural person who's concluding a contract directly related to their economic activity, where the contents of this contract indicate that this contract has not the professional nature for this person. That means that if I'm being a Prospero, if there is a Prospero and he buys a phone, he will use for his private purposes and professional purposes, he'll be treated as if he was a consumer if he is not selling and buying phones within his business activity, which is a bit, well, for some, absurd. The problem is that if you look at the insurance contract, here in the directive, in the IDD, we do not have the definition of a consumer in the Act, so the acquis communautaire, well, it covers dual purposes contracts in general, so we can say that here, yes, Prospero will be treated as a consumer, he will have the status of the consumer. From the Polish perspective, we have the same problem, and especially if Prospero only looks at the Polish Civil Code, because our code has this narrow definition of consumer, which we have to interpret in the light of acquis communautaire to broaden it. But that's not all the problems we face. We've got the unfair commercial practices framework, and here in the directive, dual purpose contracts are not mentioned, though it is argued that this directive covers dual purposes contracts. The thing is that here the focus is different. It's on the special protection of consumers who are vulnerable either to some state they're in, like the static category, and this is what's being said and what's being accepted broadly. And there is this lovely guideline on the interpretation and application of directive, which was already on the board at least twice today, which says that the concept of vulnerability is not limited to the characteristics listed in Article 5, Section 3, but it also covers context-dependent vulnerabilities. And there is this idea that the average consumer can be even a single consumer. The thing is that they also underlined there that the current concept of vulnerability under UCPD is dynamic and situational, which might bring us to the conclusion that it already covers digital vulnerability. The problem is that if we look at it, we see that this multiplicity of concepts of consumers and the introduction of the dynamic category of this digital vulnerability significantly reduces legal certainty. There are high compliance costs. And the problem is that expectations of persons, both the consumer and the business, as their status, they are different. They think that they have some status, but they don't. They think that they have certain obligations, and the legal reality turns out to be different. In addition, this trend towards dynamic protective structures, such as digital vulnerability, may mean that the traditional consumer protection mechanisms begin to change their character. And they lose their objectivity and standardization. And those two things were something that made them, in the beginning, relatively effective and easy to apply for everybody, including this poor Prospero. This begs the question, should we really introduce a new individual protection mechanism on the EU level? Something that's so similar to vice of consent we all have in our civil codes. The premises of both seem similar. They're individual. And so they're equally difficult to prove. The thing is, like, the core difference is there will be no causal link. And should we really introduce individual protection mechanism on EU level just to get rid of the causal link? Thank you.
Now, this year, the EIOPA, the supervisory body at the European level, drew an interim evaluation of the insurance distribution directive after 5 years, and the conclusion was sobering. I mean, in a line that because the insurance sector is fairly conservative, it's far more conservative than, let's say, fintech in general, and much more conservative than the banking sector. So insurers look at what happens elsewhere and only then adopt certain provisions or solutions. So I would say the global risk to clients is probably lower than with respect to banking products or investment products. But what is interesting is that the individual risk in a specific case may be high, because if you purchase an index-linked life insurance, which will run for 10 or 20 years, your transactional decision may be flawed. So that's why the field is not entirely free of such concerns yet, even given a fairly low level of digitalization. So to give you some data, for instance, on the German market, it is reported only 3% of life insurance products are bought online. So still I would say, in-person distribution prevails, which, looking at this in a sectoral way, is a good way to see how the market gets transformed and how the digital channels become more prominent. So this is perhaps a lesson from a fairly conservative sector. But of course, this concerns the stage of distribution and, let's say, product sales. But I would say dangers are the same as far as advertising is concerned, because there are few insurance-specific tailored rules regarding advertising. So what is now being discussed is fine-tuning the existing legal framework, in particular making certain requirements of conduct on insurance distributors, which is a very broad notion, including both insurance and all types of intermediaries, making them more specific to eliminate most typical risks of the contracting process. Having said that, I'm slowly coming to the end of our academic part of the presentation now. Here I will perhaps just we'll be acting as an agents of all our community, of those who are outside of Ferrara. It's a little thank you to the organizers. I have one question. Look above. So there is a Polish poet, very well known, Zbigniew Herbert, wrote a poem about Ferrara. That's why I'm familiar with Ferrara from 15 years old. And this is not his best poem, but it gives you a taste of how Herbert writes, and the collection of poem is entitled Rovigo. So I have met some Italians who I told, I'm going to Rovigo. What is Rovigo? Well, every man of letters in Poland knows Rovigo thanks to Zbigniew Herbert, even if not all Italian citizens know there is such a beautiful city not far from Ferrara. So Ferrara is very well known in Poland, and we are very honored to be here. So thank you very much, the organization team. This brings us to an end. Okay.
All right, so it's been quite interesting because we've been focusing on consumer-related issues, beginning with advertising to consumers in general, and then the selling of risk-based financial products like credit and insurance, right? And what's interesting is the definition of a consumer that we saw in the Polish law, right? So the idea that you are purchasing a product not related to your own professional activities. But what we're going to see very much is a flipping of the script. Very much surveillance and vulnerability within someone's professional capacity, falling very clearly outside that definition under Polish law. And so we're going to be looking at another empirical study, this time from Switzerland, looking at employees. So take it away, Isabel.
Yes, hello. I realize that you are all really tired by now, so I'll try to keep it quick, but I do think it's a really important topic because we're all somehow employers or employees in life. So I will present you some of our findings in a research project that was funded by the Swiss National Science Foundation on employees and digital tools that are used at the workplace. So there's all sorts of different tools that can be used, and the most extreme that I have heard of and that a company told me about is the smart toilet that you see in the middle. In the smart toilet, basically, when you go to work on Monday, your employer will already know whether you've had some cocaine on Saturday evening, whether you have whether you're pregnant, whether you have diabetes, so he can pretty much analyze you. Now, some of the companies that we have interviewed that actually use this in certain continents told me that they would never use that in Europe because of GDPR. And so that's whatever can be said about GDPR, that I thought it does protect us from certain tools that maybe I personally really wouldn't want to have at the workplace. So the whole idea behind using tools at the workplace is to be profitable. It's basically business motives. You're doing what you used to do otherwise beforehand, now with more advanced tools to be more profitable. And that can constitute a new form of surveillance. Last week I was at a digital festival, a crazy conference in Berlin, the Republica. It has 20,000 people who go there, and in the keynote opening it was Meredith Whittaker, who is the president of the Signal Foundation, the one who also has the Messenger, and when asked what she thinks is the biggest risk of artificial intelligence, she very clearly said it's worker control. So I think, even though I tried to keep this short, that worker control or surveillance really is a big issue that concerns us all. When it comes to terminology, I have seen all sorts of terminology, and there doesn't seem to be clear cut definitions. Some people call it new surveillance, people analytics, HR analytics. Since the last half a year, I find that oftentimes people use algorithmic management as the expression, the terminology. Is it really always artificial intelligence? No, mostly not. Most companies, they brag with their AI tools, but then when you go into it and you dig, then really most of them are not AI. So I will quickly tell you why I think employees are especially digitally vulnerable, give you some numbers. We found, based on interviews and our empirical studies, regulatory gaps. We looked at Swiss law, but the same gaps are in other countries as well, and we made some proposals. Now, why are employees so vulnerable? We always had some form of surveillance, and some decades ago, maybe it was just your neighbor in the room beside who always observed what you were doing and went to the boss and said, he takes a lot too many coffees a day. So that always existed, but what's new now? We found in our study that it's the variety of data that's being collected, it's the interoperability between the different systems that can be taken together so you really become quite transparent, and the increasing analytical performance of the systems. So that really does increase the digital vulnerability, and employees are as such already in a weaker position within their contractual relationship, which is why most countries have quite limited contractual freedom when it comes to employees. Our project basically consisted of 3 parts. First, we just wanted to find out what kind of tools there are out there. Then we went into a quantitative survey where we wanted to find who has what in Switzerland and what do they use not the smart toilet, as I told you. They're rather innocent things, but all companies use them. Then in a third year, we did 100 interviews in 5 big Swiss companies. And these qualitative studies we haven't published yet. We're right now preparing to do that. We found that, we basically found that all tools belong into 5 categories, and then we basically looked at it in 2018 and again in 2021. After the pandemic hit, we did it again to find out what they're being used for, and you can see that a lot of tools are being used for retention and transition. So you want to see whether your employees, they update their LinkedIn and have a new professional photo, very nice, so they're probably about to apply somewhere else, and maybe you want to keep them and you give them a better offer to keep them, that type of thing. The second thing is performance management. You want to see how someone performs. And with that, you have to be sort of careful, because one example that sticks to my mind, you buy these tools kind of off the shelf, and they're not always adapted to your concrete situation. And we found a situation where one company, a logistics company in Switzerland, they bring parcels to people who do online shopping, etc. And their employees were always they always got evaluation, performs badly when they were driving 20 kilometers an hour, because the system found that that's too slow. But then later on it was found out they do that while they're on some crazy alpine street and it's all icy and they're trying not to fall off the road. But for years they had been punished for that, because the system was bought and it wasn't customized to the alpine streets. So here you can see that the distribution is basically, it's interesting for big companies. If you are a small family holding, then you know your people and you know if they're unhappy and about to leave. You don't need tools, and then it costs too much. So, but all big Swiss companies use them, and not just one, many. In the qualitative studies, we went into 5 big Swiss companies, and we did 100 half-structured interviews, and we always asked first the management level, how they deal with it, and then the concerned employees. And we found some interesting things. Most employees, for example, think their boss is still responsible, yet the boss kind of thinks, but it was the tool. So that was one sort of problem with it. There's no employee participation in the sense that you would really, in a democratic way, involve employees when implementing such a tool. The way it works is, I'm saying it a bit sloppily, but the way it works is someone from HR goes to someone from IT and say, "Wow, there's this really hip, cool new tool, wanna get it? Yes, wanna get it. Okay, let's not ask the lawyers because they're not enablers, they will just say no. So let's just not ask them altogether." And then in order to get feedback from the employees, there's this cool young guy with white sneakers. We will make him a power feedback user, so he will give us feedback. He's not very critical, but that's not the same thing as if you do a consultation procedure in a democratic employment law way, right? One thing that was important that we found, that communication and information is like the key, as always in life. Basically, two companies had the same tool introduced, and in one company, everybody went crazy and they weren't informed, and then found out, you know, so you kind of, that type of thing you read in the paper, you find a sensor on your desk and you freak out. In the other company, it was introduced in a good communication. Here we have a new tool. How do you like it? You want to have it? And then everybody thought it was cool. We're so digital. So the same tool was conceived in a completely different way. Also, what makes employees, because we looked at that trust aspect, you know, what kills the trust of employees. If you have a learning culture and you don't punish and you say, you know, we just want to collect this data in order to learn, then that's fine for most employees. But if you start sanctioning, if you start saying, okay, if we find this in your performance, there you go with a sanction, that's not going to go over very well. Now, there's a lot of regulations, of course, in any nation that will apply, and it concerns different topics. And there's no specific, in most countries, no specific regulations for analytics or however you want to call it, these tools at the workplace. So you basically use the normal rules, and then when you look at that, you find there's certain regulatory gaps. Because all in all, there's an increase in privacy harms, there are information asymmetries. Information is also an important aspect. I've talked about that with people, what they think. The managers told me in one company, we always inform, you know, we inform what data we collect, for what purpose, how exactly we use it. We're perfect, we're doing a perfect information. Then we interviewed the employees and they had no clue what's being collected, knew nothing, and we kind of thought, how is that possible? Then we found out the information oftentimes is just another PDF on the internet, and that's too much, no one's going to read it. So I kind of plead for, if you want to inform, it should be short, concise, understandable. If you're going to do another 60-page PDF, it's just going to be like terms and conditions, you know, when you buy stuff, or the crosses that you make when you buy something online, no one's ever going to read it. And that's why there were a lot of information asymmetries. Then you have a certain loss of human agency. What I find interesting is that we have all this, also in the GDPR, regulations for fully automated systems. These tools at the workplace, they're almost never fully automated. They're only decision supporting, not decision taking. So these rules for them don't apply, but yet we found in our empirical studies that no one ever overrides the support. So I would argue, does it really make a difference if it's supporting or decision making? Because in the end, who is going to override it if the system tells you to do something? And there is a risk of algorithmic discrimination. Now, we made some proposals, for example, in a data protection law in Switzerland for the Swiss government. Maybe some of you know we have a new Swiss Data Protection Act entering into force in September. And we stated that it's important that the relation to the workplace is necessary, that you don't collect someone's data like out of their free time in the evening, which some employers do. Then informed consent, as I told you, is kind of a difficult concept, it seems, for many reasons, but also because the information just doesn't arrive, because only 48% of employees understand what the employer tells them. And then there's a health and safety aspect, because 20% of all employers told us that they constantly observe behavior, and under Swiss law that would be illegal due to health and safety regulations. Then we also proposed, and I would propose that not just for Switzerland, but for many countries, that it's not just enough to inform someone individually. There also needs to be some kind of collective participation. It's not enough to inform that one power user with the white sneakers that you can give me feedback. You need to democratize it in a way. You need to really do this from an employment law perspective in a correct way, and that's not happening. That's just not happening in practice, even though you would have to. So we found that the involvement of external stakeholders in the design and use of people management tools is really low. So trade unions are not involved, representatives are not, employee representatives are not involved. So there's a lot of room to, I'm not saying it needs a regulation change, because most countries already have that, but it's not being done. And then we developed one last approach, because most tool developers, they don't want to really go into every single national law, especially since it's pretty much in a gray zone in these areas. So maybe it would be good to find a solution as a company if you want to enroll a tool, more of a transnational approach. And we kind of wrote a paper together with Jeremias Adams-Prassel, which some of you, like Catalina, knows. He's a professor in Magdalen College in Oxford. And the idea is to sort of do a business and human rights due diligence at the workplace, and just constantly monitor what you're doing and think about it critically. Because you're not going to basically check everything for every country, and that way maybe you can at least do a good procedure. So those were some of the suggestions we did. And I hope I gave you a bit of an insight. I also think one last anecdote until we're very close to our Prosecco. From a societal point of view, I found it interesting that, for example, by making logistics more and more profitable, we all shop online, we get parcels, you know, all of this is done by a navigation system that takes things into account like traffic jam and weather. And one employee from a logistics company told me, you know, I used to go in really remote areas in Switzerland, in the Alps, and there was this old granny, she is 90, and basically everyone has died, she barely talks, she's very lonely, and I would take an espresso with her 5 minutes a day. And I did something to the society overall for the elderly. But then with these systems, you have to be in the next place in 2 minutes, otherwise you get punished with this performance evaluation. So no more espresso with granny. And I mean, also from that perspective, we have to think how we want to work in the future, and whether as a society we want to go down that route that no one drinks with the poor granny an espresso anymore. So now I'll be done. I hope that was fine. We're almost done now. We're approaching a wonderful evening.
Yes, and I know we're all, I mean, the hospitality so far and anticipated has just been wonderful, you know, truly Italian style, which we don't have in the States. So, I mean, I'm really excited. But before that, I'm really looking forward to the discussion and the Q&A. So please, so yes, we have someone in the front.
Thank you, and I don't mean to stand between you and Prosecco. I think I was triggered by the space laser, flat earther thing. I have two questions, and it relates back to the name of this conference. We call it Digital Vulnerability in European Private Law. Now, before I ask the questions, I'm a lawyer in a room full of lawyers, you will forgive me. I will speak as an academic and not as part of my organization. So we take it the name of the conference, we look at European private law. Together with Craig, I might be one of the few people in the room not from Europe. We listened to Jerry, there's a lot of things to do with the click-through, for example, on YouTube and so on. And at some point, TNO Delft did a very interesting study where they say 90% of data that goes through Europe is not hosted in Europe. It's actually hosted in the United States or in China or someplace else. And so it's wonderful that the Europeans have the private law framework and the private law system. And my question is, how is this law applicable, and how would you make it applicable to this sort of things when the data is held outside of Europe, being transacted outside of Europe? What would you do in a situation like that? Bearing in mind, as Isabel says, there's no smart toilets in Europe because of a GDPR issue, but there will not be this issue. There will be smart toilets outside of Europe, meaning that competitiveness-wise, Europe will not be competitive if we have those kinds of regulation, because, like it or not, those companies are going to want to make money in a place where they can make that money. So that's my first question. How would the wonderful frameworks you have in the European private law system translate beyond the borders? So for the scope of this project, maybe to take a bigger view so that people like Craig and I don't have to go to smart toilets. So one thing. The second thing is digital vulnerability. And I've heard so many different ideas of digital vulnerability today. So I've taken notes on all. That's why I keep typing on the phone. I'm not texting. I'm actually taking notes. But one of the things which I wanted to ask is this: all of the speakers would have gotten a pretty strict email telling you have to submit something in writing by a certain deadline, which I'm going to miss. But in terms of digital vulnerability, we heard so many different concepts today. And I wonder how much of it is in three parts. One, from Web 2, which is consumerism, and the vulnerability there, to semantic Web 3, which is content monetization, like Catalina said. So basically there's a change, not just in the status, but the use of the user, the person, the person at the center of that vulnerability, to Web 4, which is symbiotic, and is machine to machine, and there is a machine to human aspect of that. Is that one thing to look at? Is it a matter of looking at vulnerability from an intersectionality point of view, where a status of a human being in that vulnerability situation can cross borders in different intersections? Or is it a sectorialized point of view? So when we're looking at content monetization versus insurance, and Prospero's not doing so well with his phone, when we look at employment law, do we look at it in a sectorial way? So when we look at digital vulnerability for the purposes of this project, what is the best way to go forward in the output? So forgive me for putting this panel under that particular Socratic thing, but this has been kind of churning in my head all day. And again, as I say, I speak personally in my academic capacity. Thank you.
Yeah, thanks. I can answer maybe the first question with if my data is here, your data is in Colorado, how that's going to work. There is a framework for that, right? So we have the federated learning framework where, in any case, that it's naive to believe that all the data is somewhere on one computer and then the companies use that computer to train the data. So it's necessary to have some data on this server, some data on this other server. There's no cloud, right? There's always a server somewhere. So, and then the idea is that, okay, how do I make the training of the algorithms or whatever so that it still works by taking data from server 1, taking data from server 2, and then they're synchronized. But there are frameworks for that, and they are working. So, and I'm pretty sure we are already applying them. So I think technically that's possible. And I think it's already happening for sure from a technical perspective, but I think that's the way also to apply it on, also to conform legally. So I don't see why that won't work. So yeah.
Maybe just to build on that, so this concept of federated learning also finds itself in the work of Michael Veal, a scholar who is very interdisciplinary and who has been having already for a few years the message of we shouldn't focus on data anymore. This is, where we're getting to see the issues that perhaps were happening in practice maybe 10 years ago. So, we're talking about personalization and targeted advertising. I mean, if Cambridge Analytica wouldn't have been so prominent in the news, perhaps we would still be even less, aware of some of these business practices that were revealed with public scandals and whistleblowing. But the thing is that what Michael Veal says in his scholarship is that the pace of development of technologies and also the power of some companies of actually really using this technology to do legal compliance. So federated learning, like Google has very good federated learning. Google will be able to deal with GDPR, requirements and implications. I think that we do not have any more privacy experts in the room, or unless I don't see any, because I'm not a privacy expert. But what I know from the scholarship is that basically the pace of all of these issues is just so fast that we just keep on speaking about practices that are going to be perhaps relevant for smaller companies, and where the smaller companies are going to have also a much higher burden of compliance. And I think that links very much to your second point with Web3. Again, so we're talking about the vulnerable consumer and personalization, right? So this has been an issue that has been happening for a while. So what is the next paradigm? What is the next dimension? Web3, I think, still needs to take off. We saw with all of the cryptocurrency scandals of the past years that blockchain has been definitely reduced in its use. or at least the hype has kind of slowed down a little bit. And now, yeah, with augmented reality and virtual reality, we have to see whether the promises of Web3 will actually get to consolidate. So I think it's still a lot of uncertainty there. But that entails that, you know, if you have to think about the situation where you are watching your favorite influencer and your favorite influencer is in front of your eyes on like the new Apple device of augmented reality, and your favorite influencer is who is going to be Alberto once he's going to get on Twitter, you know, and then Alberto is going to tell you, here, this is the best book on digital vulnerability and European private law. You should buy it. You know, is that actually going to work better than the ad that you were mentioning? Because there will be some new implications that we aren't even aware of right now. So I am a little bit afraid, and I don't know, I guess that for the representatives of institutions, such as the European Commission, this must be also very, very heavy because technology doesn't stop. But our understandings of these phenomena are really need some time to develop. And we're in this cat and mouse game, yeah.
Thank you very much to all of you. I would like to build on Jerry's comment, and this fundamental issue that we have to address is what are we talking about when we use this idea of digital vulnerability? And we have been discussing a lot about vulnerability, and I would like to focus now on the first part, digital. Because I have been thinking in all the different presentations, we clearly link exacerbated or aggravated vulnerability when there is technology involved, digital technology involved. But I can imagine 3 different layers, and I would like to get your views on that. The first one is digital vulnerability linked to the fact that technology is used as a tool, purely electronic commerce. So I use a tool that is a technological tool. Because of that, I feel more vulnerable because I am unable to manage this particular technology. So this is the first, in my opinion, very rudimentary and very basic digital vulnerability. The second one is technology as a space. So consumer is vulnerable in the digital space because there are many elements, dark patterns, interfaces, that are in a way recreating different practices and different relationships, different transactional environments. So digital economy as a space. And the third layer would be when we use technology, we can do things that we cannot do with the same effectiveness without technology. Algorithmic management, content moderation. So the fact that we use technology enables us to do things that without technology we cannot do. And that is the source of digital vulnerability. So I have in mind, and I would like to discuss with all of you these 3 layers. And I think that Web 2.0 is the way? Web 2 is why? So this is a very basic idea of technology as a tool, but we are going further. Probably the idea of technology as a space and technology as a new environment within we can do things and provide services that otherwise they are not feasible, they are not viable. So that would be my idea for discussion. Thank you so much.
Actually, it's funny that you're saying that because just 2 days ago I got sent a new publication that was done for the European Commission. Some Spanish researchers, but I don't remember the name, I'd have to look it up afterwards, and they did exactly that. The work was called Platformization at Work, and they distinguished pretty much these 3 layers. I think if we want to make this a project for the future on digital vulnerability, yes, we will, I agree, in the structure maybe it should be distinguished 3 or 4 pillars because there are different issues, and they did exactly that. The first issue, for example, if I'm now talking as an employment lawyer, that's that you're always reachable, right? That's a problem with which most nations' employment law can't deal, because if you're checking an email at midnight, it's night work, it's forbidden in most countries, and it basically is working time, so you'd have to write it down, it would have to get paid, etc. So the practice is very different from what should be, and I think that working with tools is one aspect, and then what the tool does with me, how my data is collected, for example, as a consumer or at the workplace, is another pillar. I think you're right, we should think about that. I think there are different aspects, me and technology, how they work together.
So if I may say something to catch up on what Teresa said, I think we've been tackling the vulnerability in the two first meanings, which you mentioned, as a tool, as a space. It's helpful, the division you suggest, but I don't think that the insurance sector as yet provides enough data to discuss the third layer. What we had if we had no technology, probably this may be due to business and political decisions of insurers. They would not be ready to hand over the underwriting decisions outside of human control. And I talked with an insurance broker, and in Poland there is a specific provision on that and I think also in the Netherlands, that any underwriting decision must be done by humans. It cannot be outsourced to inhuman entities. So. And what I want to mention, which I have forgotten in my presentation, what Professor Veneziano said this morning, it's actually comforting to see that a good share of Polish consumers saw digital technologies as an enabler, not only as a risk. Yeah? So I remember someone commented, another distinguished scholar commented on Ben Shahar's and Schneider's book, and they said, yes, they see a lot of problems, and they are right to indicate them. But there are also markets which function quite well, and we should have in mind a balanced view of the reality, because sometimes disclosure works. It does work on very specific markets. And the same is probably, so my inclination would be to keep the balance of seeing the enabler dimension and the risk dimension, and to go about, I would say, at a low pace, looking at different sectors, because then we may end up with I remember discussion about Europeanizing private law, where we put up very glorious projects which come back to the rules of civil codes of 200 years ago. So my intuition is to be very narrow, market specific, and only then to go upwards. Yeah.
Just a very quick thought. So this is fascinating, what you're saying, but at the same time, this has also been dealt with in a lot of other disciplines, because I think I love private law. I consider myself, I identify as a private lawyer, but I believe that, for instance, if you look at the literature on law and technology from more than a decade ago, James Grimmelman from Cornell, Lillian Edwards, who has been writing like the volumes on internet law, and unfortunately, I think for the continent, it does happen that the tradition of internet law is a field of kind of a little bit of e-commerce here and there, some copyright stuff. It kind of emerged in the more common law space, so we had a lot of catching up to do. But if you look, those spaces have been already mapped. Of course, what you're saying is absolutely correct. We have new iterations that are more sophisticated, but at the same time, we're talking about cyberspace. So it's cyberspace that has been fulfilling certain functions that have been enabled by the affordances of the platforms that are economic actors therein. And of course, here we have all of these very complicated understandings of, like what works, what is viral, why is TikTok, like we didn't talk about TikTok like 4 years ago, We didn't know it existed because it was only teenagers, as Isabel can tell you over drinks, only teenagers were on Musical.ly and on TikTok doing their dances, and that was it. And now TikTok is all the rage because there were so many factors, economic, social, there was a pandemic, and people started, wanting to make videos when they wake up in the morning, although they work for Washington Post. And then they're gonna be in their bed and say, oh, did you see what Trump said last night? Let's just discuss that. And then while they're preparing their cappuccino in the morning, they're giving you the news of the day. So all of these things are also very ad hoc, and they're happening in these spaces, which, and this is happening because they're enabled by these platforms. So I am very happy to share more of this literature. And also Andrés Guadamuz, who has been a brilliant scholar working on internet regulation, and who has been trying to also map a lot of these directions, and who's very big big on Web3, so I think you would very much enjoy his writings.
Because I do want to try and be timely. So I can see 2 questions in the front. Are there any further questions? Okay. That's great. You're right next to each other. You can hand each other the mic.
Thank you so much. Well, first of all, I would like to thank all the speakers for such an interesting day and thought-provoking presentations. I'll try to be super quick with my question, as I know it's super late. My question is for Catalina and Jerry, as their presentation spoke to me in particular, as I work for Google. So I wanted to share with you a thought, right? I like the idea of applying consumer law to content moderation, but I believe that that is already happening, at least to some extent. So essentially you cannot, of course, advertise, for instance, unlawful products. Anything that is unlawful in a video portrayed on YouTube would come down, right? So you were talking about conspiracy theories and but these kind of content, like disinformation as well. Don't you think that the main issue around these topics that are the core of content moderation is actually not unlawful content, but content that is lawful but harmful and dangerous, right? So how do we manage this space? My opinion, of course, so I do work for Google, but today and tomorrow I'll be sharing my personal views, right? The regulation space in this context is fundamental, and I think the European Commission with the codes of practice have got us a long way, but it's just, I think we have to keep in mind that phenomenons like the ones that you're citing, especially conspiracy theories, are very hard to define and pinpoint with a general definition, and can usually be picked up upon only after they have been created and spread.
Yeah, thanks for the question. I think as we were preparing the presentation, I found like a long list of, I don't know, YouTube regulations on what content is removed and so on. We didn't have time to include it. But I do see the challenges that you mentioned, and sure, you know, it's a challenge. I still think maybe the main problem here, at least what I see, is that what is the recommender system optimizing for? Because I'm pretty sure they're not directly optimizing for conspiracy theories, but they're optimizing for what is going to keep me engaged, what will make me click more, right? And this is the whole perception, which also people may not know, right? I would expect a recommender system for me, right, which is still useful, is that I could tune it and it's transparent that I want to see this type of content, and I guess maybe then I wouldn't pick that I want to see 5G proof underwear. So for sure, right, there are content challenges, which I think maybe, you know, I'm the first one to acknowledge, because we're trying to build also models exactly that detect, I don't know, fake reviews or anything. It's very difficult. But I still think that the platforms have much more responsibility on being more transparent about how the recommender system, what it optimizes for, because it does optimize for engagement. That has been shown as well, right? That polarization sells in the sense that of clicks and, you know, ads and anything. So I think, yeah, so content plays a role, but at the same time, I think it's more about, yeah, what are we optimizing for and how transparent are we about that?
Maybe just to build on that, I've done some research, some empirical research with Pietro Ortolani, who's a professor at Radboud University in the Netherlands. We looked at what we called actionable content on 4 different platforms. YouTube was not one of them, so I can't speak as to YouTube. But basically the idea was content moderation. What can you report, right? Like, what's the button? So this was just an interface, a mobile interface study. What kind of stuff can you report on 4 different platforms: Twitch, Twitter, Meta, and the Meta platforms, Facebook and Instagram. Out of all of the things that you could report, you had all of these, you know, very politically sensitive things that platforms really did, like the disinformation code. So you could report criminal law issues. You know, for instance, if you have terrorist content, if you see child sexual exploitation content, you can report that. Consumer protection stuff, nothing, absolutely nothing. For instance, hidden advertising, you couldn't report that. Last year, TikTok introduced that, and they're under the pressure of the Italian Consumer and Competition Authority, introduced a report button for hidden influencer ads. And that's a consumer content moderation issue or a consumer content moderation question. But the thing is that all of these other platforms only had like illegal goods, right? So if you're going to have safety gate products or if you're going to have, I don't know, selling drugs on social media, but advertising would be fine. If you advertise weed, then it's fine. You don't take that down on many different platforms, but yeah, so I think that there's a lot of space that we can still use for the question, well, how can we use consumer protection for content moderation?
I just think it's very interesting because we've had 3 questions so far, or 3 questioners, I should say. Oh, no, I was just... Oh, no, I was just saying it's... I wasn't stopping you. I was just going to talk about the questions. I'll come to you in a second, if that's okay. Yeah, and so I just think it's very interesting that we've had these 3 questions, and each of them seem to interrogate different aspects of the title of the conference, right? So Jerry's question first begins by thinking about the different contexts of what it is to be private, right? Is it a status? Is it sectoral, right? And it's interesting because we've had, a lot of talk about consumers, and consumers who provide money, consumers who provide data, but employees who provide labor, right? And these are all very different kinds of interactions, it would seem. So what are these private contexts that we're working in, right? The second question had to do with digital, right? And are we, what is the meaning of digital in this context? I actually also want to suggest that if we think about vulnerability, we may want to think about the non-digital world as well, right? Because I think that there are many aspects of our non-digital lives that render ourselves vulnerable in digital spaces, right? And then the third concept was about vulnerability. Are we talking about harm? Are we talking about, and so I just wonder whether each of these concepts are being explored further, right? And to my mind, I wonder about the robustness of these concepts in these spaces, right? Because I don't think that when you talk about vulnerability, we aren't so much thinking about the activity of the individual. So whether they're a consumer or whether they're an employee, but we're thinking about what it is being done to them, right? And so is this a situation where they're being exploited or getting an unfair deal in terms of what is being extracted from them, to invoke Julie Cohen's conceptualization of data use. And so basically one thing I'm gonna put to the panel, and then we'll get to that question, and then we'll answer both interventions questions together, is to what degree does do the concepts of consumer, employee, does that concept get to, is that still robust when we think about vulnerability, right? Does the concept of private versus public law remain robust when thinking about vulnerability? Right? Is vulnerability something that just transcends the idea of that juxtaposition? So I'm going to leave that on the table, get to our last question, and then maybe we can just do a quick wrap up. So please.
Yes, thank you very much. I just wanted to raise a point, an issue. It's more policy issue, because we have been talking about the taxonomy of vulnerability. We have heard about so many different concepts about vulnerability. And then we asked ourselves, what, even if we figure out what this vulnerability is, what could be the solution? And so I think there are 2 problems here: an enforcement problem and the so-called redress vulnerability, which is one of the main issues, talking about not digital sources of vulnerability, and also the policy issue, which is how do we regulate this? I don't think that hyper-regulation would be the answer. And we have been talking about fairness by protection, and design by protection. And I think that this could be the way. We should have open-ended texture, so to make the legal framework more flexible, because as we said, this is an issue which there is a very high degree of obsolescence. We cannot update every 1 or 2 years the regulation and the legal framework. So I think that the only way is an open-ended texture and to give flexibility. And so to make the judiciary on the enforcement side able to regulate as many cases as possible.
So what we're going to do is maybe, for folks who want to react, 1 minute each, right? So please, if anyone wants to react, you know, so please go.
I think it would be wonderful to have a concept that is not so sectoral, but in the end I do believe a bit that it's sectoral. For example, when I read about liability in the States, for example, there is a litigation going in an employment context directly against the manufacturer and not against the employer anymore, but one has to see that in most countries in Europe, employment law is very heavily regulated, meaning from a procedural point of view, you may have some for free procedures, you may have special labor courts that have simplified procedures, and I strongly believe one shouldn't take that away. I think the employer remains responsible. There is also new German litigation that if you can't explain exactly how the black box works because you are under, it's a business secrecy, you'll be liable as an employer, and in the end you're liable. So I think we also have to look at this procedural. In the end, I think it will be difficult to not go sector by sector.
Just one final thing. I would be, because what was said from the perspective of Singapore, I remember it was 2019 or 2018 being in a conference on InsurTech with several presenters from outside Europe. I think they were talking about market infrastructure that is not even yet in Europe now. So this heavy, as Roger Brownsword said, this human-centric view that the EU legislator is always assuming, which is very conservative in terms of accepting let's say, technology as enabler, I think we are now several years behind non-European markets. And I think we should more probably talk about politics, who wants to regulate what, and the competition between the EU, preempt as much as possible, or the balance between how much is Europeanized and how much is left to free competition. And I think that's we need to admit that the EU is far behind, and it makes sense to ask for the reasons why it is. Perhaps these reasons are legitimate, but this should be discussed probably openly why it is so.
Absolutely, and I think that humility in some ways is the best way to end a conversation on such complex topics. Thank you very much to our speakers and to everyone for being here.
Brilliantly. Thank you. So just an organizational note, you received an email I sent you. Please check your inbox account regarding the location for 2 nights dinner. It's no longer Savonarola. It's Cucina e Bottega. You have all information on your email account. See you at 8.